Hello? Court officer, sir? Madam? Madam, ಕೇಳಿಸ್ತಾ ಇದೆಯಾ ಮೇಡಮ್ ನಮ್ದು? Thank you, madam.
Court officer. Court officer. Court officer. Court officer. Court officer mentioning ಮಾಡ್ಬೋದಾ?
ಮಾಡಿ ಸರ್. ಪೇಜ್ ವೈಸ್ ಕರೀತೇವೆ.
ಅಲ್ಲ ಪೋಸ್ಟಿಂಗ್ ಮೇಡಮ್, ಪೋಸ್ಟಿಂಗ್ಗೆ
ಪೋಸ್ಟಿಂಗಿಗೆ ಹೊಸ ಮೆಟ್ರ್ ಆದ್ರೆ ಇಲ್ಲ ಸರ್, ಆಟೋಮೆಟಿಕ್ ಆಟೋ ಲಿಸ್ಟಿಂಗ್ ಇದೆ. ಇನ್ ಮಿಕ್ಕಿದ್ದು ಡೇಟ್ ಇದ್ರೆ ಬಂದೇ ಬರುತ್ತೆ.
ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್.
ಓಕೆ.
ಹೇಳ್ರಿ, ವೇಟ್ ಮಾಡಿ ಆರ್ಡರ್ ಸರ್. ಹೇಳಿ. Commissioner Council submits that charge sheet is filed and hence going to file the copy of the charge sheet. Hence with this matter next Monday is the date, 18th.
My lords, may I make a submission, my lords?
1 second.
Please,
47 to 61. Huh? 50? ಹೇಳಿ ಏನಾಗು ಚಾರ್ಜ್ ಶೀಟ್ ಮಾಡಿದಾರಾ? ನಮ್ಗೆ ಗೊತ್ತಾಗ್ತಿಲ್ಲ ನೀವೇನ್ ಹೇಳ್ತಾ ಇದ್ದೀರಾ. ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಆಗಿದೆಯಾ? ಆಗಿದೆ. ಟೈಮ್ ಬೇಕಾ? ಸೇವ್ ಮಾಡ್ರಿ ಮೇಡಮ್. ಹಿಂದಿನ ಮಾಡಿ ಸೇವ್ ಮಾಡಿ. ನಲ್ಲಿ
My lords, list one, serial number 38, my lords.
only one list.
Serial number 38, my lords. My lords,
38 ಹೇಳಿ ರಾಘವೇಂದ್ರ
my
ಕೆ.
lords, yes, my lords. My lords, may I pray for a week's time, my lords? We have
ಲಾಸ್ಟ್
further.
ಟೈಮ್ ಟೈಮ್ ಕೇಳಿದಿರಿ ನೋಡಿ. ಲಾಸ್ಟ್ ಟೈಮ್ ಕೇಳಿದಿರಿ, ಟೈಮ್ ಕೊಟ್ಟಿದ್ದೀನಿ. ಮತ್ತೆ ಟೈಮ್ ಇಲ್ಲ.
My lords, short accommodation, my lords. We have further.
ಲಾಸ್ಟ್ ಟೈಮ್ ಕೇಳಿದಿರಿ, ಪ್ರತಿ ಸಾರಿ ಟೈಮ್ ಕೊಡೋದಿಲ್ಲ. ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಬೋದು, ಇಟ್ಕೊಂಡಿದ್ದೇವೆ. 62 to 69. HL Pradeep Kumar. Additional counsel absent, 1 week time granted. Manjunda Gowda. Victim na party? ಆಯ್ತು. Petitioner counsel seeks 2 days time to comply with office objection. Meanwhile ಕೊಡೋದಿಲ್ಲ. ನೀವು ಮಾಡಿದಲ್ಲ ನಾವ್ ಹೆಂಗ್ ನೋಟಿಸ್ ಮಾಡಕ್? Time granted as sought, or post the matter as per roster. If complied in fact. Reni Sebastian. Now we have mentioned 24 or 25. 24 then.
Offense mentioned in the main prayer and petition memo is not valid if the page of bail rejected order of miscellaneous criminal miss to be clarified.
ನೀವು ಆರ್ಡರ್ ಮಾಡಿರೋದೇ ಒಂದು, ನೀವು ಮೆನ್ಷನ್ ಮಾಡಿರೋದೇ ಒಂದು ಅಂತ. Yes. 35 of the Arms Act ಅಂತಿದೆ ಬೇಲ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ. ಹೌದಾ? ಪೇಜ್ 15. 24 of the Arms Act ಅಂತಿದೆ. Initially, that is initially. Included section 307 of IPC and section 24 of Arms Act. Now you are seeking for bail in respect of offense 24 of Arms Act. Actually 25, but ಎಲ್ಲಾ ಕಡೆಲ್ಲೂ ಮಿಸ್ಟೇಕ್ ಇದೆಯಲ್ಲ. ನೀವು ಆಯ್ತ್ರಿ, ನಿಮ್ಮ ಪ್ರಕಾರ ನೀವು 24 ಹಾಕಿದಿರಿ. ಪ್ರೇಯರ್ ಕರೆಕ್ಟ್ ಆಗಿ ಹಾಕ್ಬೇಕು. You seek for an amendment. On that. Office objections ಗೆ you comply with office objection. ಎಷ್ಟು ಸಬೇಕು? ಎಷ್ಟು ಸಲ ಯಾಕೆ ಬೇಕ್ರಿ? ನೀವು ಟೈಮ್ ಕೇಳಿ ಕೊಡ್ತೀನಿ. ಎಷ್ಟು ಸಲ ಬೇಕು? 1 ದಿವಸದಲ್ಲಿ ಮಾಡ್ತೀರಾ, 2 ದಿವಸದಲ್ಲಿ ಮಾಡ್ತೀರಾ? ಓವರ್ ನಾನ್ ಹೆಂಗ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ? ನಿಮ್ ಪ್ರೇಯರ್ಲೆ 24 ಅಂತ ಬರ್ದಿದ್ದೀರಿ. ನಾನ್ ಹೆಂಗ್ ಓವರ್ ರೂಲ್ ಮಾಡಕ್ಕಾಗತ್ತ? ನೀವು ಕರೆಕ್ಟ್ ಮಾಡ್ಕೋಬೇಕು ಅದನ್ನ. ನೀವೇನ್ ಕರೆಕ್ಟ್ ಮಾಡ್ಕೋತೀರಿ ಅದ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಆಯ್ತು. Petitioner counsel seeks 2 days time to comply with office objection. Granted. If complied, post the matter as per roster. 4. Jairaj G. 1 week. Counsel seeks 1 week time to comply with office objection. Granted as sought. Bhadravadi Siddeshwara. Absent 1 week time granted. Abhishek NN. Absent 1 week time granted. Second time Javed S. Absent 1 week time granted. If not complied, list the matter on 18th. Dilraj Jude Rohit Sikwera. Yes, madam. 1 week. Council takes 1 week time. Granted, and if not complied, list this matter on 18. 9th, Balakrishnan, yes, Balakrishnan. Council is absent, 1 week time granted, if not complied, list this matter on 18. Third time, Mahadevaya. Petitioner council is absent and matter listed for third time for non-compliance. No representation. And hence urgent on cost of rupees 500 payable at registry. If not complied and cost not paid, list this matter on 18. Fourth time.
Man, in this case, my lord, the cost has been paid, my lord, petitioner. My lord, 3 days time to complete the office objection, my lord.
Council submits that he has paid the cost as ordered in the previous date of hearing and again seeks 3 days time and granted 3 days time. Vishwanatha, non-payment of cost, pass over ಮಾಡಿ. 9th time, ಏನ್ರಿ ಇದು? Non-payment of cost, ಇದು pass over ಮಾಡಿ. 14 to 22. ಯಾವ್ದ್ರಲ್ಲ notice ಹೋಗ್ತಾ HCGP? HCGP is directed to take notice and file objections if any. List all the matters on 18th. ನೋಡಿ ಇದ್ರಲ್ಲಿ ಯಾವ್ದಾದ್ರು ಇದ್ರೆ ನೋಟಿಸ್ ಹೋಗೋಂಥದ್ದು ಎನಿ ಮ್ಯಾಟರ್. Now you are seeking for respond number 2, POXO matter. POXO. ಆಯ್ತು, ಹಾಗಾದ್ರೆ serial number 20 ತಗೊಳ್ಳಿ ಮೇಡಮ್. Petitioner counsel submits that it is a POXO matter and hence issue notice. Instead of issuing notice, HCGP is directed to notify complainant, informant, victim. Date ಕೊಡಿ 20th madam, 2 days more. ಹೇಳಿ 13. ಅದಾಯ್ತು, 1 ನಿಮಿಷ ಇರಿ, ಫಸ್ಟ್ 1 ನಿಮಿಷ ಇರಿ. 14 to 22. ಇನ್ನು ಏನೇ ಅದರ ಪೋಕ್ಸೋ ಮ್ಯಾಟರ್ ಇಲ್ಲಲ್ಲ? ನೋಟಿಸ್ ಇಲ್ಲಿ ಹೇಳಿ, ಈಗ ಏನಾಗ್ಬೇಕು? ಯಾವ್ದು 9th ಟೈಮ್ ಹೇಳಿ. ಯಾರ್ದು? ನಿಮ್ದ? ಅಲ್ಲ ಆಯ್ತು, ಲಾಸ್ಟ್ ಟೈಮ್ ಅಲ್ಲ, ಇದು 9ನೇ ಸಾರಿ ಬಂದಿರೋದು. ಫಸ್ಟ್ ಕಾಸ್ಟ್ ಕಟ್ಟಿ, ಇವತ್ತು ಕಟ್ ಬನ್ನಿ, ಆಮೇಲೆ ಟೈಮ್ ಕೊಡ್ತೀನಿ ಅಲ್ವಾ? ವಾಟರ್ಡ್ ಮ್ಯಾಟರ್ಸ್ ಶಂಕರಪ್ಪ.
Problem is the case is not the allegation is not the CSS property of CH-17. We created the lawsuit and all the 50 projects and we created the name of the second response, second petition.
Second petitioner.
Complainant is a 24-year old.
Second petitioner ಪ್ರಭಾವತಮ್ಮ, ವೈಫ್ ಆಫ್ ಮುಖಂಡಪ್ಪ ಅಂತಿದೆ. ಹೌದಾ? ಸೆಕೆಂಡ್ ಪಿಟಿಷನರ್ ರಾಜೇಶ್ ಕುಮಾರ್. ರಾಜೇಶ್ ಕುಮಾರ್ BM ತನ್ ಪರವಾಗಿ ಗಿಫ್ಟ್ ಡೀಡ್. ಆಯ್ತು. Property belongs to the complainant.
Property belongs to CH-17.
ಚಂದ್ರಶೇಖರ್. ಆಯ್ತು.
Complainant is only the son of Chandrasekhar.
Complainant is the son of. ಆಯ್ತು.
By death of the Chandrasekhar, by creating the documents of Chandrasekhar, we claiming as a father of Chandrasekhar executed this.
Oh, this Prabhavatama claiming that she is the daughter anta. Daughter anta.
Complainant is claiming is a son.
Son. ಆಯ್ತು.
Here is a document. But the Chandrasekhar was purchased this property, certificate property at the age of 61.
ಆಯ್ತು 61.
61. That is in 1985.
ಹಾ
8/11/1985.
ಆಯ್ತು. ಹಾ
Daughter, the second petitioner is age of 61. Now,
ಹಾ
the complainant claiming as a son,
ಹ್ಮ್
age of 24 years
ಹ್ಮ್
at present.
ಹ್ಮ್
That means in 8 when the property was purchased,
ಹ್ಮ್
the property was executed.
Yeah.
He's not an assessor, he was not Karnataka.
ಹ್ಮ್ ಏನ್ ಪ್ರಾಪರ್ಟಿ ಆಯ್ತು. ಪ್ರಾಪರ್ಟಿ ಪರ್ಚೇಸ್ ಮಾಡುವಾಗ ಮಗ ಬದುಕಿರ್ಬೇಕು ಅಂತ ಏನಿಲ್ಲ. ಆಯ್ತ್ರಿ, ಅದೆಲ್ಲ ಆಮೇಲೆ ನೋಡೋಣ. ಈಗ ನೀವು ಚಂದ್ರಶೇಖರ್ ಅವ್ರ ಮಗಳನ್ನ ತೋರ್ಸಕ್ ಏನ್ ದಾಖಲೆ ಇದೆ ಅಲ್ಲ, ಅದು ನೋಡೋಣ. ಬಟ್ ಈಗ ನೀವು ನಿಮ್ಮ ಪ್ರಕಾರ ನೀವು ಆರ್ ದಿ ಡಾಟರ್ ಆಫ್ ದಿ ಚಂದ್ರಶೇಖರ್, ನೀವು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಹಾಕ್ಬೇಕು. ಸ್ಕೂಲ್ ರೆಕಾರ್ಡ್ಸ್ ಇರುತ್ತೆ ನಿಮ್ಮ ಹತ್ರ, ಅದೇ ಹಾಕ್ಬೇಕು. ಸಾಕಲ್ಲ? ಓದೋರಿಲ್ಲ, ಓದೇ ಇಲ್ವಾ ಒಂದು? ಆಯ್ತು. ವೇರ್ ಇಸ್ ದಟ್ ಗಿಫ್ಟೆಡ್? But you are claiming that you have executed a gift deed in favor of your son. No, we'll see the gift deed. No, ಏನ್ ಮಾಡಿದ್ರು ನೀವೇನ ಸೈನ್ ಮಾಡಿದ್ರು? ಇದೆಯಾ ಕೊಡಿ. Now you are claiming that she is an uneducated. ಪ್ರಭಾವತಮ್ಮ, you see, unexecuted ಅಂತಾರೆ. ಇಂಗ್ಲಿಷ್ ಅಲ್ಲಿ ಸೈನ್ ಮಾಡಿದಾಳಮ್ಮ. ಅದಕ್ಕೆ ಕೇಳಿದ್ ನಾನು, ಗಿಫ್ಟ್ ಡೀಡ್ ಕೊಡಿ ಅಂತ ನೋಡೋಣ ಅಂತ. ಫ್ಯಾಮಿಲಿ ಟ್ರೀನೇ ಕೊಡಿ ಅಟ್ಲೀಸ್ಟ್. ಫ್ಯಾಮಿಲಿ ಟ್ರೀನೇ ಕೊಡಿ ಅಟ್ಲೀಸ್ಟ್. ಈಗ she has signed, according to you, she is an illustrator. But she has signed the document of gift deed executed on 19/5/2020 in favor of her own son. Signed the document in English. ನೀವು ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿದ್ ನಿಮ್ಮ ಮಗನ ಹತ್ರ ಮಾಡ್ಕೊಂಡು ನಿಮ್ಮ ಹತ್ರ ಡಾಕ್ಯುಮೆಂಟ್ ಹೆಂಗ್ರಿ ಇಲ್ದಂಗಿರುತ್ತೆ ಶಂಕರಪ್ಪ? ನಿಮ್ಮ ಹತ್ರಲ್ಲೇ ಇರ್ಬೇಕು ಅದು ಆಕ್ಚುಲಿ. ಆಯ್ತು, ಅವನಾರಾಗ್ಲಿ ನೀವಾರಾಗ್ಲಿ ಅವನೇ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟವನೆ ಅಲ್ವಾ? ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ರೆ ಅವನು ಪೊಲೀಸ್ನವ್ರು ಎನ್ಕ್ವೈರಿ ಮಾಡ್ಲಿ ಬಿಡಿ. ವೆದರ್ ಯು ಆರ್ ಜುನೈನ್ ಡಾಟರ್ ಆರ್ ವೆದರ್ ಹಿ ಇಸ್ ಜುನೈನ್ ಸನ್, ಲೆಟ್ ದಮ್ ವೆರಿಫೈ. ಏನ್ ಪಿಟಿಷನ್ ಎಷ್ಟಿದೆ? 438. ಮತ್ತೆ ಹೋಗಿ ಎನ್ಕ್ವೈರಿ ಆಗ್ಲಿ, ಪೊಲೀಸ್ನವ್ರ ಮುಂದೆ ಅಪಿಯರ್ ಆಗಿ ಮಾಡ್ಲಿ, ಎನ್ಕ್ವೈರಿ ಮಾಡ್ಲಿ. Petitioner counsel seeks time to place the genealogical tree of the family of Chandrasekhar and also to place the document to show that the second petitioner is the daughter of the said Chandrasekhar. And hence this matter on 18th ಆಗ್ಬೋದಾ? ಒಂದ್ ವಾರ ಸಾಕಾ? ವರ್ಡ್ ಇನ್ ಪಾರ್ಟ್ ಅಂತ ಮಾಡಿ ಮೇಡಮ್. ನೋಡಿ, ನೀವು ವೆರಿಫೈ ಮಾಡಿ. ಪೊಲೀಸ್ನವ್ರು ಆಟ ಆಡ್ತಾರೋ ಯಾರು ಆಟ ಆಡ್ತಾರೋ ನೋಡಿ. ಆಯ್ತು. 24 ಚೇತನ್ ಹೇಳ್ರಿ. R2ಗ ಸುಜಾತ ಅಂತ ಏನೋ ಇದ್ರಲ್ಲ, ಹಾಕಿದೀರಾ ನೀವು? ಯಾವಾಗ ಇವತ್ತು ಹಾಕಿದಿರಾ? ಆಫೀಸಲ್ಲಿ ತೋರ್ಸಿಲ್ಲ ಮೇಡಮ್? ಈಗ ಕಳ್ಸಿದಾರೆ. ಹೌದು, the office has sent ವಕಾಲತ್ filed on behalf of R2 by counsel Sri GM Sharat Kumar. The same is taken on record. ಏನ್ ರೆಡಿ ಇದ್ದೀರಾ ನೀವು? ರೆಡಿ ಇದ್ದೀರಾ? ಹೇಳ್ರಿ. R2 ಅಂದ್ರೆ ಯಾರು? ಇದೇನ್ ಮ್ಯಾಟ್ರ್ ಏನು? ಓ, ಪೋಕ್ಸೋನಾ? ಓಕೆ. Huh. Hmm. Huh. ಓಡಾಡ್ತಾ ಇದ್ದಾರೆ ಅಂದ್ರೆ ಈ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟವ್ರು ಯಾರು? ಮದರ್ ಆಫ್ ದಿ ವಿಕ್ಟಿಮ್. But minor. What is the medical records? What is the medical records? It will offense goes back to the date of the offense. Date. Now maybe she is a major. Charge sheet ಆಗಿದೆ. 45 and 46. Ashok, that girl, her 164 statement. What she says? He forced her to marry ಅಂತ. ವಿದ್ಯು ಸಾಯಣ ಎಂದು ಹೇಳಿದಾಗ ನಾನು ಭಯದಿಂದ ಸೀರೆ ಹೊಟ್ಟು ಬಳೆ ತೊಟ್ಟು ಹೂ ಮುಡಿದುಕೊಂಡೆನು. ಬಲವಂತ ಪಡಿಸಿದಾಗ ನಾನು ಆತನೊಂದಿಗೆ ಬೈಕ್ ನಲ್ಲಿ ಕುಳಿತೆನು. ನಾನು ಈಗಲೇ ಬೇಡ, ನನಗೆ 18 ವರ್ಷ ಆದ ನಂತರ ನಮ್ಮಿಬ್ಬರನ್ನು ಹೆತ್ತರನ್ನು ಒಪ್ಪಿಸಿ ಮದುವೆ ಆಗೋಣ ಎಂದು ಹೇಳುತ್ತಿದ್ದೆನು. Why it was deferred last occasion? But she is in her parental house. ಏನ್ರಿ ನೀವೇ ಹೇಳ್ಬೇಕು, ಅವರಲ್ಲ. ನಿಮ್ಮನ್ನ ನೀವು ಎಂಗೇಜ್ ಮಾಡಿದಾರೆ, ನೀವ್ ಹೇಳ್ಬೇಕು. ಹೇಳಿ ಏನು? ಏನ್ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತಾರ? ಅಲ್ಲ, ಬರೀ ಓನ್ಲಿ ಹೊರಗಡೆ ಬರಕ್ ಮಾತ್ರ ಹೇಳ್ತಾರ, ಹಿಂಗೇನಿಲ್ಲ. ಯಾರು ಅವ್ರ ತಾಯಿನ? ಆಕೆನೆ ಕೊಟ್ಟಿರೋದು ಕಂಪ್ಲೇಂಟ್. The petitioner counsel and also the counsel appearing for the state and counsel for auto ಮಾಡಿದಾರಲ್ಲ ಅವ್ರನ್ನ. The factual matters of the case of the prosecution is that the mother of the victim girl filed the complaint with the police, stating that knowing fully well that CW2 is the minor girl, this petitioner persuaded her and kidnapped the CW2 from Anjaneya Swami temple. With the help of A226 Full stop. When A1 persuaded CW2 to marry her, in spite of she has refused, he threatened her, stating that he would kill her and also he would also die. And he took the bangles and forcibly tied the tali on her and also took the photograph. Thereafter, A126 and CW2 were taken in the car belongs to A5 to the house of CW5 and left both of them. And that on 28/21 to 24/9/21, A1 continuously had the sexual intercourse with her. When CW1 went and informed CW3, A2 to A6 abused in a filthy language and threatened them, and hence case has been registered and investigated the matter and filed the charge sheet. The counsel appearing to the petitioner would submit that both of them are fell in love and the victim herself went with this petitioner and there was no any force, only at the instance of the mother of the victim a false complaint is lodged. And also counsel would submit that she was not subjected to sexual act before the marriage, only after the marriage only she was subjected to sexual act. It is also contended that both of them have lived as husband and wife after the marriage from 28/21 to 24/9/21 for a period of 34 days and not wrongfully confined her as alleged in the charge sheet. And this petitioner is in custody from Yavagindidandri from 2012-21 from 2012-21 and no need of further custodial trial and hence he may be enlarged on bail. The counsel also would submit that both victim now victim has attained majority and she is visiting the house of this petitioner and now they are cordial. For contra, the counsel appearing to the state would submit that specific allegation is made that forcibly she was taken and also while marrying, while tying tali also forced her and thereafter took her in the car and left her in the house of CW5 wherein she was also subjected to sexual act continuously, knowing fully well that she is a minor. The counsel appearing for the R2 submits that the victim also visiting the house of this petitioner and both of them are cordial and the victim mother is also present before the court. The counsel would submit that mother also says that there was a misconception and already they have married and they are going to live together and the peculiar facts of circumstances can be also to be taken note of. Having heard the petitioner counsel and also the counsel appearing for the state and also state as well as counsel appearing for R2 and considering the material on record that the mother had lodged the complaint at the first instance that this petitioner persuaded her, took her to a temple and tied tali and subjected her for sexual act. The police have also registered the case against accused number 2 to 6 alleging that they have assisted in taking the victim girl to a temple. They have already been enlarged on bail. The others have also been enlarged on bail. Having taken note of the factual aspects of the case that the victim girl is aged about 17 and a half years at the time of marriage, and now she has attained the majority. And no doubt she was subjected to sexual act continuously. And the same is after the marriage. And no allegation in the police in the investigation records that prior to marriage, this petitioner had subjected her for sexual act. The 164 statement of the victim girl also reiterates the same that says, but she claims that forcibly her marriage was solemnized with this petitioner. And taking into note of the factual aspects of the case and also subjected her for sexual act after the marriage, and mother complainant also present before the court that daughter is visiting the matrimonial house even this petitioner is in custody and they're going to live together in future. And the said fact is also taken note of, and peculiar circumstances of the case also taken note of, and hence enlarged on bail with conditions. Then parted matter. Parted. ಹೇಳಿ what is the matter? ನಮ್ಮ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಹಾಕಿದಿರಾ ಇದೆ ಚಾರ್ಜ್ ಶೀಟ್ ಪೆಟ್ಟಿರಿ. 28/6. Page 88 of additional charge sheet material ಅಥವಾ first petition main petition ಅಲ್ಲಿ page 88 ಹೇಳಿ. Second February 22. Who sent? Accused number 8. 8 sent. Residing jointly means this petitioner and who is both are living together. Huh? 3. Who are all? This petitioner is accused number 1. Accused number 1. A1, A2, and A6 are living together.
They came to this flat. So this petitioner was applying for work the Lord, that is work from home on laptop. Was the Lord on 18/6/21. 8/7. That may not he has worked the Lord. this company is burned.
Hmm.
But at that time, the suddenly,
Hmm.
came inside.
Hmm.
Last day, the cost.
Hmm.
The parcel was on the inside. It was in bad condition.
Hmm. Hmm.
It was taken.
Hmm.
The parcel was taken.
Hmm.
Bishop got 2 arrived and Bishop got 6 color.
Hmm.
Whom this parcel was.
Hmm.
They were not there, were not at that time.
Hmm. Hmm.
Secondly, was asked, what is that? And I do not know, not go. Then he was pulled away, he resisted.
Hmm.
Why are we taking? Why is it? Why is it? I got the warrant.
Ah.
Then he was put in there. Oh, wow. But all of this is navigation because moments the Lord will be there. So that was taken to custody and he 6 weeks.
Hmm. Hmm. Merits, man. After filing of charge sheet.
This ground is not considered.
After earlier petition was disposed of after filing of charge sheet.
That day,
Ah.
last week of meeting,
Hmm. Hmm.
subsequent petition is maintainable
Hmm.
on a different ground,
Hmm.
meaning legal ground.
Ah.
Legal may be there at that time, but
Hmm.
it is not considered.
Hmm.
I can see color this petition,
Hmm.
paragraph 2.
First one, huh? Hmm. Hmm. Briefly.
Yes,
Hmm.
an order, but an order that using an application for me
Hmm.
does not necessarily preclude another.
Hmm.
On a later occasion,
Hmm.
giving more details,
Hmm.
further development, different consideration.
Hmm.
This is what is the order?
Hmm.
Giving more material,
Hmm.
different consideration.
Next.
But it's all the order, but the mobile phone movements,
Hmm.
and some of the online
Hmm.
work from home, can you see the petition obligation?
Hmm.
This
Yes, 79. Hmm.
draft letter 8:27 p.m.
Hmm.
That was the last meeting, work from home.
Hmm. Annexure L. Ah. Hmm. 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 Hmm.
But next page at page 18.
Hmm.
That he was taking a lot of his house on Friday.
Hmm. Hmm.
This is the lot of the mobile now petitioner with his mobile phone
Hmm.
on 18 this is the internet connection.
Yes.
So this record will not kindly next page will not. Next page 83 will not. Next page will not. 83 will not. Because in Pakshi Garden that is the CCTV office.
Hmm.
Water will not be there. Pakshi Garden, Garden Pete.
Hmm.
Arrived at the 10:52 a.m.
Hmm.
The red color from light color, they both that article.
Hmm.
These police officers do not hear. No alcohol.
Hmm.
At some bar and restaurant, they consume alcohol.
Hmm.
They slept in the bar itself from night.
Hmm.
They are taken into the CCTV office. They reach Malad at 10:52 a.m.
Hmm.
So this is the double location of the mobile phone.
Hmm.
Since then,
Hmm.
was
I think this tower location also argued in the earlier date of argument. Huh? Huh. 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 I remember that you have argued the same in earlier while arguing this matter. Huh.
Clearly, a person is committed to law.
Hmm.
He should be hanged as per law.
Hmm.
The innocent person, the Lord,
Hmm.
this is our attempt.
But you are not disputing the fact that in your room only hashish were there. Hashish were there.
Person was not there.
Hmm.
That's the kind of what it is.
According to you, it was there on the teapot. It is on the teapot.
Parcel was come to
Uh,
December 2. Say, from accused number 8 from Himachal Pradesh. They have come upon that information to take accused number 2. Accused number 2 was not in that.
But at the time of Caesar, this man was there in the.
Not seized at that time.
That was
They have
Caesar.
legally taken that and it has seized it. Now the Lord what they did, but from 18 to the 22, Kashmir and see after 4 days, these 5 persons they were taken to PG. PG at Bradley. The Bradley police station living in the Lord, which is more than 30 kilometers from this area to that area. Bangor Road, Bradley.
Sorry, where it was seized?
Seized at PG.
PG.
Just specific PG on 22nd of 4 days. They are not showing the seizure of this muscle in that of the that they have taken there, they have all the 5 persons who taken into custody. That the parcel which was in the they have bifurcated, planted in the bank packet of the person. And they are shown seizure. So we have produced a direct document to Russia the guidance. That this accused the lot was residing in the lot. This is the direct document application.
Whether it is registered document?
Yes.
Registered document. Rent agreement. Sir. It can be come into existence at any time if it is not registered. 70? 75. Yes.
After 4 days, they were taken to the PG, which is located in Baki Road. Baki Road, and they were made to sit there and Chirama install as that they are seizing from the PG. Was important aspect of the law. Now, Jashik has inquired. PG registered the law and they do not indicate that they were the occupants of PG. They were not the occupants of PG. Particularly, this petitioner was not the occupant of PG. But they made to appear like that by trying a Mahazar sitting in the job. They were not taken. Now, the seizure shown whether it was PG, but it is as per the Panchanama test. Now, we learned that seizure you learned in the past data very after that. This aspect of matter. Now, the seizure shown the learned at this practices.
36 ಎಲ್ಲ ಓದಿದಿರ್ರಿ ಅವಾಗ್ಲೇನೆ ಜಸ್ವಿನ್ ಲೋಬೋ.
Item number 1, the lot is the property the lot that is this is transfer like that. Other things,
That is at page 38. 38 also in respect of this petitioner only. Zip lock or cover ನಲ್ಲಿ ಹಾಕಿ ಅದರಲ್ಲಿ ಪಂಚೆ ಸಮಸ್ಯೆ ಮಾಡ್ತಾರೆ regarding Caesar is concerned.
My submission is not that the PLS is from this is not subjected to there is nothing to show that the expression tablets in was found to be positive for presence of
Hmm.
the article which was sent to the for FSL. Page 69.
Hmm. 69 opinion. Hmm.
Sample found in the illustrated article number 4 as responded to the presence of
Hmm. Hmm. Read. Hmm.
This item, article number 4 is not come to this register.
Hmm.
The article number 1 is that
Hmm.
the article number 1 alert as by trying is sample
Hmm.
is not sent to the cell. Now alert he is in custody since 14 months.
Hmm.
4 items of MDMA has been received. And there are only 1 item of MDMA is sent to the
Yes.
This is not a serious defect where an infirmity
Hmm.
in charge.
Yes.
The doctor positively stated
Hmm.
that he is the material of this case.
Hmm.
Was and died immediately as the date.
Hmm.
But just the aspect of the doctor, where is the obsession? Put the charge of the number that was
Hmm.
but the writing doctor,
Hmm. Hmm. 4. Ah. Hmm. I think this is also argued earlier. Repetition ಆಗೋದು ಬೇಡ ಯಾಕೆ ಸುಮ್ಮನೆ ರಿಪಿಟೇಷನ್.
SCP was not called after gazetted officer. But he was not to act as a seizing officer. Now he takes the position of such a seizing officer on the request of police inspector. So that is not.
I think ಅದರ ಮೇಲೆನೂ ಫೈಂಡಿಂಗ್ ಕೊಟ್ಟಂಗಿದೆ ನೋಡಿ. ನೋ ಬಾರ್ ಅಂತ ಹೇಳಿದೆ ನೋಡಿ. ಹಾ. Supreme Court also. 482. Oh, in 482. But prayer is also made.
Not a main prayer.
How a court can 482 ನಲ್ಲಿ bail ಕೊಡಬಹುದು? After exhausting the remedy under section 439. After exhausting the remedy under section 439. Supreme Court granted, but whether High Court. That's what.
The matter was reserved 4 months.
ಆಯ್ತು ದೆನ್ ರಿಸರ್ವ್ ನೋಡೋಣ, ವೇಟ್ ಮಾಡಿ ಕ್ವಾಶ್ ಆದ್ರೂ ಆಗ್ಬೋದು, ಯಾಕೆ ಅಲ್ವಾ? ವೇಟ್ ಮಾಡಿ ಕ್ವಾಶ್ ಆದ್ರೂ ಆಗ್ಬೋದು. ವೇಟ್ ಮಾಡಿ, ಪಾಠ ಆಡಿದ್ದೆ ಹೆಂಗಿದ್ರು ನಾವು ನೋಡೋಣ, ಕ್ವಾಶ್ ಆದ್ರೆ ಕ್ವಾಶ್ ಆಗ್ಬೋದು, ಬೆಟರ್ ಅಲ್ಲ? ವೈ ವಿ ಹ್ಯಾವ್ ಟು ವೇಸ್ಟ್ ಅವರ್ ಟೈಮ್? ನೋಡಿ, ಹರ್ಡ್ ದಿ ಮ್ಯಾಟರ್.
Order was not possible. Therefore, Melody.
ಅಲ್ಲ, ದಟ್ಸ್ ವಾಟ್ ಐ ಆಮ್ ಆಸ್ಕಿಂಗ್ ಯು. ಹರ್ಡ್ ಆಯ್ತು, ಹರ್ಡ್ ಫರ್ದರ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್. The petitioner counsel and also the counsel appearing for the state would submit that already invoke the jurisdiction of 482 for very quashing of the proceedings, and the court also heard the matter and reserved for the judgment. Hence, list this matter. ಯಾವಾಗ? ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಈಗ ಹಾಕ್ಲಾ? ನೆಕ್ಸ್ಟ್ ವೀಕ್ 20th. ಆಯ್ತು, list this matter on 20th. ಇದು ನೋಟ್ಸ್ ಇಟ್ಕೊಳ್ಳಿ ಮೇಡಮ್. ಆಯ್ತು, ಅದ್ ಬಿಟ್ಬಿಡಿ ಈಗ. ಅದು ಪ್ರೇಯರ್ ಈಗ ಸ್ಟಕ್ ಅಪ್ ಆಗಿದೆ. ಈಗ ಏನಾದ್ರು ಕ್ವಾಶಿಂಗ್ ಆದ್ರೆ ನೋಡೋಣ, ನಿಲ್ಸಿ. 26 ಬಿರಾದಾರ್ ಸೌಕತ್ ಅಲಿ ಉಸ್ಮಾನ್ ಪಟೆ. ಏನೋ 50,000 ರೂಪಾಯಿಗೆ ಏನೋ ಕ್ಯಾಶ್ ಶೂರಿಟಿ ಕೇಳಿದಾರೆ ಅಂತ, ಹೌದಲ್ಲ? ಪೆನಾಲ್ಟಿನ ನೀವು ರೆಡ್ಯೂಸ್ ಮಾಡಿ ಅಂತ ಅದೇ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕೇಳಿದೀರಾ? ಏನಾಯ್ತು ಆರ್ಡರ್? ಏನಾಗಿದೆ? ಪೇಜ್ ನಂಬರ್ 9. Reasons. This court, while granting bail to the accused earlier, he was directed to furnish surety, and accordingly he had furnished surety. When the accused remained absent before the court, NBW and notice to surety was issued. Notice issued to surety returned with endorsement that he has not given any surety. Some other person impersonated the original owner of the property and sought for taking necessary action against the surety. In view of such endorsement, the bail bond of accused number 1 was forfeited to government. Once the bail bond is forfeited, the accused and surety are bound to deposit bond amount. If that accused is not in a position to pay the bond amount, he could only seek remission of portion of the penalty under the provisions of 446 of CH, and he cannot seek relaxation of condition while granting bail. The accused has not only furnished false surety, but has also violated the bail conditions by not attending the court irregularly, and now he is not ready to obey the conditions. No grounds are made. What is the error in the order? ನಿಮ್ಗೆ ಮತ್ತೇನ್ ಕಂಡೀಷನ್ ಬರ್ತದೆ? ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ವಾಸ್ ರಿಜೆಕ್ಟೆಡ್ ಅಲ್ಲ? ಆಯ್ತ್ರಿ, ನಿಮ್ಗೆ ಬೇಲ್ ಕೊಟ್ಟಾಗ ನೀವು ಕೊಟ್ಟಿರೋದು ಬೇಲ್ ಶೂರಿಟಿ ಫಾಲ್ಸ್ ಶೂರಿಟಿ ಕೊಟ್ಟಿದ್ದೀರಿ. ಗೊತ್ತಿಲ್ಲ ಅಂದ್ರೆ ಹೆಂಗ್ ಮಾಡಕತ್ತ? ಗೊತ್ತಿಲ್ಲ ಅವ್ರ ಈಗ ಹೆಂಗ್ ನಾವು ರಿಲ್ಯಾಕ್ಸ್ ಮಾಡೋದು ಅದನ್ನ? ಆರ್ಡರ್ ರೀಸನ್ಸ್ ಆರ್ ವೆರಿ ಕ್ಲಿಯರ್. 446 of 3 years. ಏನ್ ಕಂಡೀಷನ್? ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಅದು ಎಲ್ಲಿದೆ. A3 ಇದು. ಪೇಜ್ ನಂಬರ್ 15. ಏನಾಗಿದೆ 15 ಅಲ್ಲಿ? ಬೇಲ್ ಆಗಿದ್ದು ಯಾವಾಗ? ಅದು 14, 15 ಎಲ್ಲಿದೆ ಅದು? ಬಾಂಡ್ ಫಾರ್ ₹50,000 and shall furnish surety for like sum. ನಿಮ್ಗೆ ಯಾಕೆ ಕೊಟ್ಟಿದ್ರು? ಅದೇ ತರ ಕಂಡೀಷನ್ ಮಾಡ್ಕೊಟ್ಟಿದ್ದಾರೆ. ಇದು ಅಲ್ರಿ A3 ಕೊಟ್ಟಿರೋದು, ಇದು ಫ್ರೆಶ್ ಬೇಲ್ ಅಲ್ವಾ? ಏನಾಗಿದೆ? ಸೇಮ್ ಕ್ರೈಮ್ ಅಲ್ಲಿ ಅವ್ರನ್ನು ಕಸ್ಟಡಿ ತಗೊಂಡಿದಾರ? ಎಲ್ಲಿದೆ ಅದು ಆರ್ಡರ್? Accused number 3 was enlarged on bail. He was regularly appearing before the court. One surety, namely Anand, had offered surety to accused number 1 and 3. ಇವನ್ ಎಷ್ಟನವನು? ಇವನ್ A1. Since accused number 1 remained absent, NBW issued against accused number 1 notice to surety of accused number 1 was issued. The notice to surety was unserved with endorsement that the person to whom this police went for service informed that he has not given any surety to any person. Some other person might have impersonated him. The age of surety in the affidavit is shown as 32 years, whereas surety to whom the notice was served as per report of police is 55 years. When this accused number 3 was inquired as to who has given the surety to him, he was unable to say as to who was surety and submitted that it was lawyer who arranged for surety. Hence, the person who is unknown to accused number 3 has offered surety to accused number 3, and therefore taken to judicial custody and remanded to judicial custody as per order dated 17. Now the accused number 3 has filed this bail application content that he is ready to furnish genuine surety to the satisfaction of the respective court. ಆಯ್ತು. ಹೆಂಗಾಗ್ತದೆ ನಿಮ್ಮವನು ಅಪಿಯರ್ ಆಗಿಲ್ವಲ್ಲ ಕೋರ್ಟ್ಗೆ ಫಾಲ್ಸ್ ಸೂರಿಟಿ ಕೊಟ್ಟು ಆಗಿಲ್ಲ ಅಂತಾನೆ ಬರ್ದಿದ್ದಾರೆ ಆರ್ಡರ್ ನಲ್ಲಿ ನೋಡಿ. ಆಯ್ತ್ರಿ ಆಮೇಲೆ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿ ಅಪಿಯರ್ ಆಗದಿಂದ ಕ್ಯಾನ್ಸಲ್ ತಗೊಂಡಿರೋದು. That is not the case of accused number 3. Accused number 3 was very much appearing before the court. A3 present ಇದಾನೆ, ನಿಮ್ಮವನು ಕೋರ್ಟ್ಗೆ ಅಪಿಯರ್ ಆಗಿಲ್ಲ, ಕೊಟ್ಟಾದ್ಮೇಲೆ ರೆಗ್ಯುಲರ್ಲಿ ಅಪಿಯರಿಂಗ್ ಬಿಫೋರ್ ದಿ ಕೋರ್ಟ್ ಅಂತ ಬರ್ದವ್ರಲ್ಲ ಇಲ್ಲಿ. ಫಸ್ಟ್ ಸೆಂಟೆನ್ಸ್ ಇದೆ ನೋಡಿ, ನೀವು ಹೌ ಯು ಆರ್ ಕಂಪೇರಿಂಗ್ ವಿತ್ ದಿ ಅದರ್ ಆರ್ಡರ್. ಎಲ್ಲಾರು ಬಡವರೇ ಇರೋದು, ಫಾಲ್ಸ್ ಸೂರಿಟಿ ಕೊಡೋದಕ್ಕೆಲ್ಲ ಬಡವರ ಕೊಡಕ್ಕಾಗಲ್ಲ. ತೊಳಿ heard the petitioner counsel and also the counsel appearing for the respondent. ಅಮೌಂಟ್ ಕಡಿಮೆ ಮಾಡೋದು ಯಾವಾಗ ಅಂತಂದ್ರೆ ಇಫ್ ಇಟ್ ಇಸ್ ಎ ಜೆನ್ಯೂನ್ ಸೂರಿಟಿ ಇದ್ದಾಗ. ಈಗ ಜೆನ್ಯೂನ್ ಸೂರಿಟಿ ಇಲ್ದಲೇನೆ ಮಾಡಿರೋದೇ ನೀವು ಫಾಲ್ಸ್ ಸೂರಿಟಿ ಕೊಟ್ಬಿಟ್ಟು ಕೋರ್ಟ್ಗೂ ಅಪಿಯರ್ ಆಗ್ದಲೇನೆ ಈಗ ಅಮೌಂಟ್ ಕಡಿಮೆ ಮಾಡಿದ್ರೆ ಹೆಂಗಾಗ್ತದೆ? ಎತ್ರಿ ಹೇಳಿದ್ರಲ್ರಿ, ಓದಿದೀನಿ ನಾನು ಆರ್ಡರ್, ಮತ್ತೆ ಅದೇ ರಿಪೀಟ್ ಮಾಡ್ಬೇಡಿ. Heard the petitioner counsel and also the counsel appearing for the state. The present petition is filed under section 439(1)(b) of Code of Criminal Procedure Code, praying this court to relax the bail order condition number 2. That is, the accused number 1 shall deposit forfeited bond amount of rupees 50,000 as penalty, imposed in SC number 357 of 2019. With order dated 18/12/21, passed by the Principal City Civil and City and Session Judge CCS at Bangalore. The counsel appearing to the petitioner would submit that petitioner is very poor and very difficult to comply the condition number 2. His families are doing police work and due to condition very difficult to deposit for forfeited bond amount of 50,000 as a penalty. And in the pandemic situation, he can pandemic situation. Was not able to. Petitioner is a daily wager and he is the only breadwinner of their family members, and without presence of the petitioner, family will suffer for their livelihood. And hence, the order requires to be modified. For contra, the counsel appearing for the state would submit that this petitioner was enlarged on bail earlier, and he has furnished the surety. And subsequently, he remained absent before the court, and hence LBW was issued and surety notice was also issued. The notice issued to the surety returned with an endorsement that he has not given any surety, and the said person was impersonated. Hence, bail bond was forfeited to government, directed to deposit the forfeited bond amount. The court also made an observation with regard to section 446(3) of CRPC. And court has also observed that not only furnished false surety but has also violated the bail conditions by not attending the court. Hence rejected the application filed for modification of condition number 2, directing him to deposit the forfeited amount. The counsel appearing for the state would submit that it is not a case for modify the condition imposed by the trial court. Having heard the respective counsel, admittedly his petitioner was enlarged on bail. Consequent upon enlarging him on bail, he had also furnished surety. When he did not appear before the trial court, so NBW was issued and also simultaneously surety notice was also issued. The said surety notice was returned with an endorsement that a fake surety was furnished, and he denied the very execution of surety. The said fact is also taken note of by the trial court. Not only he has violated the bail condition, and also it has brought to the notice of the court that false surety was furnished. And when such being the material on record, It is not a fit case to exercise the discretion in favor of the petitioner to modify the condition. The surety bond earlier was executed, was forfeited, and issued the process for depositing of the said amount. When such being the material on record, not a case for exercise the discretion once again to modify the condition imposed by the trial court. The counsel also appearing for the petitioner would submit that A3 also furnished the same surety, but no such condition is imposed. But in the fact on record, this petitioner violated the very conditions of the bail order and furnished the false surety. But the order passed by the trial court in respect of accused number 3, it is clear that he was regularly appearing before the court. And he had also furnished the fresh surety when he had comes to know about the false surety was furnished. When such being the case, the very contention of the petitioner's counsel doesn't arise since this petitioner has violated the terms and conditions of the court which has been imposed earlier. Then no grounds are made out to modify the same. We have the discussions made up. I pass the following order. Petition is dismissed. Shiva Prasad, yes. Pass over ilva. ಏನು ಬರ್ತಾ ಇಲ್ಲ ಇವರು ಪಾಸ್ ಅವರ ಲಾಸ್ಟ್ ಟೈಮ್ ಇಲ್ಲಿ ಆಬ್ಸೆಂಟ್ ಅಂತ ಬರ್ಕೊ ಬಂದಿದ್ದೀನಿ. ಚಕ್ರವರ್ತಿ TS ಪಾಸ್ ಓವರ್. ಆಕಾಶ್ B Shetty 419 420 66 C and D. Attack on the later on he was arrested. So 439 is 438. I heard. But there is an observation in spite of issuing the notice, the petitioner herein has not appeared before the police and cooperated with investigation. Where is that material to show that he had appeared? Where is the statement? The statement record madidara whether he had appeared before the police. ಆಯ್ತು ರೆಕವರ್ಡ್ ಅಂತಂದ್ರೆ he appeared before the police ಅಂತ ಮತ್ತಿನ್ನೇನ್ ಮತ್ತೆ ನೋಟಿಸ್ ಕೊಟ್ರಿ ಅಪಿಯರ್ ಆಗಿದ್ದಾನೆ he is cooperating ಅಲ್ವಾ ನೋಡಿ what the petitioner counsel and also the counsel appearing for the state. The case is registered against whom? So the factual matters of the case of the prosecution is that the complainant who is working as a associate vice president in Zeroda, within bracket one of the largest stock brokers in India, bracket close, made an allegation that some unknown persons, BDOs, within bracket distributed denial of service, bracket close, attacks on Zeroda servers have taken place from various IP addresses and logs all over world. So, for instance, on October 6, 2021 and October 16, 2021, there were 40 lakhs and 4 crore 60 lakhs page requests created by the attackers. Zerodha page. Further, the Zerodha platform uses the services of Cloudflare for infrastructure security and protection, and for whom Cloudflare reports have shown that all the IP address and blocks were posted in Amazon AWS, for which Amazon AWS have requested for a official request to the police, and the complaint also requests to investigate the case. The council would submit that the police suspected this petitioner, and notice was also given in terms of police notice, and accordingly the petitioner was also appeared and assisting the police. It's an apprehension arrest. Hence, he may be enlarged on bail. For contrary, the council appearing for the state would submit that it was found in view of the phone number of this petitioner, and the council appearing for the state also not discuss the fact that the persons of notice he had appeared. The council appearing for the respondent petitioner brought to notice of this court that trial court will the bail application made an observation that in spite of issuing the notice, the petitioner herein has not appeared before the police. Cooperate with the investigation. When the notice was issued and also this petitioner appeared before the police, in spite of it is the intention of the petitioner that there is an apprehension of arrest. And when such being the case, when this petition given the statement, and according to the HCCP, the mobile of the petitioner was also seized. When such being the case, it is not a big agency, it is a big case to exercise the power for the date of their to enlarge non conditions to cooperate with the investigation. Raju M. 304B. Given.
ನಿಮ್ ಕೇಸ್ಗೆ ಇವಾಗ ಅಲ್ಲಿ ಹೋಗ್ತಾ ಇದೀವಿ ಹೈಕೋರ್ಟ್ ಹೋಗೋರು ಅದಕ್ಕೆ ಸಾಹೇಬ್ರು ಹೇಳ್ತಾರೆ.
Marriage. Not 4. Not 4 nil, the order sheet is 104, 105. That is an order sheet. Death note hakidira. I have furnished the death note. ಏನು ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ? ಸುಶೀಲಮ್ಮ ಅವರು ಏನು ಹವಾಮಾನದ ಹ?
The sheep was being creating the or executed the disease to get away. So whereas the accused on the one and the deceased one is on the.
ಹ್ಮ್ ಹ್ಮ್ ಕಸ್ಟಡಿಯಲ್ಲಿ ಯಾವಾಗಿಂದ ಇದ್ದಾನೆ 2019 ಇಂದನೇ ಇದ್ದಾನೆ ನೋಡಿ. Third, the petitioner counsel and also the counsel appearing to the state. The factual matters of the case of the prosecution is that this petitioner marriage was solemnized with the victim in 2019. And at the time of marriage, they have given 10 lakhs rupees. And after the marriage also, this petitioner and accused number 2 both insisted her to get additional dowry. And hence father had arranged an amount of 2 lakh. And in spite of it, harassment was continued. And abusing her that she is not a fit daughter-in-law. And she was consoled on several occasions. In spite of 2 lakhs was arranged, not looked after her very well. Ultimately, the counsel appearing to the petitioner would vehemently contend that this petitioner is in custody from 2019, 21, and others who have been arraigned as accused persons have been enlarged on bail. The counsel also would submit that investigation has been completed and charge sheet is also filed and no material to connect this petitioner that he subjected her for harassment and cruelty. And question of invoking section 304B doesn't arise. And so also section 3 and 4 of DP Act. The counsel also would submit that in the death note no allegations are made against this petitioner. And victim herself says sorry to him. And hence he may be enlarged on bail. May be enlarged on bail. For contrary, the counsel appearing to the state would submit that the complaint allegation as well as statements of witnesses clearly discloses that this petitioner subjected her for both as well as
ಸಂದೇಶದ ಈಗ ಅಲ್ಲಿಗೆ ಹೋಗಿದಾರೆ ಅಂತ ಗೊತ್ತಾಗಿರುತ್ತಲ್ಲ.
ಯಾರೇ ಅದು ನೋಟ್ ಏನಾಯ್ತು ಮೇಡಮ್ and also suspected her that she has scolded the family members. And death note also reveals the same. Having heard the respective counsel and also on perusal of material, particularly taking note of death was taken place on 22/10/2021. And she has committed suicide in the matrimonial home. No doubt marriage was also solemnized in 2019. And apart from that, other accused persons were enlarged on bail. This petitioner is in custody from the date of arrest. And having taken note of the contents of the death note, no specific allegations are made against this petitioner except he is expressing that those he loved him so much, this petitioner did not understand her. And also she has stated that she has not even quarreled with baby sister. Baby akka. Baby ಯಾವತ್ತು ಬೇಬಿ ರೇಖಾ BB ಏನೋ ಇರ್ಬೋದು. We never behaved and her caused any hurt against Rekha sister. And say sorry. And having taken note of the contents of the death note, it is a fit case to exercise the powers of 439 of CRPC with conditions. Why counsel? Charge sheet ಆಗಿದೆಯಾ? ಆಯ್ತು. Traditional counsel supposed that charge sheet already filed. Proclaimed offender ಅಂತಲ್ರಿ. 438 ಹೆಂಗ್ ಮೇಂಟೈನ್ ಆಗುತ್ತೆ? ಆಗಿಲ್ವಾ? ಆಯ್ತು. Traditional counsel seeks style to produce the order sheet that summons was not served on him. Hence, this matter on 18. Basavaraj Isappa Hadalagi. Yes, counsel. Charge sheet ಹಾಕಿದ್ದೀರಾ? Yes, where is the charge sheet? ಹಾಕಿಲ್ವಾ? ಈಗ ಆಗ್ತಾ ಇದ್ದೀರಿ? ನಿಮ್ಮ ಹತ್ರ ಇದೆಯೇನ್ರಿ? ಆಯ್ತು ಹೇಳಿ. ಚಾರ್ಜ್ ಶೀಟ್ ನೀವು ನೋಡಿದೀರಾ ಮೆಟೀರಿಯಲ್? ಆಯ್ತು ಹೇಳಿ ಏನು?
Who in turn had information that some petitioner and her brother and her mother together had reached only head to some unknown. And there were found.
Now they are relying upon the eyewitness evidence of CW3.
CW3 does not speak about three. That he is the eyewitness to the incident. If each and every witness that he came to know from some other source. None of them are eyewitnesses to the incident. He fell down and sustained one incident of the process. One signal here, getting water from there is a disease that is fell down. By running away from the escape from the clutches of evil. There he fell down, sustained one injury. That could be the 2.5 injuries is still different. The cause of death is due to the regurgitation to particles entering into the this is the interpret down to the house of the those there he hit his mother. She sustained the injury from her head. Seeing the level, no one they were coming, he started.
Yes, go to the statement of CW3. Eyewitness, sole eyewitness to the incident. Manoj son of Manjunatha. ಏನಿದ್ದಾರೆ ರಿಕವರಿ ಏನಾರು ಇದೆಯಲ್ರಿ? ವುಡನ್ ಸ್ಟಿಕ್ ಬ್ಲಡ್ ಸ್ಟೈನ್ಸ್ ಇದೆಯಾ? ಬ್ಲಡ್ ಸ್ಟೈನ್ಸ್ A1 and A2 ಸಿಮಿಲರ್. ದೊಣ್ಣೆಯಿಂದ ಹೊಡೆದ್ರು ಅಂತಲ್ಲ. ವಾಟ್ ಅಬೌಟ್ A2? A2 ಏನಾಗಿದೆ? ದಿಸ್ ಇಸ್ A2 ನಾ? A2. A1 and A2. Whether any bail granted in favor of other accused persons? First petition ಬೇರೆ ಯಾರಿಗೂ ಆಗಿಲ್ಲ. ಏನ್ ರಿಕವರಿ ಏನಾಗಿದೆ? ವುಡನ್ ಕ್ಲಬ್ ಬ್ಲಡ್ ಸ್ಟೈನ್ಸ್ ಇದೆಯಾ?
It was laying there and it was everyone hit the club. It was laying on the spot. He picked up that wooden club and he but whether he has hit or not, nobody has seen. Oh, well,
that's why I'm asking you. Read CW3 eyewitness statement Manoj ಅಂತ ಅವನ ಸ್ಟೇಟ್ಮೆಂಟ್ ನೋಡೋಣ. ರವಿಕುಮಾರ್ ಬೇಡ, ಮನೋಜ್ ಅಂತ ಇದೆ ನೋಡಿ. ಅವನ್ ಐ ವಿಟ್ನೆಸ್ ಅಂತ ಸೈಟ್ ಮಾಡಿದ್ದಾರೆ. ಎಲ್ಲಿದೆ ಪೇಜ್ ನಂಬರ್? ಎಲ್ಲಿದೆ ರೀ ಪೇಜ್ ನಂಬರ್ ಹೇಳಿ. ಈಗ ಚಾರ್ಜ್ ಶೀಟ್ ಕಾಪಿ ಹಾಕಿದಿರಿ, ಅದ್ರಲ್ಲಿ ಇರುತ್ತೆ ಸ್ಟೇಟ್ಮೆಂಟ್. ಪೇಜ್ ಮಾಡಿದಿರಲ್ಲ ಎಲ್ಲ 65 64 ಎಲ್ಲ ಪೇಜ್ ವೈಸ್ ಮಾಡಿದಿರಿ ನೀವು ಪೆನ್ಸಿಲ್ ಅಲ್ಲಿ. ನಿಮ್ಮ ಹತ್ರ ಇಲ್ವಾ ಅದು? ಮನೋಜ್ ಐ ವಿಟ್ನೆಸ್ ಇಲ್ಲೇ ಇದೆ ನೋಡು. ಕೃಷ್ಣಮೂರ್ತಿರವರ ಮನೆಯ ನೇರದಲ್ಲಿ ಹೋಗುತ್ತಿದ್ದಾಗ ರಸ್ತೆಯ ಬಲಭಾಗದಲ್ಲಿರುವ ಹೊಲದಲ್ಲಿ ಹನುಮಂತೇಗೌಡ ಮತ್ತು ಅವರ ತಾಯಿ ಗಂಗಮ್ಮ ಮತ್ತು ತಂಗಿ ನಾಗರತ್ನರವರು ಸೇರಿ ಜಗದೀಶನ ಮೇಲೆ ಜಗಳ ಮಾಡುತ್ತಿದ್ದರು. ನಂತರ ನಾನು ಡೈರಿಗೆ ಹೋಗಿ ಹಾಲಿನ ಕ್ಯಾನ್ಗಳನ್ನು ತುಂಬಿಕೊಂಡು ವಾಪಸ್ ಬರುವಾಗ ಅವನಿಗೆ ಹೊಡೆದು ಬಿದ್ದಿದ್ದ ಅಂತ ಹೇಳ್ತಾನೆ. ಇಲ್ಲಿ ಇದು PM ರಿಪೋರ್ಟ್ ಎಲ್ಲಿದೆ ರೀ? ಇದು ತಲೆಗೆಲ್ಲ ಇಂಜುರಿ ಬಂದಿದೆಯಲ್ಲ, PM ರಿಪೋರ್ಟ್ ಎಲ್ಲಿದೆ? ಹೆಡ್ ಇಂಜುರಿ, ಅದೇ ಹೆಡ್ ಇಂಜುರಿ Photo head injury. Death was due to aspiration of food particles into air passages due to head injuries. Without funding for want of analysis and pathological examination report. Huh?
Money injury and that fell down while reading. And he himself had got to the out of the and there he picked up car, he did that mother so and ran from there. So while running away, he fell down and died. No, what I think is there. He has not felt up in any blood and he has not.
ಏನ್ರಿ ಒಂದೇ ಹೆಡ್ ಇಂಜುರಿ ಒಂದೇ ಇರೋದು ಒಂದೇ ಕ್ಲಬ್ ಇರೋದು ಹೊಡೆದ್ರು ಅಂತ ಬಟ್ ಹೊಡೆದ್ರೆ 2-3 ಇಂಜುರಿ ಇರುತ್ತೆ ಒಂದೇ ಇದೆ ಮೇನ್ಲಿ ಆನ್ A1 ನೋಡ್ heard the petitioner counsel and also the counsel appearing for the state. ಅದೇನೋ ಮೊಬೈಲ್ ವಿಚಾರ ಗಲಾಟೆ ಆಗಿರೋದು.
What is the mobile number? What is the age?
Heard the petitioner counsel and also the counsel appearing for the state. The factual matters of the case of the prosecution is that there was frequent quarrel with the deceased and A3 with regard to the mobile. And CW4 and 8 went and told A3 to give back the mobile and not return the same. And in spite of it, not return the same. That on 2/4/22, when the deceased at around 4:30 to 4:45 went near the house of A3 and asked him to return the mobile. And galata was taking place between them. Having heard the galata sound, A2 came to spot. He also started quarrel with the victim. And the A3 also abused in a filthy language and assaulted with her hands. The A1 also came to spot. And when the victim saw the A1, he started running from the place. And at that time, A1 and A2 both chased him. And at that time, victim fell down near the vacant land of CW2. And A1 and A2, with an intention to take away the life, A1 picked up the club from the spot and inflicted injury on the head. On the forehead. And accused number 2, that is the petitioner herein also with the very same club, inflicted injury on the head with an intention to take away his life. And as a result, he has sustained injury to head and he succumbed to the injuries. The counsel appearing to the petitioner would submit that an omnibus allegation is made against accused number 1 and 2. And it is highly impossible to inflict the injury with the very same club. And also the prosecution mainly relies upon the statement of CW3. The CW3 only in this statement says that earlier he saw the quarrel but he did not witness the incident of assault. And the council also brought to notice of this court the injury found on the head, and cause of death is also was due to aspiration of food particles into air passages due to head injuries. And hence petitioner is entitled for bail. For counter, the council appearing for the state to submit that a specific vote act allegation is made against this petitioner that this petitioner only inflicted the injury with the club on the head. The council also brought to notice of this court that the cause of death on, as per the provisional opinion, death was due to aspiration of food particles into air passages due to head injuries. And the allegation against this petitioner corresponds with the nature of injuries found in the PM report. And apart from that, CW3 also witnessed the incident of quarrel, and there is a direct evidence against the petitioner hearing. Having heard the respective counsel and also on perusal of material, court act allegation is made against this petitioner and also A1 that they inflicted injury with the very same club. The other allegation against accused number 3 is that accused number 3 assaulted with hands. On perusal of the PM report, there are two injuries. One is split laceration is present sagittally over the left side top of the head within bracket vertex, measuring 7 centimeter into 2 centimeter, X scalp depth and situated 12 centimeter above the left ear. The other injury is scratch operation is obliquely present over the front of right forearm, starting from the outer aspect of right elbow, runs downward and inward of the front of right forearm, measuring 17 centimeter into 0.7 centimeter in length. Having taken note of the nature of injury and also allegation against this petitioner and accused number 1 that even though the victim tried to escape from the spot by seeing the accused number 1, both of them chased the victim, and while chasing the victim fell down at the vacant place of CW2, and by that time both this petitioner and also accused number 1 inflicted injury with the same club. The specific vote act allegation made against this petitioner is that he used the very same club used by accused number 1 and inflicted injury on the head. And also taking note of the injury, the measurement, head injury is measuring 7 centimeter into 2 centimeter. And when such being the material on record, and CW3 also witnessed the incident of quarrel at the first instance, and thereafter when he came back, he found the injured is lying. And when such being the material on record, when specific vote act allegation is made against this petitioner, and the cause of death is also in terms of the PM report corresponds with nature of injury. And when such being the material on record, it is not a fit case to exercise the discretion in favor of the petitioner. The council appearing for the state also submit that the club was seized and the same is also sent to the FSL. FSL FSL in the report, and FSL report is awaited. And hence, unless FSL report is awaited, not a fit case to exercise the discretion. We have the discussion made by Pastor Palangoda, bail petition is rejected. However, liberty is given to approach this court after the receipt of FSL report. Why counsel? Last time also pressed him. ಆಯ್ತು ಹಾಕಿದ್ರಿ ಇಲ್ಲ ಏನ್ ಹಾಕಿದ್ರಿ ಈಗ ಲಾಸ್ಟ್ ಟೈಮ್ on what ground you have sought time ಕೊಡಿ ಆಯ್ತು ಈ ಶಿವಮೊಗ್ಗ ಆಗ್ಲಿ ಎಲ್ಲಾರು ಲರ್ನೆಡ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದ ಪಿಟಿಷನರ್ ಸೀಕ್ಸ್ ಟೈಮ್ ಅಂತ ಇದೆ ನೋಟ್ ಜಡ್ಮೆಂಟ್ ಪಾಸ್ ಓವರ್ ಮಾಡ್ತೀನಿ ನಿಮ್ ಸೀನಿಯರ್ ಇಲ್ಲ ಅಂದ್ರೆ ಕರ್ಸಿ ಇಲ್ಲ ಅಂದ್ರೆ ನೀವೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಪಾಸ್ ಓವರ್ ಏನು
EAP is conducted. EAP report is not approved. But they are writing. Get EAP report.
Last occasion also you took time. ಯಾವ ಗ್ರೌಂಡ್ ಒಟ್ನಲ್ಲಿ ಟೈಮ್ ತಗೊಂಡಿದ್ರಿ ನೋಡಿ how many times court has to read the papers
EAP report our customer. EAP report is required.
ನಿಮ್ಮ ಹತ್ರ ಇದೆಯೇನ್ರಿ ಅವ್ರ ಹತ್ರ ಇದೆಯಂತ
You get a certificate copy.
Now petitioner counsel again sixth time. List this matter on 18th. No further 18th next Monday. 21st. 21st. No further time will be granted on that day. ಹಾಕೊಳ್ಳಿ on the ground that PI parade papers are not there ಅಂತ ಕರುಣಾಕರ ಹೇಳಿ ಮೇಡಮ್ to 68 gram of what? Dry ganja. Only dry ganja. Where it was seized? Because this is petitioner section 438. Where it was seized? Agricultural land belongs to this petitioner. Kudrakonda Gramada Rudrappa is the petitioner. ಇವರಿಗೆ ಸೇರಿದ ಸರ್ವೆ ನಂಬರ್ 37 ಜಿಲ್ಲೆಯಲ್ಲಿ ನಾಡಿ ನಡೆಸಿ ಹೋದಾಗ ಮೆಕ್ಕೆಜೋಳದ ಇಂಧನ ಸಂಗ್ರಹಿಸುತ್ತಲು ನರಕೆ ಕಟ್ಟಿದ ಸ್ಥಳದಲ್ಲಿ ಅರೇವಾ ಪೇಂಟ್ ಕಂಪನಿ ನೀಲಿ ಮತ್ತು ಬಿಳಿ ಬಣ್ಣದ ಸಾಮರ್ಥ್ಯದ ಒಂದು ಪ್ಲಾಸ್ಟಿಕ್ ಬಕೆಟ್ ಇರುವುದು ಕಂಡು ಬಂದಿದ್ದು ಅದನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಘಾಟು ವಾಸನೆಯಿಂದ ಕೂಡಿದ ಗಾಂಜಾ ಎಲೆ ಗಾಂಜಾ ತೆನೆಯ ಪುಡಿ ಹಾಗೂ ಒಣ ಗಾಂಜಾ ಕಂಡು ಬಂದಿತ್ತು. ಎನಿ ಕ್ರಿಮಿನಲ್ ಆಂಟಿಸಿಡೆಂಟ್ಸ್ ಏನಾರು ಇದೆಯೇನ್ರಿ ಇಲ್ವಾ ಫಸ್ಟ್ ಟೈಮ್ ನೋಡಿ Heard the petitioner counsel and also the counsel appearing for the state. The factual matters of the case of the prosecution is that on 33/22 at 9:30 a.m. on credible information that illegally possessed with dry ganja went and found 268 grams of dry ganja in the land of this petitioner in survey number 37. And hence the same was seized. The counsel appearing for the petitioner would submit that this petitioner has been falsely implicated in the case and this petitioner was not present at the time of the seizure. And also counsel would submit that the dry ganja seized quantity is also 268 grams and the same is a small quantity. And hence he may be enlarged on bail. He is ready to obey with the conditions that may be imposed by this court by appearing before the IO. For contra, the counsel appearing for the state would submit that dry ganja of 268 grams was found in the land of this petitioner and hence his presence is required for further investigation. Having heard the respective counsel and also on perusal of material available on record, particularly accusation made against this petitioner is that he had kept the 268 grams of dry ganja in the land belongs to him. And taking into note of the gravity of the offense and accusation made in the complaint as well as quantum of ganja, that is 268 grams, which is the small quantity. And hence, petitioner is entitled for bail with conditions to cooperate with the IO for the investigation. Jagadish H. Ilva? Pass over. Pravardhan Aras. Yes. One were having a extramarital relationship. So 3 and 4. They gave Supari. Where is the charge sheet? Page number 34. 34. Available at page 53. 53. Page number 53. Column number 17. Whether this victim is the husband of A1. Now A2 is the, according to the prosecution, he is the paramour. Howda? Yenri connect ಮಾಡಕ್ಕೆ ಏನಿದೆ 3 and 4 other than 120B. Phone recovered from A2.
Belongs to the name of A1. A1 is was used only for the purpose of communicating
A1.
And statements of
That is with regard to the extramarital relationship. What is the children also says that frequently is coming on. CW?
they are bought
Land.
always used to do in WhatsApp calls. And before that, he used to give SMS. Because it times all the calls. SMS or this calls are only for communication. There is also a frequent calls to A3 and 4. And
A3 and A4. Call between
A2, A3,
A2 to 3.
they are the main assignments.
3 and 4. This petitioner was also in touch with the A3 and A4.
And he was deposited to somebody else. CW. After putting their order,
After the murder. A4's account.
prior to that, he was deposited.
Prior to the 4.
He had given 50,000 cash.
Total 2.5 lakh. Henry, what is your answer to all this? Whether you made phone call to A3 and A4 or not? No.
It says that A4 already after the incident. But as per the CDR report,
Date of incident ಯಾವಾಗ? 31/1/22.
CDR report of A4 page
365. 409.
After the incident, A4 already found that there's no such project.
Four not name. 31/1/22. Murder at what time? 3:45. ಒಂದುವರೆಗೂ ಇದೆ ಕಾಲು. ಮುಂಚೆನೇ ಇದೆ. ಮರ್ಡರ್ ಮಾಡಕ್ಕಿಂತ ಮುಂಚೆ ಇದೆ. ಮರ್ಡರ್ ಮಾಡಕ್ಕಿಂತ ಮುಂಚೆ ಇದೆ ಅಂದೆ. ಕಾಲು ಮರ್ಡರ್ ಮಾಡಕ್ಕಿಂತ ಮುಂಚೆನೇ ಇದೆ ಅಂದೆ. ಮತ್ತೆ ಹೂಸ್ ನಂಬರ್?
The money is being transferred to A3 and A4. The statement of CW26. This is Mr. SK.
Page number 5. 504.
ನಾನು ಕಂಪನಿಗೆ ಹಣ ಕಳಿಸಬೇಕಾಗಿತ್ತು. ಫೋನ್ ಪೇಗೆ ಹಣ ಕಳಿಸಿ ನನ್ನ ಫೋನ್ ಪೇ ಇಂದ ದಿನಾಂಕ 8/12/5,000, 12/5,000, 15/12/10,000, ದಿನಾಂಕ 17/12/5,000, 19/12/10,000 ಮತ್ತು 23/12/5,000 ನವೀನ ಸಬ್ಸಿಡಿಗಳು ಫೋನ್ ನಂಬರ್ ಹೇಳಿ ಫೋನ್ ಪೇ ಮಾಡುವಂತೆ ತಿಳಿಸಿದರು. ಅದರಂತೆ ನಾನು 16 ಫೋನ್ ಪೇ ಮಾಡಿದ್ದೆ. But there is no record to show that petitioner transferred the money to CW26 through phone pay. Also, my lord, as far as CW19 statement is concerned, it says that I handed in over cash of 1 lakh rupees. But he's ಕೂಲಿ ಕೆಲಸ ಮಾಡಿಕೊಂಡು ಜೀವನ ಮಾಡಿಕೊಂಡು that I got this legal and handed him over 1 lakh to deposit it to a
But he is an employee of this petitioner. What is his name? Whether he says he made the payment or not. ನನ್ನ ಅಂಗಡಿಗೆ ಬರಮಾಡಿಕೊಂಡು ನಾನು ಆರ್ವೇರ್ ಅಂಗಡಿ ಮಾನವ ಸಾಮಾನು ಉಪಯೋಗಿಸಿಕೊಂಡು ನನ್ನ ಹತ್ತಿರ 1 ಲಕ್ಷ ಹಣವನ್ನು ಸೇಮ್ ಮುಗ್ಗೇಳಿ ಕೆನರಾ ಬ್ಯಾಂಕ್ ನ ಹಣ ಕಟ್ಟಿ ಬರುವಂತ ತಿಳಿಸಿದರು. ಕಟ್ಟಿರುತ್ತೇನೆ. That is A4 account. This is an account belongs to the A4. You only given instructions to deposit the amount to the account of A4. That's what he says. A2. Hmm. 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 Hardware store or painter? ಇನ್ನೊಬ್ಬ ಎಲೆಕ್ಟ್ರಿಷಿಯನ್ ಆಯ್ತು. It also connects. Customers.
The other witnesses will transfer money or matter.
Hmm. Hmm.
I hope.
Good. I will not consider that. Only now material only I will see the prima facie case. That's all. A1 and A2 relationship ಬಗ್ಗೆ ನಾನೇನು ಹೇಳೋದಿಲ್ಲ. It is a matter of trial. Witnesses should speak during the course of the trial. That's all. Bail matters ಅಲ್ಲಿ ಅವೆಲ್ಲ ನಾವು ಈಗ ಮೊನ್ನೆ ಒಂದು ಆರ್ಡರ್ ಸೆಟ್ ಮಾಡಿದೆ. 438 ಅಲ್ಲೇನೆ ಇಟ್ ಇಸ್ ಎ ಕನ್ಸೆನ್ಷಿಯಲ್ ಏನು ಸೆಕ್ಸ್ ಅಂತ ಹೇಳಲ್ಲ ಬರ್ತಿಟ್ಟಿದ್ರು. ಅವೆಲ್ಲ ನಾವು ಡಿಸೈಡ್ ಮಾಡಕ್ಕಾಗಲ್ಲ ಈಗ. Right. Only the accusation. There was a extramarital relationship between A1 and A2. That is the case for committing the murder of deceased ancestor. Right. Good. Heard the petitioner, counsel, and also the counsel appearing for the state. The factual matters of the case of the prosecution is that A1 and A2 were having extramarital relationship between them. And the victim is coming in the way of their relationship. And hence, in order to eliminate him, Sufari was given to accused number 3 and 4. And accordingly, on 31/1/2022, he implemented the Sufari entrusted by this petitioner to accused number 3 and 4 and committed the murder of victim. And hence, case has been registered and investigated the matter and filed the charge. The counsel appearing for the petitioner would submit that in order to connect accused number 1 and 2 that they were having extramarital relationship between them, no material is found. And apart from that, in order to give Sufari murder to accused number 3 and 4, also no material is placed before the court. The counsel also would submit that this petitioner is in custody from the date of arrest, and investigation has been completed and charge sheet has been filed and no need of custodial trial. And hence, he may be enlarged on bail. For contra, the counsel appearing for the state submits that A2 phone was seized, which is standing in the name of A1. One SIM. There were 2 SIMs, but one SIM. And he is using the very same SIM to talk to A1 continuously, and the same is used for only for the said purpose. The counsel also would submit that CW2 and 3, who are the children of the victim, made the statement that this petitioner was frequently visiting the house of accused number 1. And apart from that, A1 and A2 found in the agricultural land. And hence the victim installed the CCTV to the house. The counsel also submits that telephonic conversation between accused number 1 and 2 was found frequently, and they are using the WhatsApp call with an intention to not to record the same, and used to send message before making WhatsApp call. The counsel appearing for the state also would submit that A2 made frequent call to accused number 3 and 4, with whom he entrusted the work of eliminating the victim. The counsel also would submit that CW 25 and 26 have given the statement that money was also transferred to the account of the A3 and A4. And in all, payment of rupees 2.5 lakh, including cash, was paid to them. And hence there is a prima facie case against the petitioner. Herein and the CDR report also discloses frequent contact between A1 and A2 as well as A2 to 3 and A2 to 4. Having heard the respective counsel and also on perusal of material, incident was taken place on 31/1/22. And also phone was seized at the instance of this petitioner. And the same was standing in the name of the petitioner. And the same was standing in the name of the accused number 1. And also CDR reports also discloses both of them are constant, they were in constant touch with each other. The prosecution also mainly relies upon the CDR report with regard to A2 is in constant touch with A3 as well as A4. And apart from that, prosecution mainly relies upon the statement of the children of victim, that is CW2 and 3, with regard to the frequent visit and also found in the land. Both A1 and A2 and Galata was taken place with regard to the setback. The accusation made in the charge sheet that A1 and A2 are having illicit relationship, and the same cannot be a ground to consider and reject the bail petition, and the same is a matter of trial. And witnesses have to be examined with regard to both of them are having illicit relationship with each other. When the case of the prosecution that Supari was given to A3 and A4, and when the CDR report discloses constant touch with this petitioner and accused number 3 and 4, and apart from that, witnesses who made the phone pay with regard to the phone number of the A3 and A4 and the instructions of this petitioner, and all this material connects this petitioner with regard to accusation made against the petitioner hearing. And when such being the case, it is not a fit case to exercise the discretion in favor of the petitioner, since the investigation already been completed and the material collected by the IO prima facie discloses the case against the petitioner hearing. Herein, the counsel appearing to the petitioner would submit that investigation already been completed and charge sheet is also filed and no need of further custodian cannot be accepted for the reason that it is a heinous offense of taking away the life of a person. And the punishment is also either for life or for death. Hence, when an heinous offense is committed, not a case for granting bail. Raghavendra K. Counsel last time also took time. ಪ್ರತಿ ಸರಿ ಟೈಮ್ ಕೇಳಂಗಿಲ್ಲ. ಅದಕ್ಕೆ ಬಿಗಿನಿಂಗ್ ಎಲ್ಲ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡೇ ಕೊಟ್ಟಿರೋದು ಇವರು. ಆರ್ಡರ್ ಶೀಟ್ ತಗೊಳ್ಳಿ ಮೇಡಮ್, ತೋರಿಸಿ ಅವ್ರಿಗೆ ಆರ್ಡರ್ ಶೀಟ್. ಯು ಓನ್ಲಿ ಟುಕ್ ಟೈಮ್ ಲಾಸ್ಟ್ ಟೈಮ್. ಮತ್ತೆ ಆಯ್ತು 482 ಹಾಕೊಳ್ಳಿ, ಕ್ವಾಶ್ ಮಾಡಿಸ್ಕೊಳ್ಳಿ. ಬೇಲ್ ಕೊಟ್ರು ಕ್ವಾಶ್ ಮಾಡಿಸ್ಕೊಳ್ಳಿ, ಕೊಡದ ಹೋದ್ರು ಕ್ವಾಶ್ ಮಾಡಿಸ್ಕೊಳ್ಳಿ. ಹೇಳಿ 504, 506, 406, 420, 21 of banning of 9 of KPID Act. Argument ಮಾಡಿ. No date counsel. Last time also date ಕೊಟ್ಟಿದ್ದೀನಿ, ನೀವು ಕೇಳಿದ್ರಿಂದ ಕೊಟ್ಟಿದ್ದೀನಿ. ಅದಕ್ಕೆ ನಾವು ಫಸ್ಟ್ ಹಾಕ್ಬಿಟ್ಟಿರ್ತೀವಿ, ಅಡ್ವೊಕೇಟ್ ಶುಡ್ ನಾಟ್ ಸೀಕ್ ಎನಿ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಅಂತ. ನಾ ಓದ್ಕೊಂಡ್ ಬಂದಿರ್ತೀನಿ ಪೇಪರ್ಸ್, ಅದಕ್ಕೋಸ್ಕರ how many times court has to read your paper? ಹೇಳಿ ಮೆರಿಟ್ ಮೇಲೆ ಏನಿದೆ ಹೇಳಿ, ಇದ್ರೆ ಕೊಡೋಣ. ಇಂದವ್ರಿಲ್ಲ. ಫೈಲ್ ಇಲ್ಲ ಅಂದ್ಮೇಲೆ ಕೋರ್ಟ್ಗೆ ಯಾಕೆ ಬಂದ್ರಿ ವಿತೌಟ್ ಫೈಲ್? ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಇದ್ದೇ ಹಾಕಿರೋದು ಪಿಟಿಷನ್. ವಿತೌಟ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಯು ಆರ್ ನಾಟ್ ಫೈಲ್ಡ್ ದಿ ಪಿಟಿಷನ್. ಅದಾಗ್ಲಿ ಕ್ವಾಶ್ ಮಾಡಿರಿ, ಇನ್ನೂ ಬಹಳ ಅನುಕೂಲ. ಕೋರ್ಟ್ ಟೈಮು ಎಲ್ಲ ಉಳಿಯುತ್ತೆ. ಆರ್ಗ್ಯೂ ಮಾಡಿವ್ರ ಎಷ್ಟು ಸರಿ ಓದೋದು? Go to page number 15, copy of the complaint. ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಬೇಕಂದ್ರೆ 1,000 ಕಾಸ್ಟ್. ಏನ್ ಮಾಡ್ತೀರಿ ಹೇಳಿ, ನಿಮ್ಗೆ ಚಾಯ್ಸ್ ನಿಮ್ದು. ಆಯ್ತು. Petitioner counsel against 6 time against adjourned on cost of rupees 1,000 payable at register. This matter on 18th. A2, 3, 4, 5, 6, 7, 420, 468, 471. ಹೇಳಿ. 438 ಹೌದು.
Department we will apply for the same post process after the verification of the document. They will file the document as the paid document was based on that they are so I have paid this certificate from the Karnataka State Open University of Mysore Hospitals. I don't have knowledge about the making of the document and the provisions of section 471 is not attributed. Hence the concept of property also was there. I don't have intention to change.
If fake documents are used, then it attracts section 471. Made use of the forged document or fake documents for getting an employment, it attracts section 471 only.
I obtained a certificate from the Karnataka State Open University.
ಆಯ್ತು, ನೋಡೋಣ. ನೀವು ಅಪ್ಲೈ ಮಾಡಿದ್ರ ಅಥವಾ 50 CS ಆಮೇಲೆ ನೋಡೋಣ, ತನಿಖೆ ಆಗ್ಲಿ. ನಾನ್ ಡಿಸೈಡ್ ಮಾಡಾಕಲ್ಲ, ಅದನ್ನ ಡಿಸೈಡ್ ಮಾಡಕ್ಕೇನೆ ಪೊಲೀಸ್ ಇರೋದು. ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡಬೇಕು. ಯು ಹ್ಯಾವ್ ಟು ಅಪಿಯರ್ ಬಿಫೋರ್ ದಿ ಪೊಲೀಸ್ ಅಂಡ್ ಅಸಿಸ್ಟ್ ಮಾಡಿ. ನೀವು ಅವ್ರಿಗೆ ಅಸಿಸ್ಟ್ ಮಾಡಿ. ಅದೇನೆ ಅಸಿಸ್ಟ್ ಮಾಡ್ಬೇಕಂದ್ರೆ ನಿಮ್ ಪ್ರೆಸೆನ್ಸ್ ಬೇಕು. It is a serious offense. It is a serious offense using of fake documents for employment. That too in the government department.
If there is an intention, then only it's a serious offense.
Council not a case for 438. ಹೇಳಿ. ಏನ್ ಪಾಸ್ ಓವರ್ ಮಾಡಿದ್ರೆ ಏನು ಉಪಯೋಗ ಇಲ್ಲ. ಏನ್ ಹೇಳಿ, ನೀವು ಪ್ಲೇಸ್ ಮಾಡಿದ್ರು ನಾನ್ ಕೂತ್ಕೊಂಡು ಇಲ್ಲಿ ಡಿಸೈಡ್ ಮಾಡಕ್ಕಲ್ಲ ವೆದರ್ ಇಟ್ ಇಸ್ ಎ ಫೇಕ್ ಆರ್ ನಾಟ್. Not a case for 438. That's all. ಹೌದು. ಏಳು ಅಭ್ಯರ್ಥಿಗಳ SSLC ಮೂಲ ಅಂಕ ಪಟ್ಟಿಗಳ ಬಗ್ಗೆ ಸೂಕ್ತವಾದ ತನಿಖೆ ನಡೆಸಬೇಕಾಗಿತ್ತು. ಅಭ್ಯರ್ಥಿಗಳ ವಿವರ SSLC ಅಂತಾರೆ. ನೀವು ನೋಡ್ರಿ ಯಾವ್ದು ಮತ್ ನೀವು ನೋಡಿದ್ರೆ ಯಾವ್ದು ಓಪನ್ ಯೂನಿವರ್ಸಿಟಿ ಅಂತೀರಿ. ಯಾವ ಓಪನ್ ಯೂನಿವರ್ಸಿಟಿ? ಕ್ಲಾರಿಫಿಕೇಶನ್ ಏನಿಲ್ಲ. ಓಪನ್ ಯೂನಿವರ್ಸಿಟಿ ಅಂತ ನೀವ್ ಹೇಳ್ತೀರಿ. ಇಲ್ಲಿ ನೋಡಿರೋದು SSLC ಮಾರ್ಕ್ಸ್ ಕಾರ್ಡೇ ತಿದ್ದಿರೋದು. ಅಂಕಪಟ್ಟಿಯಲ್ಲಿ ಇರೋದು ಅಧಿಕೃತ ದೃಢಪಟ್ಟಿದ್ದು. ಅದು ತಾತ್ಕಾಲಿಕ ಆಯ್ಕೆ ಪಟ್ಟಿಯಲ್ಲಿ ಸೇರಿದ್ದಾರೆ, ಸೆಲೆಕ್ಷನ್ ಆಗಿದ್ದಾರೆ. ಆಮೇಲೆ ವೆರಿಫಿಕೇಶನ್ ಹೋದಾಗ ದೀಸ್ ಆರ್ ದಿ ಫ್ಯಾಕ್ಟ್ಸ್ ಕಮ್ಸ್ ಟು ಲೈಟ್ ದಟ್ ದೀಸ್ ಆರ್ ದಿ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಆರ್ ಫೋರ್ಸ್ಡ್. ಇವನ್ ಸೆಲೆಕ್ಷನ್ ಪ್ರೋಸೆಸ್ಗೋಸ್ಕರ ನಿಮ್ಮನ್ನ ಮಾಡಿದ್ದಾರೆ. ಸೆಲೆಕ್ಷನ್ ಆಗ್ಬಿಟ್ಟಿದ್ದೀರಿ, ವೆರಿಫಿಕೇಶನ್ ಮಾಡುವಾಗ ಗೊತ್ತಾಗಿರೋದು ಇವು ಫೇಕ್ ಅಂತ. ಹೌದಲ್ಲ? ಅಲ್ಲಿ ಪ್ರೈಮಾ ಫೇಸಿ ದೋಸ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಆರ್ ಫೇಕ್ ಅಂತ ಆಯ್ತು. ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಇಂದ ತರಿಸಿರ್ತಾರೆ. ಕ್ರಾಸ್ ವೆರಿಫೈ ಮಾಡೋದೇನೆ ಫ್ರಮ್ ದಿ ಡಿಪಾರ್ಟ್ಮೆಂಟ್. ಬೋರ್ಡ್ ಅಲ್ಲಿ ಕ್ರಾಸ್ ಚೆಕ್ ಮಾಡಿದಾಗ ನಿಮ್ಮವ್ರು ಸಿಕ್ಕಾಕೊಂಡಿರೋದು. ಇನ್ನೇನ್ ಕ್ಲಾರಿಫಿಕೇಶನ್ ತಗೊಂಡೆ ಕಂಪ್ಲೇಂಟ್ ಬರ್ದಿರೋದು. ಕಂಪ್ಲೇಂಟ್ ಫೈಲ್ ಮಾಡೋದು. ರೆಗ್ಯುಲರ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಏನ್ ಬರ್ತದೆ? SSLCನೇ ಫೇಕ್ ಅಂತ ಗೊತ್ತಾಗಿದೆ. ಪರೀಕ್ಷಾ ಮಂಡಳಿ ಎಂದಿರುತ್ತದೆ. ಆದ್ದರಿಂದ 7 ಅಭ್ಯರ್ಥಿಗಳ ಅಂಕಪಟ್ಟಿಗಳು ನೈಜವಾಗಿರುವುದಂತೂ ಲೆಟರ್ ಬರ್ದವ್ರೆ. ಲೆಟರ್ ಬರ್ದಿದ್ದಕ್ಕೆ ಒಪಿನಿಯನ್ ಏನಿದೆ ಕೊಡು. ಮಾತ್ರ ಇದೆಯಾ?
That is a
ಮಾರ್ಕ್ಸ್ ಕಾರ್ಡ್ ಆಲ್ಸೋ ನಿಮ್ ಕಡೆಗೆ ಇದೆಯೇನ್ರಿ? ನಿಮ್ಮ ಹತ್ರ ಒಪಿನಿಯನ್ ಇದೆಯೇನ್ರಿ? ಒಪಿನಿಯನ್ ಬಂದಿದ್ಯಾ? ಅಲ್ಲ ರೀ, ಫಸ್ಟ್ ಒಪಿನಿಯನ್ ಬರುತ್ತೆ ನಿಮ್ದು, ವೆರಿಫಿಕೇಶನ್ ಕಳಿಸ್ತಾರೆ. ನೀವು ಇಲ್ಲಾಂದ್ರೆ ಕಂಪ್ಲೇಂಟೇ ಫೈಲ್ ಮಾಡಕ್ ಬರಲ್ಲ ಅನ್ಲೆಸ್ ಯು ಗೆಟ್ ದಿ ಒಪಿನಿಯನ್ ಫ್ರಮ್ ದಿ ಬೋರ್ಡ್. ಇದು ಲೆಟರ್ ಬರ್ದಿರೋದಷ್ಟೇ. ಇದು ಅವ್ರು ಕೊಟ್ಟಿದ್ ಲೆಟರ್ ಬರ್ದಿರೋಂಥದ್ದು. ಇದು ಮಾರ್ಕ್ಸ್ ಕಾರ್ಡ್ ಯಾರು ಕೊಟ್ಟಿದ್ ನೋಡಿ. ಕರ್ನಾಟಕ ಪ್ರೌಢ ಶಿಕ್ಷಣ ಪರೀಕ್ಷಾ ಮಂಡಳಿಯ ಕಾರ್ಯದರ್ಶಿಗಳು, ಕರ್ನಾಟಕ ಮುಕ್ತ ಶಾಲೆ KOS ಇದು. ಇವರು SSLC ಮೂಲ ಅಂಕಪಟ್ಟಿಗಳು ನೈಜವಾಗಿರುವುದಿಲ್ಲ ದೃಢೀಕರಿಸಿ, ಇಲ್ಲೇ ಇದೆ ನೋಡ್ರಿ, ನೀವು ಹಾಕಿರೋ ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ ಅನೆಕ್ಷರ್ ಬಿ ನಲ್ಲಿ ಇದೆ. ವರದಿ ಅನ್ವಯ 7 ಅಭ್ಯರ್ಥಿಗಳ SSLC ಮೂಲ ಅಂಕಪಟ್ಟಿಗಳ ಬಗ್ಗೆ ಸೂಕ್ತವಾದ ತನಿಖೆ ನಡೆಸಬೇಕಾಗಿದ್ದು, ಅಭ್ಯರ್ಥಿಗಳ ವಿವರ ಈ ಕೆಳಗಿನಂತಿದೆ. ಅವರೇ ಕನ್ಫರ್ಮ್ ಮಾಡಿದ್ದಾರೆ ಫೇಕ್ ಅಂತ. ಅನೆಕ್ಷರ್ ಬಿ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಮೆನ್ಷನ್ ಮಾಡಿದ್ದಾರೆ ಅಂದೆ. ಏನ್ರಿ ಕೋಡ್ನವರು ರಿಪ್ಲೈ ಕೊಟ್ಟಿರೋದು ಇವರಿಗೆ. ಕರ್ನಾಟಕದಲ್ಲಿ ಶಿಕ್ಷಣ ಪರೀಕ್ಷಾ ಮಂಡಳಿ ಏನಿರುತ್ತೆ ಅದರಿಂದ 7 ಅಭ್ಯರ್ಥಿಗಳ ಅಂಕಪಟ್ಟ ನೈಜವಾಗಿರುವುದರಿಂದ ಈ ಮೂಲಕ ಅಷ್ಟೇ. Heard the petitioner counsel and also the counsel appearing for the ಡಾಕ್ಯುಮೆಂಟ್ ಯಾವ್ದು ಹೇಳಿ, ನೀವು ಕೊಟ್ಟಿರೋ ಡಾಕ್ಯುಮೆಂಟ್ ಯಾವ್ದು? ಯಾವ್ದು ಹೇಳಿ ಆ ಡಾಕ್ಯುಮೆಂಟ್? ಅದರಲ್ಲೇ ಕೊಟ್ಟಿರೋದು ನಾಟ್ ಜಿನೈನ್ ಅಂತ ಕೊಟ್ಟಿರೋದು ಅದು. ಮತ್ತೆ ಮಾರ್ಕ್ಸ್ ಕಾರ್ಡ್ ಆಯ್ತು, ಹೇಳಿ.
The Karnataka open school examination. There is document lordship I am obtained from the Kendra Vilasa. It's bottom of the page of it. Study center for name and address. QQ006.
Yes.
Karnataka open school. Sri
ಶಿವರಾತ್ರೀಶ್ವರ ನಗರ, ಮೈಸೂರು. ಎಕ್ಸಾಮಿನೇಷನ್
was issued on 26 July 2022. The authority of the complaint should get the clarification from the Karnataka Secondary Education Board of open school audit, but not the regular the examination authority. There are constituted as 2 departments. One is Karnataka Karnataka Secondary Education Examination Board, which is a regular process. This is not a regular process.
ಅವ್ರ ರೆಫರೆನ್ಸ್ ಅಲ್ಲಿ ಹಾಕಿದಾರೆ ನೋಡಿ ಲೆಟರ್. ಕರ್ನಾಟಕ ಮುಕ್ತ ಶಾಲೆ KOS ಅಂಕಪಟ್ಟಿಯ ನೈಜತೆ ಪರಿಶೀಲನೆ ಕುರಿತು ಅಂತ ಅವರೇ ಅದ್ರ ಬಗ್ಗೆ ರೆಫರೆನ್ಸ್ ಹಾಕಿ ರಿಪೋರ್ಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ರೆಫರೆನ್ಸ್ ಹಾಕಿ ಕೊಟ್ಟಿದ್ದಾರೆ ನೋಡಿ, ಅಲ್ಲೇ ಇದೆ ಸಬ್ಜೆಕ್ಟ್. ಯು ಸಿ ದಿ ಸಬ್ಜೆಕ್ಟ್ ಇದೆಯಲ್ಲ ಅಷ್ಟೇ. ಆಯ್ತು, ಕೌನ್ಸಿಲ್ ನಾಟಿ ಕೇಸ್ ಫಾರ್ ಗ್ರಾಂಟಿಂಗ್ ಆಂಟಿಸಿಪೇಟರಿ. ಸ್ವಲ್ಪ ದಿವಸ ಒಳಗೆ ಹೋಗಿ ಬರ್ಲಿ ಬಿಡಿ, ಏನಾಗಲ್ಲ. ಆಮೇಲೆ ನೋಡಿ, ಇಂಥವ್ರನ್ನೆಲ್ಲ ಬಿಟ್ರೆ ಆಗೋದಿಲ್ಲ. ಕ್ಲಾಸಸ್ ಎಲ್ಲ ಆಮೇಲೆ ನೋಡೋಣ, ವಿಲ್ ಸಿ. ಬಟ್ ಗಾಟ್ ಇಟ್ ಕನ್ಫರ್ಮ್ ದಟ್ ದೀಸ್ ಆರ್ ದಿ ಫೇಕ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅಂತ. ಆಯ್ತು, ಅವ್ರು ಮಾಡಿರ್ತಾರೆ. 439 ಇರ್ಬೇಕು ನೋಡಿ. 9 ಅಷ್ಟೇ, 439 ಅಷ್ಟೇ, 439, 437 ಇರ್ಬೋದು. ಆಯ್ತು, ರೆಗ್ಯುಲರ್ ಬೇಲ್ ನಾಟ್ ಆಂಟಿಸಿಪೇಟರಿ ಬೇಲ್. ಆಯ್ತು, ನಾನ್ 438 ಕೊಡಲ್ಲ. ಟ್ರಯಲ್ ಕೋರ್ಟಲ್ಲಿ ಹೋಗಿ ರೆಗ್ಯುಲರ್ ಬೇಲೆ ತಗೊಂಡಿ, ನಂದೇನ. ಆಯ್ತು, ನಾನಂತೂ ಕೊಡಲ್ಲ ಈ ತರದ ಕೇಸ್ಗಳಲ್ಲಿ ಕೊಡಲ್ಲ. Heard the petitioner counsel and also the counsel appearing for the state. The factual matters of the case of the prosecution is that these petitioners have applied for the post of D group in the police department, in the fire service department, and they have been selected in the temporary list, and documents were sent to SSLC, open SSLC board, and received the report that the documents which have been placed at the time of seeking an appointment are the fake documents, and hence complaint is lodged by the Director of Police dated 13/5/2022 to take action against them, and hence case has been registered, invoking the offences punishable under section 420, 468, 471 of IPC. The counsel appearing for the petitioner would vehemently contend that the petitioners are ready to assist the IO, and the allegation made in the complaint is baseless, and report is not obtained from the Karnataka Open KYS. And also placed the marks card before the court and says that the examination was conducted by Karnataka Secondary Examination Board and center is JSS Karnataka Open School, Sri Shivarateshwara Nagara, Mysore, Karnataka. And appearing through the center only, they passed out in the examination, and hence they may be enlarged on bail. Per contra, the counsel appearing for the state would submit that the report was sent to, and the report is obtained from the concerned department and found only 7 candidates have placed the fake documents. And case and complaint was given, and police inspector also obtained the report from the Karnataka SSLC board, where report dated 27/5/22 confirmed that those marks cards are fake documents, and hence there is a prima facie case, and against, and hence the very presence of these petitioners are necessary to probe the matter and unearth the crime, and hence not entitled for bail. Having heard the respective counsel and also on perusal of material, specific allegations are made against these petitioners who have been arraigned as accused number 2 to 7, that they have indulged in fabrication of document and made use of the fabricated document to get an employment in the government department. The material also discloses that they have been selected, but while verifying the documents comes to know that documents are fake documents, and complaint was given. Even the inspector also obtained the report from the concerned board that those documents are fake documents. When such serious allegations are made that the petitioners are indulged in creation of document and also made use of those documents for getting an employment and played the fraud at the inception of applying for the post of D group in the government department, and when the prima facie material discloses indulging in such an act, it is not a fit case to exercise the powers of 438 of CRPC, and the presence of the petitioners is required to investigate the matter and unearth the crime with regard to the fabrication of document and making and using of the same for getting an employment. In view of the discussions made above, I pass the following order. Bail petition is rejected. Now he is A1. A2 mother already enlarged. What is the allegation against this petitioner? Now charge sheet agide. What is the material relying upon subjecting her for cruelty as well as taking extreme step of committing suicide? ಕಂಬಿಗೆ ಸೀರೆಯನ್ನು ಕಟ್ಟಿಕೊಂಡು ಕುತ್ತಿಗೆಗೆ ನೇಣು ಹಾಕಿಕೊಂಡು ಮರಣಿರುವುದು. Whether she has left any death note? No death note. Only statements of witnesses. One Murtappa went along with the complainant and told that they are unable to give any site as demanded by them and advise them to take care of the victim. That is the allegation. ಏನ್ರಿ ಪಂಚಾಯತ್ ದಾರ್ ಏನಾರು ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಗಿದೆಯಾ? ಎಷ್ಟು ದಿವಸದಿಂದ ಇದಾರೆ ಒಳಗಡೆ? 5 months. 13/2. ಮದುವೆ ಆಗಿದ್ದೆ 2017. ಸೈಟ್ ಅನ್ನು ಬರ್ಸಿಕೊಂಡು ಬರುವಂತಾಗಿ ಒತ್ತಾಯಿಸಿ ಮಾಡ್ತಿದ್ರು ಅಂತ. ಏನಿದು ಚಾರ್ಜ್ ಶೀಟ್? ಯಾವ್ದು ಚಾರ್ಜ್ ಶೀಟ್ ಇದು? ಈ ಕೇಸಿಂದನಾ ಹಾಕಿದಿರಲ್ಲ ಚಾರ್ಜ್ ಶೀಟ್, ಬಟ್ ಅಡಿಷನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಹಾಕಿರ್ಲಿಲ್ಲ. ಇದು ಮೆಡಿಕಲ್ ರೆಕಾರ್ಡ್ಸ್ ಈ ಕೊಟ್ಟರೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅಲ್ಲ? ಹಾ ಹೇಳಿ ಏನು? ಹಾ ECG dated 9/12/21. ಆಕೆ ಸತ್ತಿರೋದು ಯಾವಾಗ? ಏನ್ರಿ ಏನೋ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗಿದೆ, ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ, ಏನು? ವಾಟ್ ಇಸ್ ದ ಮೆಟೀರಿಯಲ್? ಕನೆಕ್ಟ್ ಪಂಚಾಯತ್ ಅವ್ರು ಮಾತ್ರ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹೇಳಿದ್ದಾರೆ. ಯಾರ ಮೂರ್ತಪ್ಪ ಅಂತ ಯಾರೋ ಒಬ್ಬ. ಇದೇ ಮ್ಯಾಟರ್ ಆಫ್ ಟ್ರಯಲ್. Not the petitioner counsel and also the counsel appearing to the state. The factual matters of the case of the prosecution is that this petitioner marriage was solemnized with the victim in 2017. In the said wedlock, victim gave birth to 2 children. And the allegation against the petitioner and the mother-in-law is that they were insisting to get the site as agreed at the time of the marriage, and continued both mental and physical harassment, and hence he took the extreme step of committing suicide by hanging herself on 13/2/22. Based on the complaint, police have registered the case and investigated the matter and filed the charge sheet and invoked the offence punishment of section 304B and also section 498A and section 3 and 4 of Dowry Prohibition Act. The counsel appearing for the petitioner submits that the prosecution mainly contend that marriage was solemnized in 2017 and question of insisting to get site in 2022 doesn't arise. The counsel also would submit that the prosecution mainly relies upon the statement of Panchayat Dars. The same has to be tested in trial. An investigation has already been completed and that charge sheet also filed. The counsel also would submit that this petitioner is in custody from 13/2/22, almost from 5 months, and hence no need of further custodial trial, and hence he may be enlarged on bail. For contrary, the counsel appealed to the state would submit that though marriage was solemnized in 2017, and she was subjected to harassment by this petitioner as well as the mother-in-law, who has been arraigned as accused number 2. It is also the case of prosecution that 6 lakhs was spent at the time of marriage, and harassing continuously both mentally and physically. And hence 4 to 5 months back took the CW4 to the house of accused and gave an amount of rupees 1 lakh and expressed that they are unable to provide any site and requested to look after her very well. But in spite of it, the same is continued. And hence it took extreme step of committing suicide. Having heard the respective counsel and also a perusal of material available on record, an allegation is made that marriage was solemnized in 2017 and death was taken place in 2022. And also allegation that they were insisting to get the site. The investigation has been completed and charge sheet is also filed. Whether whether the petitioner has subjected for harassment both mentally and physically along with accused number 2 is a matter of trial. So no need of further custodial trial. And hence it is a big case to exercise the powers of 439 of CRPC. The counsel appearing to the petitioner also relied upon the medical documents just prior to the taking of extreme step committing suicide. In the month of December also she was taken to hospital and she was not getting the sleep. And those documents can be relied upon before the trial court for defense. In view of the discussion made above, ask the following order. Bail petition is allowed with conditions. 41 Rajashekar Raghavendra K NOC. ಯಾರು ನೀವ್ಯಾರು? ರಾಜಶೇಖರ್ ಆಲ್ರೆಡಿ ಇವರು ವಕಾಲತ್ ಹಾಕಿದಾರಲ್ಲ ತಗೊಳ್ಳಿ. Memo filed for retirement by counsel Rajashekar is accepted since the counsel Sri Raghavendra already filed NOC. ಹೇಳಿ. No, why? ಫಸ್ಟ್ ಟೈಮ್ ಆದ್ರೇನ್ರಿ? ಬೇರೆ ಕಾರ್ಲಿ ಇಟ್ಬಿಟ್ಟವ್ರ? ಬೇರೆ ಕಾರ್ಲಿ ಇಟ್ಟು ಮೈಸೂರಿಗೆ ತಗೋಬಿಟ್ರ? Ninth, petitioner counsel seeks time on the ground that file was misplaced. ಆಯ್ತು, list this matter on 18th ಆಗ್ಬೋದಾ? 19th ಬೇಕಾ? ಆಯ್ತು 19th. Prakash M. 4 and 6 376. Medical evidence ಏನಿದೆ ರೀ? Medical evidence. What is her age? 14 years. 2007. 9th standard. ಏನಾಯ್ತು ಹೇಳಿ. ಏನ್ ಮೆಡಿಕಲ್ ಎವಿಡೆನ್ಸ್ ಇದೆಯಾ? ಏನು ಮೆಡಿಕಲ್ ಎವಿಡೆನ್ಸ್ ಇದೆ? ಐಮನ್, ವಾಟ್ ಈಸ್ ಅವರ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇನ್ 164? ಯಾರು ಇಲ್ಲದ ಸಮಯದಲ್ಲಿ ಆರೋಪಿ ನೊಂದ ಬಾಲಕಿಯನ್ನು ಲಿಂಗರಾಜಪುರದ ರಾವಪುತ್ರ ಮನೆಗೆ ಕರೆದುಕೊಂಡು ಹೋಗಿ ಸಾಕಿ 2 ರವರು ಬೇಡ ಅಂದ್ರೆ ಇಚ್ಛೆ ವಿರುದ್ಧವಾಗಿ ಹಲವಾರು ಸಂಭೋಗ ಮಾಡಿರುತ್ತಾರೆ. ಅಪಹರಿಸಿಕೊಂಡು ಆರೋಪಿತನ ಲಿಂಗರಾಜಪುರ ಮನೆಗೆ ಹೋಗಿ ಮನೆಯಲ್ಲಿ ಲವ್ ಅಫೇರ್ ಏನ್ರಿ? 11-14 ವರ್ಷ ಅವಳಿಗೆ. ಎಷ್ಟು? 14 ವರ್ಷ. 9th ಸ್ಟ್ಯಾಂಡರ್ಡ್. ಮತ್ತೆ ಪಿಟಿಷನರ್ 19 years. ಆಯ್ತು, ಒಂದ್ ಮೇಜರ್. ಮದುವೆ ಮಾತ್ರ 21 ಬೇಕು. 4/11/21. ಆಯ್ತ್ರಿ, ಅವಳಿಗೆ ಏಜ್ ಅಬೌಟ್ 14 years. ತೋಳಿ ಏನಿಲ್ಲ, ಟ್ರಯಲ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಟ್ರಯಲ್ ಅಲ್ಲಿ ಮಾಡ್ಕೊಂಡು ಆಮೇಲೆ ಮದುವೆ ಮಾಡ್ಕೋತೀರಾ, ಏನ್ ಮಾಡ್ಕೋತೀರಾ ಮಾಡ್ಕೊಳ್ಳಿ. ಟ್ರಯಲ್ ಗೊತ್ತಲ್ಲ ಏನ್ ಮಾಡ್ತೀರಿ, ಹೆಂಗ್ ಮಾಡ್ಬೇಕು. ಲಿಬರ್ಟಿ ಫ್ರೆಶ್ ಮೇಲ್ ಪಿಟಿಷನ್ ಹಾಕೋತೀರಾ? ಮತ್ ಹಾಕಿದ್ಲ್ವಾ? ಹಾಕ್ತಲ್ಲಿ ಇಲ್ಲಿಗೆ ಹೆಂಗ್ ಬಂದ್ರಿ? 439 ಅಲ್ಲನ್ರಿ? ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹೋಗೇ ಅಲ್ವಾ ನೀವು? ಬಿಫೋರ್ ಚಾರ್ಜ್ ಶೀಟ್, ಆಮೇಲೆ ಹೋಗಿಲ್ಲ. ಈಗ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆಯಲ್ಲ ಇಲ್ಲಿ. ಆಯ್ತು, petitioner counsel, heard the petitioner counsel and also the counsel appearing for the state. When this court about to dictate the orders at this juncture, the counsel submits that charge sheet is filed and after the charge sheet not approach the trial court and hence permitted to may be permitted to withdraw with liberty to approach the trial court. Hauda? Permitted to withdraw with liberty. ಹೇಳ್ರಿ 376 406 420 504 506 ಹೇಳಿ ವೆಂಕಟೇಶ್ ಪ್ರಸಾದ್ ಫಾರ್ ಕಂಪ್ಲೇಂಟ್ ಇದಾರ ವೀರಾ ಹೋಗಿ ಏನ್ರಿ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದಾರ ಎಲ್ಲಿದೆ ಚಾರ್ಜ್ ಶೀಟ್ ಪೇಜ್ ನಂಬರ್ Letter of 14 years. ಏನು ಎವಿಡೆನ್ಸ್ ಎಲ್ಲ ಆದಂಗಿದ್ರೆ 164 ಸ್ಟೇಟ್ಮೆಂಟ್ is in custody from 17/5. ಚಾರ್ಜ್ ಶೀಟ್ ಕಾಲಮ್ ನಂಬರ್ 17 ಎಲ್ಲಿದೆ ಇದೇನಿದೆ ವಾಟ್ಸ್ಆಪ್ ಚಾಟ್ ಅವ್ರಿಗೆ ಕಾಪಿ ಕೊಟ್ರ ಅದರ್ ಸೈಡ್ಗೆ ಪೇಜ್ 10 7 4 oh this is all till you officially get married ಅಂತ ಹೌದಾ
Last year I told
Case 22. Hmm. 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 Page 27. Ah. You are marrying. Hmm. 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 Page 27. Hmm. Hmm. ಹ್ಮ್ ಏನ್ರಿ ಇದೆಲ್ಲ ನೋಡುವಾಗ ಮ್ಯಾರೇಜ್ ಏನ್ ಬರ್ತದ? ಹ್ಮ್ ಆಯ್ತ್ರಿ, ಬಟ್ ಇದೆಲ್ಲ ಏನ್ ಡಿಸ್ಕಷನ್? ಓನ್ಲಿ ಕಂಟಿನ್ಯೂಯಿಂಗ್ ಅ ಫಿಸಿಕಲ್ ರಿಲೇಶನ್ಶಿಪ್ ಬಿಟ್ವೀನ್ ದೆಮ್, ದಟ್ಸ್ ಆಲ್. ಹ್ಮ್ ನೋಡ್ರಿ, ದಿಸ್ ಇಸ್ ಆಲ್ ಟಿಲ್ ಯು ಅಫಿಷಿಯಲಿ ಗೆಟ್ ಮ್ಯಾರಿಡ್ ಅಂತ ಹೇಳ್ತಾರೆ. ವಿತ್ ರಿಗಾರ್ಡ್ ಟು ದಿ ಫಿಸಿಕಲ್ ರಿಲೇಶನ್ಶಿಪ್ ಇಸ್ ಕನ್ಸರ್ನ್. ವಾಟ್ ಈಸ್ ಮೆಂಟ್ ಬೈ ಇಟ್? ಅದೆಲ್ಲ ದುಡ್ಡಿನ ವ್ಯವಹಾರ ಆಮೇಲೆ ಬೇರೆ ಮಾಡ್ಕೊಳ್ಳಿ. ಅದು 376 ಕಲರ್ ಏನ್ ಕೊಡೋದು? ಯು ಸಿ further discussion also in the WhatsApp message. Continue speaking to your future wife. Everything she is having knowledge. You are appearing for complainant. Whatever it may be. But this short or prior to the complaint, is it not? Complaint have kotradu. Complaint is dated 16/5. 16/5. ಈ ಚಾರ್ಟ್ ಯಾವಾಗ ಆಗಿರೋದು? ಮಾರ್ಚ್ ಏಪ್ರಿಲ್ ಅಲ್ಲ. Even before giving complaint also, it is clear that they are having only the how it attracts section 376. Promise ಎಲ್ಲಿ ಬರ್ತದ್ರಿ? He is aware of all this. And also subsequently says, I expected this behavior once you engaged officially or after the marriage. These are the messages exchanged between both of them. How it attracts section 376. Third. Or the petitioner counsel and also the counsel appearing for the state. ಚಾರ್ಜ್ ಶೀಟ್ ಫೈನಲ್ ಎಲ್ಲಿದೆ? ಯಾವ ಪೇಜ್ ಅಲ್ಲಿ ಇದೆ? ಈಗ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಹಾಕಿ ಕಾಲಮ್ ನಂಬರ್ 17 ಎಲ್ಲಿದೆ? ಪೇಜ್ 4 ಚಾರ್ಜ್ ಶೀಟ್ ಈಗ ಹಾಕಿದಿರಲ್ಲ, ಅದು FIR ಇದೆ, ಚಾರ್ಜ್ ಶೀಟ್ ಇದೆ ಅದರಲ್ಲಿ. ನೋಡಿ ಮೇಡಮ್. Heard the petitioner counsel and also the counsel appearing for the state. The factual matters of the case of the prosecution is that the complainant in the complaint made an allegation against this petitioner that he made false promise of marriage and subjected her for both physical and mental harassment and also subjected for sexual act and also life threatening and also received an amount of rupees 4 lakh from her and cheated the complainant. And he said the amount is her alimony amount. ಏನ್ರಿ ನೀವು 4 ಲಕ್ಷ ಇಸ್ಕೊಂಡು ಮತ್ತೆ ದುಡ್ಡು ಕೊಡೋದಲ್ಲ ಯಾವಾಗ ಮತ್ತೆ 91 rupees 4 lakhs on 19/4/21, which was my alimony amount that I gave him, which he promised to return within a 3 months of time, but did not return the money as promised. After requesting a lot to have give back only 1 lakh on 2/4/22, which he transferred to me online to my Indian bank account. ಮತ್ತೆ ರಿಮೈನಿಂಗ್ ಆಯ್ತು, ಅದನ್ನ ಅವರೇ ಅಡ್ಮಿಟ್ ಮಾಡಿದ್ದಾರೆ. ನೋಡಿ ಏನಾಯ್ತು ಮೇಡಮ್. paid the same sum out of her alimony amount, and out of that only he returned an amount of rupees 1 lakh on 2/4/22, and remaining amount has not been paid. Based on the complaint, police registered the case and investigated the matter and filed a charge sheet, wherein an allegation is made against this petitioner that he not only subjected her for sexual act and also committed an offense of criminal breach of trust and fraud, and also caused life threat and abused in a filthy language. The counsel appearing to the petitioner also placed charge sheet materials before the court and contend that the complainant is a divorcee having 14-year-old child, and though alleged that there was a promise, no such promise of marriage, and frequently meeting each other and not dispute the fact that an amount of rupees 4 lakh was received, and however, counsel submits that the amount was returned by cash 3 lakhs and 1 lakh was paid by way of check, and even ready to pay the amount of rupees balance amount of rupees 3 lakhs. The counsel also would submit that there was no any promise of marriage, and counsel in support of his argument, he relied upon the WhatsApp chat between the complainant and this petitioner, and particularly he brought to notice of this court the chat dated 23/3/22, wherein the complainant herself has chatted with the complainant that this is all till the petitioner officially get married, and also brought to notice of this court the other conversation between other WhatsApp chat between the complainant and petitioner dated 7/4/22, saying that continues speaking to the petitioner future wife. The counsel also brought to notice of this court the other chat dated 9/4/22, and replying that he has forced the petitioner to love her, and also saying that her old Shiva is gone somewhere. The counsel also brought to notice of this court dated 12/4/22, referring the girl which the petitioner is intent to marry her. And further chart dated 14/4/22 that he expected this behavior once the petitioner engaged officially or after marriage. The counsel referring these charts would contend that there was no any promise as alleged in the complaint. The complainant was aware of the fact that the relationship has been continued. And also the complainant was aware of the fact that he is going to marry a other girl and discussed with regard to the marriage also. When such being the case, not a case for invoking section 376 with a promise to marry. Hence, he may be enlarged on bail. For contra, the counsel appearing for the state which submits that the complaint government is very specific that with the promise to marry, the petitioner subjected her for sexual act. Apart from that, amount was also collected to the tune of rupees 4 lakhs. And counsel appearing for the complainant who assisted the HCGP also brought to and also through HCGP brought to notice of the court that there was a continued sexual act by the petitioner along with the complainant. And hence there is a prima facie case against the petitioner herein and hence is not entitled for bail. Having heard the respective counsel and also on perusal of material, based on the complaint, case has been registered, invoking an offence punishable from 376, 406, 420, 104, 506 of IPC. And also the police have investigated the matter and filed the charge sheet. The counsel appearing for the petitioner also placed the charts of the WhatsApp chart between the complainant and the petitioner herein. And taking into note of the WhatsApp chart referred above, and also considering the material on record, and when the investigation has been completed and charge sheet is filed, and accusation has to be proved during the course of trial, and in keeping the WhatsApp chart between complainant and petitioner, and the said allegation made in the complaint as well as in the charge sheet has to be proved during the course of trial, and hence no need of further custodial trial of the petitioner, and hence it is a fit case to exercise the powers of 439 of CRPC with conditions. So, in view of the discussions made by Pasti Parangoda, bail petition is allowed with conditions. Lasting on the condition, the petitioner is directed to refund the amount of rupees 3 lakhs forthwith within 1 week from today. ಅಕೌಂಟ್ ಹಾಕಿ ಅವ್ರ ಅಕೌಂಟ್ ನಂಬರ್ ಇದೆಯಲ್ಲ, ನೀವು ಹಿಂದೆನ ಹಾಕಿದ್ರಲ್ಲ ದುಡ್ಡು, ಮತ್ತೆ ಅದಕ್ಕೆ ಹಾಕಿ ಇನ್ನೊಂದು 4 ತಿಂಗಳು ಇನ್ನೊಂದು 5 ವರ್ಷ ಅಲಿಯೋದು ಬೇಡ. ಫಸ್ಟ್ ಯು ಮೇಕ್ ದಿ ಪೇಮೆಂಟ್, ವಾಟ್ ಎವರ್ ದಿ ಅಮೌಂಟ್ ಯು ಹ್ಯಾವ್ ರಿಸೀವ್ಡ್, ಯು ಪೇ ಬ್ಯಾಕ್ ದಿ ಅಮೌಂಟ್ ಇಮಿಡಿಯೇಟ್ಲಿ. $406, $409, $420. There are 30 accused. 1522 arrest. Right. That is returned. Right. Only against this petitioner allegation is only 62 lakh. The son's account. But any other
That was also freeze.
A5. What is the amount? What is the amount?
So that is about
39 lakh. Adu repaid.
13 lakhs.
13 lakh. That is also paid.
30 lakhs is all freeze.
30.
And the price, that's about another small amount was
Also paid. Already freezed.
Yes, we got here. Because working as a district manager of the here American most to be sanctioned a lot by 2007, 8 and 9. From head of this operate after we are American. December 29, 26 and 29, 27, 28 and 29. They have transferred the amount, but the beneficiaries are district level also. At that time, the amount is different amount. Now the only allegation is the beneficiaries are not Indian. That is the matter.
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆಯಾ? Still under investigation. Who is absconding? So the amount which is transferred to his account has been transferred. Seeking permission from your authority to deposit a sum of 62,26,365 deposited, misdeposited to current account.
They are not arrested
MBA. ಅಲ್ರಿ ಅಂಬೇಡ್ಕರ್ ಅಭಿವೃದ್ಧಿ ನಿಗಮ ಉದ್ಧಾರ ಮಾಡಿ ಅಂತಂದ್ರೆ ಇವನು ತಾನೇ ಉದ್ಧಾರ ಮಾಡಕ್ ಹೋಗಿದ್ದಾನಲ್ರಿ. ಅದು 1-2 ರೂಪಾಯಿ ಅಲ್ಲ, ಲ್ಯಾಕ್ಸ್ ಟುಗೆದರ್, ಕ್ರೋರ್ಸ್ ಟುಗೆದರ್. A2 ಆಯ್ತು ಆಯ್ತು. ಸೂಪರಿಂಟೆಂಡೆಂಟ್ ಗಿಂತ ಇವನ್ ಹೈಯರ್ ಪೋಸ್ಟ್ ಆಯ್ತ್ರಿ. ಇವನು ಈಸ್ ದಿ ಇದು ಹೈಯರ್ ಪೋಸ್ಟ್, ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಮ್ಯಾನೇಜರ್ ಆಯ್ತು. ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಮ್ಯಾನೇಜರ್ ಈಗ ಅಕ್ಯೂಸ್ ಅದಕ್ಕೇನೆ A1 ರಿಂದ A30 ಮಾಡಿರೋದು ಅಲ್ವಾ? ಅದೇ ಹೇಳಿದ್, ಇವೆಲ್ಲ ಕಾರ್ಪೊರೇಷನ್ಸ್ ಎಲ್ಲ ಮಾಡೋದೆಲ್ಲ ಜನರು ಉದ್ಧಾರ ಮಾಡಿ ಅಂತ, ಇವ್ರು ಉದ್ಧಾರ ಮಾಡೋದೆಲ್ಲ ಈ ತರದವು. ಆಯ್ತು, ಡಿಟೆಕ್ಟ್ ಆಗೋ ಹೊತ್ತಿಗೆ ಆಯ್ತು. ಡಿಟೆಕ್ಟ್ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅದೇ ಗೊತ್ತಾಗೋ ಹೊತ್ತಿಗೆ ಫ್ರೀಸ್ ಆಯ್ತ್ರಿ. ಇಲ್ಲಾಂದ್ರೆ ಅದನ್ನು ನುಂಗ್ಬಿಟ್ಟಿರೋದು. ಏಟು ಸುಸೈಡ್ ಹೌದಾ? ಫ್ಯಾಮಿಲಿ ಈ ವಿಚಾರ ಗೊತ್ತಾದ್ಮೇಲೆ ಮತ್ತೆ ಗೊತ್ತಾಕ್ಕಿಂತ ಮುಂಚೆ ಸುಸೈಡ್ ಆಗಿದ್ಯಾ? ಅಲ್ಲ, ಈ ಕೇಸ್ ಆಗೋಕ್ಕಿಂತ ಮುಂಚೆನೆ ಸುಸೈಡ್ ಆಗಿದ್ಯಾ? ಮತ್ತೆ ಅದು ಆಕೆ ಸತ್ತಿದ್ದೆ ಅವಾಗ ಮತ್ತೆ. ಈಗ ನನ್ ಪ್ರಕಾರ ಅವಳ ಸಾವಿಗೂ ನೀವೇ ಕಾರಣ ಮತ್ತೆ. ಹೌದಲ್ವ ಮತ್ತೆ? after the comment, after the law set into motion, ಅದೇ ಹೇಳ್ತಾ ಇರೋದ್ರಿ. This district manager prevailed upon the accused number 2 to issue the checks. Issue the checks.
But accused number 26,
27 to 29 are the sanctioning authority.
They sanctioned the amount to 1,000 September. Amount has not been stayed. But accused number 2 was the superintendent. Accused number 27, he has brought a separate document. Alert for opening of accounts not as beneficiary. If you beneficiary is not accounts of open. Account was there last for different way. And the accused number 27 is not is other 26 arrested. Account is cleared out. This is also arrested.
ಇವ್ರ ಕಡೆಯಿಂದ ಎಷ್ಟು ದುಡ್ಡು ಆಗಿದೆ ರೀ? ಡೈರೆಕ್ಟ್ ದುಡ್ಡು ಯಾರ್ಯಾರಿಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿದೆ? ಮಗನಿಗೆ 62 ಲಕ್ಷ, ಆಮೇಲೆ 30 lakhs, ಆಮೇಲೆ 4.20 crore. ಚೆಕ್ಕಿಗೆ 2, that is one A1 and A2. Without the knowledge, how they can sign the checks? Now, now not 3.5 crore, now 4.20 crore. Verify and I thought. Yes. Howdo. Yes. Yes. You're the earlier anticipatory bail rejected. Heard the petitioner counsel and also the counsel appearing for the state. The factual matters of the case of the prosecution. Down an allegation.
He has also assisted in our assistant. He is the first assistant to the office. They are all done. Yes. Just granted.
Put it then that place.
He hooked up the record.
He
hooked up the entire record.
In the office. In the office. Heard the petitioner counsel and also the counsel appearing for the state. The case of the prosecution that this petitioner is working as a district manager in the Dr. B.R. Ambedkar Development Corporation, Tumkur, in Tumkur. And an allegation is that for the period from 2019-20 and 2021, an amount of rupees 4 crores 20 lakhs 23,872 was misappropriated by creating the 22 fictitious beneficiaries accounts. 22 beneficiaries accounts. Live persons, but accounts are fictitious. Non-beneficiaries means that are the fictitious accounts only. Persons may be alive, but accounts are fictitious only. ಅವ್ರಿಗೆ ಹೋಗಿದ್ಯಾ ದುಡ್ಡು? ಆ 22 ಜನಕ್ಕವರೆಗೂ ದುಡ್ಡು ಹೋಗಿದ್ಯಾ? ಅವರೆಲ್ಲ ಅಂದ್ರೆ ಇವ್ರ ಕಡೆ ಅವ್ರೆ ಅಂತ ಅಲಿಗೇಷನ್ ಏನಾಯ್ತು ಮೇಡಮ್? 4 crore and in releasing the amount it was 22 beneficiaries, and also amount was transferred to the account of this petitioner's son to the tune of 62 lakhs, and also an amount of rupees 30 lakhs. Other accused number 5, who is the friend of this petitioner, and also and in all the petitioner indulged in committing the offense of misappropriation of the amount and fraud. And in total, how many accused are arrived? Total 30 accused persons are arrived in the crime, and matter is under investigation. The counsel appearing for the petitioner would submit that this petitioner already repaid the amount of rupees 62 lakh which was paid in favor of his son, and also an amount of rupees 30 lakhs which was paid in favor of accused number 5. And totally out of 4 crore 20 lakhs, 23,872, almost 3.5 crore amount was repaid and also freezed. And when searching the case, no need of continuing him in further continuing in custody for further investigation. The counsel also would submit that on 1/5/2022, this petitioner was arrested and he was also taken to custody, and now no need of further custody for investigation, and hence he may be enlarged on bail. For contra, the counsel appearing for the state would submit that earlier this petitioner approached the court by filing criminal petition invoking section 438 of CRPC, and the same was rejected. And now the amount was repaid to the tune of 62 lakhs and 30 lakhs, which was transferred in the name in favor of his son and also his friend. And the same prima facie discloses that this petitioner had indulged in committing the offense of criminal breach of trust, and apart from that, played the fraud on the institution in which he is working as district manager. The counsel also would submit that subsequent to the registration of the case, accused number 2, who is also the joint signatory to the checks along with this petitioner, also committed the suicide, and hence there is a prima facie case, and in order to unearth the crime and also remaining amount of rupees more than 70 lakhs, the presence of the petitioner is required, and investigation is not yet over, and no case is made out to grant the bail. In reply to the arguments of the counsel appearing for the state, the counsel would submit that this court already granted bail in favor of accused number 4 in criminal petition number 8883 of 2021. Right. And he is also working in the very same department, and he used to put up the files in the office and placed the order passed by this court in criminal petition number 8883 of 21. The counsel appearing for the state also would submit that the said petitioner is only an outsourced employee and not a permanent employee, and he was working under the instructions of this petitioner. The counsel appearing for the petitioner also submits that the rest of the amount is in connection with accused number 27 to 29 and not in respect of this petitioner, and nothing to be recovered at the instance of this petitioner. And also counsel would submit that offense is also triable by the magistrate. Having heard the respective counsel and also on perusal of material, specific allegation made against the petitioner and other accused persons that they were misused their official position, misappropriated the amount to the tune of rupees 4,20,23,872 to various beneficiaries without following the procedure. The first contention of the petitioner counsel that other petitioner has already been enlarged on bail, that is accused number 4 in criminal petition number 8883 of 21, is that the allegation against the petitioner that he is an outsourcing employee and his role is limited to only entering the names of the persons and beneficiaries in the account, and he has no authority to question or disperse the amount, and hence the bail is granted in favor of accused number 4, who is an outsourced employee. The accused is this petitioner who is working as district manager in the board, and apart from that, he is also a joint signatory to the check with regard to the dispersal of the amount, and also 22 beneficiaries got the benefit in the said transaction. And when the crores of rupees are misused and misappropriated by the petitioner as well as other accused persons, ಆಮೇಲೆ ಬನ್ನಿ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕೊಂಡ್ಮೇಲೆ ಬನ್ನಿ ನೋಡಿ. ಈಗ ನಾನು ಡಿಕ್ಟೇಷನ್ ಮಾಡಕ್ಕಿಂತ ಮುಂಚೆ ನೀವು ಹೇಳಿದ್ರೆ ಮಾಡ್ತಾ ಇದ್ದೆ. ನಾನು ಆಲ್ರೆಡಿ ಆಲ್ಮೋಸ್ಟ್ ಕಂಪ್ಲೀಟೆಡ್. ಆಮೇಲೆ ನೋಡ್ಬೋದು. ವ್ಯಾಪಾರ ಈಗ ನಾನು ಮಿಡ್ಲ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. Joint signatory to the dispersal of the checks along with accused number 2, and the fact that accused number 2 is also committed suicide after the last settling to motion. And when such being the material available on record, and particularly the amount was transferred in the name of his son as well as his friend, almost to the tune of 1 crore, that is 62 lakhs plus 30 lakhs. When such allegations are made, it is not a fit case to exercise the discretion when the investigation is not yet completed, and hence it is not a fit case to exercise the discretion during the crime stage. In view of the discussion made up, I pass the following order. Bail petition is rejected. However, liberty is given to approach the court after filing of the charge sheet. 45. Oh, time aita.
May make one submission, my lord. Serial number 58, my lord, day after tomorrow, my lord. Serial number 58.
58.
Yes.
We want time?
I'm on leg before Honorable Supreme Court for another matter, my lord.
Petitioner counsel seeks time, list this matter on 18.
Much obliged.
Any other submission? 68. What happened? Only 2 weeks. Mostly roster will change after 22nd. 20th. Other report made. No, not running. If possible, you can conclude it, or otherwise next roster, the judge who comes, you can settle it and report it. What do you want now? Before 22nd, or how much time it will take for today? I will give one date, 20th. If it is settled, it's well and good, or otherwise, don't. 68. Other side either both sides are present, and counsel submits that mediation is going on, and hence list this matter on 20th. Already we have instructed. Already instructed. The same oral, that is oral. That is oral. No such order is passed by this court. Oral instructions are given. Don't precipitate the matter. ಏನೋ ಗಂಡ ಹೆಂಡತಿ ಒಂದಾಗ್ತಾರೆ ಅಂದ್ರೆ you also support them. 45 ಹೇಳಿ ಏನಾದ್ರು. ಇದೇನ್ರಿ ಈಗೆಲ್ಲ ಆರ್ಡರ್ ಶೀಟ್ ಅಂತೆಲ್ಲ ಈಗ ಎಲ್ಲಿವರೆಗೂ ಆಯ್ತು ಮೇಡಮ್? 44 ಆಯ್ತು, 45 ಹೇಳಿ. ಲಾಸ್ಟ್ ಟೈಮ್ ಏನೋ ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡ್ತೀವಿ ಅಂತೇನೋ ನೀವು ಟೈಮ್ ತಗೊಂಡಿದ್ರಿ. ಮತ್ತೆ ಹೌದ್ರಿ, ಆರ್ಡರ್ ಶೀಟ್ ಪ್ಲೇಸ್ ಮಾಡಿ ಅಂತಾನೆ ಕಳಸರಿ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಏನ್ ಟೈಮ್ ಬೇಕಾ? ಟೈಮ್ ಬೇಕಾ ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಕ್ಕೆ? ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡ್ರಿ ಮೇಡಮ್. ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟರ್ ಇದೆಯಲ್ಲ ಕೊಡಿ, ಏನಿದೆ ನೋಡೋಣ. ಆರ್ಡರ್ ಶೀಟ್ ಅನ್ನು ನಾನು ಬರ್ಕೊಂಡಿದ್ದೀನಿ ನೋಟ್ಸ್ ಅಲ್ಲಿ ಅದಕ್ಕೆ. ನಾನು ಕಾಸ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಬರ್ಕೊಂಡಿದ್ದೀನಿ. ಹೌದು, ಪ್ಲೇಸ್ ಇದೆಯಲ್ರಿ. ದಿ ಪಿಟಿಷನ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದ ಪಿಟಿಷನರ್ ಇಸ್ ಡೈರೆಕ್ಟೆಡ್ ಟು ಪ್ಲೇಸ್ ದಿ ಕಾಪಿ ಆಫ್ ದಿ ಆರ್ಡರ್ ಶೀಟ್ ಅಂತ ಹಾಕಿದ್ದೀನಿ. ಸಿಗ್ತಾ ಇಲ್ಲ ಅಂದ್ರೆ ತಗೊಳ್ಳಿ, ಹಾಕಿ. ಇನ್ನೂ ಒಂದು ವಾರ ಟೈಮ್ ಕೊಡ್ತೀನಿ. ಆಗ್ಬೋದಾ? Petitioner counsel seeks time to place the order sheet. List this matter on 18th. 18th. That's all. Twenty-six. Next matter ಹೇಳಿ. ಅದರಲ್ಲೂ ಕೂಡ ನೋಡಿ ಪ್ಲೇಸ್ ಟೈಮ್ ಅಂತಿದೆ. Let him be there. You argue ಸಾಕು. ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ರೆ ಸಾಕು. ನಮ್ಮ ಕೋರ್ಟಲ್ಲಿ ಏನು ಸೀನಿಯರ್ ಬೇಕು ಅಂತೇನಿಲ್ಲ. You assist the court, that's all. Go through and make the submission.
Time ಇದೆಲ್ಲ. ಆಮೇಲೆ
ಸಿಗಂತ ಹಾಕಿದಂಗೆ Court officer. Court officer. Court officer. Court officer.
Submit that. Advocate on record, Mr. K. Jayaprakash is not in a position to attend court. Legal of his indent. Nancy could not appear before report. And this court appointed amicus curiae. Submit that. Advocate on record, Mr. K. Jayaprakash is not in a position to attend court. Legal of his indent. Nancy could not appear before report. And this court appointed amicus curiae.
ಎಲ್ಲಿ
Court officer. Please sorry. Thank you. Court officer. Court officer.
Hey, sorry to disturb you. Dad asked me to come to Taj. Can we meeting somebody here? So we thought we'll log in.
Court officer. Court officer. Court officer. Court officer. Court officer. Court all the video ಕಾಣಿಸ್ತಿಲ್ವಲ್ಲ?
ಹೇಳಿ
Court all
ಹೇಳಿ.
video, court all video ಕಾಣಿಸ್ತಿಲ್ಲ ಅಂದೆ.
ಹಾ ಕಾಣಿಸ್ತಾ ಇಲ್ವಾ? ಕಾಣಿಸ್ತಾ ಇದೆ.
ಸಾಹೇಬ್ರದಲ್ಲ ಮೇಡಮ್, ನಮ್ಮ ಅಡ್ವೊಕೇಟ್ಸ್ ನಿಲ್ತೀವಲ್ವಾ?
ಸರ್ ನಾನು ಕೋರ್ಟ್ ಹಾಲ್ ವಿಡಿಯೋನ ಮ್ಯೂಟ್ ಮಾಡಿಲ್ಲ ಸರ್, ಅದು ಅನ್ಮ್ಯೂಟ್ ಇದೆ.
ಅಲ್ಲ, ಸಾಹೇಬ್ರದ್ದು ಕಾಣಿಸ್ತಿದೆ, ಕೋರ್ಟ್ ರೂಮ್ದು ಕಾಣ್ತಿಲ್ಲ. ನಾವು ಅಡ್ವೊಕೇಟ್ಸ್ ನಿಲ್ಲೋದು.
भाई तू बेस्ट केक लाया।
Yes, Mamdapur.
Yes, no, that to appear for the petitioner. Before that, Lords, I have filed an impleading application under 301 subsection 2 of CRPC to assist the de facto complainant, Lords, in this case.
When did you file that application?
Lords, on 4/7/2022, Lords.
4/7/22.
Yes, Lords.
Madam. So the counsel Sri Lagli submits that he has filed. Is he respondent for arrest, Lagli for complainant? Second.
Oh, yes.
Assist prosecution, that is copy to be served to the petitioner counsel. Have you served the copy on the petitioner counsel?
Yes, Lords.
No. Two affidavits are filed. The same may be clarified, and then some office objections in the notice.
That is, Lords, that we have filed one to assist the court, assist the prosecutor.
Assist the prosecution. Have you served the copy on the other side?
I'll serve, Lords. I'll serve it.
Serve the copy.
Yes, I'll serve it.
For hearing your application, you have to serve the copy on the other side.
Yes, Lord, I'll serve it, Lords. I'll serve.
Counsel Sri R.S. Lagli seeks time to serve the copy of IA filed to assist the prosecution. Now, how many days you require?
First 2-3 days, my lords. Friday it may be taken up.
Within 2-3 days. And hence, if acknowledgement is produced for having served the copy, is this matter on Monday? Monday?
Yes, ma'am.
Monday. The counsel appealing for the petitioner counsel also present. HCGP, you are representing. HCGP is also present. This matter on the 18th.
Please. Grateful, master.
ಇನ್ನೊಂದು ಯಾವ್ದೋ 231 matter ಇದೆ. Prasanna Kumar. You can file it. 2-3 days. Report kodi. The counsel Sri Prasanna Kumar, standing counsel appearing for CBI, placed on record. Yenadu report in compliance to the order dated 7/7/22. Whether raid was conducted? What is the result of the inquiry? Whether state government has taken decision? Annexure 5. Annexure 5. Seven and 8. Anything to curb the illegal mining and transportation activities and Ballari district during the period 2009 and 10. However, no investigation was carried out in depth with respect to the involvement of officers of the said departments and needs to be looked into by the government of Karnataka. Whether in view of this letter, any further progress? You found that it requires to be investigated by the state police. Closed or not closed? State government has not taken any decision with regard to. Have you received any information? But fact that the raid was conducted in respect of the residence of the ACB. Yes, so the madam, 1 second.
I also quite a.
Hmm. Hmm.
High integrity and high accuracy that. And then the opportunity also.
Personally, how you can seek personally? Anyhow, you have approached the apex court. Apex court. Hmm.
Then on the last day, I really posted I have not examined this problem. Now the court is also.
Now that order has been challenged before the SLP. Now you cannot raise any such. Without making an application before the court, how you can make submission before the court? Well, how you can make the submission? Whether you have locus standi, counsel, whether you have locus standi without the party, whether you have locus standi. You have not filed any application before the court to come on record. Huh? You have not filed any application. You can file it. We'll consider your application. You file it without you are on counsel, your senior counsel, without on the record. You cannot. You have no any locus standi to make any submission before the court.
Or even though I got.
Because he is the helm of affairs, that's why he has not carried out the investigation. That is the reason I made the observation. I have passed an order. Why I summoned the records? Because there was a threat to me. That's why I will pass an order right now itself. I don't know to whom he have contacted. I will make it in writing. I will make it in writing now. There cannot be a threat to the court. I will record what. Then I will record. If you want that, I will record this.
To say that all these things, what happens is everything is becoming viral.
Yes, that is true fact also. I intimated to the concern. I intimated to the concern with regard to the. I intimated to the concern with regard to the threat. It amounts to an independence of judiciary, threat to the independence of judiciary, and intervening in the dispensation of justice. That is nothing but interfering with the dispensation of justice. That I have already intimated to the concern. That I have already intimated. If you want, what are the words are exchanged between me and sitting judge? I will note down the same in my order also. That's what I will make it then. Yes, I will make it in the order itself. I will make it in the order. You file an application, I will consider your application. Without locus standi, how I can entertain you? You file it in the office, not in the portal.
Before I could file the application, now the issue.
I am not issuing any this thing because there is a threat to the court. That's why I summoned the service records as well as the report filed by the ACB. I will consider your application. That's all. No threat to the court. Huh? By sitting judge, that's what I expressed on that day. Why you are again asking me? I have ನೋಡ್ರಿ ಇವೆಲ್ಲ ಬೇಡ ಅಶೋಕ್ ಅವ್ರ ನಾವ್ ಎಲ್ಲಿ ಡಿಸ್ಕ್ಲೋಸ್ ಮಾಡ್ಬೇಕು ನಾನು ಅಲ್ಲಿ ಡಿಸ್ಕ್ಲೋಸ್ ಮಾಡಿದ್ದೀನಿ. ನನ್ನನ್ನು ಇಲ್ಲಿ ತಪ್ಪಿಸಿಕೊಳ್ಳೋ ಕೆಲಸ ನೀವು ಮಾಡಬೇಡಿ, ಗೊತ್ತಾಯ್ತಾ? I know where I have to disclose it. I have already disclosed it. I need not disclose here the name of the judge. Don't try to make me to commit mistake in this court. Don't do all this. You may be. I have already intimated to whom I have to intimate. I have already intimated. That's what.
Now, what I observed that I'm not working to hold the office.
That's why. That is the reason only I called the service records. I called the service records as well as the raid conducted. Raid. That's what you have filed at the SLP. You challenge it before the Supreme Court. Anyhow, matter is pending before the Supreme Court. That's all. I don't know why you are interfering in the proceedings. without any locus standi. Without any locus standi, you are interfering and making submission before the court. Against my order, you have already filed the SLP before this court. You urge those grounds. If Supreme Court says that I'm not able to pass such an order, I will obey with the order. That's all. You have already filed. You have already filed. And also there is a threat to this court through a sitting judge. Is it fair on the part of a sitting judge? Then that's all. If no threat, I would not have gone to the extent of summoning the service records and also the integrity of an ACB. But it is nothing but shaking of independence of the judiciary. You should understand that independence of judiciary and also interfering with the dispensation of justice. Is it true? Is it correct? Then let there be an inquiry. Let there be an inquiry. I have already intimated to the concern that is back to me. That's what I said. I will make it. I will make it right now also. If you want that, because you said that to disclose it. You are saying that I am sitting here. According to you, I think I am making false submission with regard to the threat. Now I will make it on record. If that is the ಮತ್ತೆ ನೀವೇ ಹೇಳ್ತಿರೋದು. ನೀವು ಅಶೋಕ್ ಅರ್ಲಂಡಿ ಅವರೇ, ನೀವು ರೆಕಾರ್ಡಿಗೆ ಬಿಡುದಲೇನೆ ಸಬ್ಮಿಷನ್ ಮಾಡಕ. ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದು ಬಂದಿದ್ರೆ ನೀವು ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರೆ ಯು ಹ್ಯಾವ್ ಲೋಕಸ್ ಸ್ಟ್ಯಾಂಡಿ ಟು ಮೇಕ್ ಸಬ್ಮಿಷನ್ without any material on record. How can you entertain you? Senior counsel, you are making submission without any application. How I can entertain your submission before the court also? Let the office put up the application. Scrutiny ಆಗಬೇಕು, ಬರಬೇಕು ಕೋರ್ಟ್ಗೆ. ಮತ್ತೆ ಅದು ಬರದಲ್ಲ ಹೇಗೆ ನಾನು ಕನ್ಸಿಡರ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ ಅದನ್ನ? How can I consider and how can I? ನಾನೇನ್ ಡಿಸೈಡ್ ಮಾಡಕ್ ಕೊಟ್ಟಿಲ್ವ, ನಾ ಹೇಳ್ದೆ ಅಷ್ಟೇ ಏನಾಗಿದೆ ಅಂತ ಹೇಳ್ದೆ. Because there is a threat to me, that is the reason only. It is nothing but independence of judiciary. You being the senior counsel, you should also protect the independence of the judiciary. But
judges should be threatened. We have never done this program of career. We may not have complete information about what.
That I will clear what had happened. Slowly, madam. You are also the same application. Ashok are also not part of this record. If you file an application, consider unless you are also on record. Cannot unless you comes on record. I cannot pass any orders on oral submission. Oral submission, that too without any locus standi. But new place madak ನೀವು application ಹಾಕೊಂಡು new place. The same answer to the Ashok Arlandi also. Unless ಅದು ನಿಮಗೆ you also no locus standi unless the council appearing to ಹೇಳಿದಲ್ಲ ಮೇಡಮ್. Report in compliance of the order dated 7/7/22 and the same is taken on record. The council appearing for the ACP submits that ಏನ್ರಿ ನಿಮ್ದೇನು SLP memo ಕೊಡಿ, certified memo. Your personal capacity na ಏನು ಫೈಲ್ ಆಗಿರೋದು ಇಲ್ಲ, ನಾನ್ ಕೇಳ್ತಿರೋದು ಅವ್ರಿಗೆ SLP ACB ನಲ್ಲೇ ಫೈಲ್ ಮಾಡಿರೋದ? ACB ನೇ ಫೈಲ್ ಮಾಡಿದೆ. ಆಯ್ತು ತಗೊಳ್ಳಿ. ಏನಾಯ್ತು ಮೇಡಮ್? The counsel appearing for the ACB submits that SLP is filed before the apex court within bracket SLP criminal bracket provisional application number 13963.2022 before the apex court, challenging the order dated 7/7/22. The said petition has been directed to be listed tomorrow before the Supreme Court. Hence prays that this petition may kindly be adjourned. This memo is taken on record. The counsel appearing for the ACB is directed to furnish the copy of memo to the petitioner counsel.
In fact, I was requesting not to have in a later day. Prosecution, if they are not existing, I don't subscribe.
ನಾನು ಯಾವ ಲಾಯರ್ ಮೇಲೆ ರಿಮಾರ್ಕ್ ಮಾಡಿಲ್ಲ. ಕನ್ಸೀಲ್ಡ್ ಅಂದ್ರೆ ಅವ್ರು ನಾನು ಕೇಳಿದ್ದಕ್ಕೆ ಅವ್ರು ಉತ್ತರ ಕೊಟ್ಟಿಲ್ಲ. ಅಶೋಕ್ ಕಾರ್ನಳ್ಳಿ ಅವರೇ, ನಾನು ಕೇಳಿದ್ದೀನಿ, ಅವ್ರು ಅದಕ್ಕೆ ಅಸಿಸ್ಟ್ ಮಾಡಿ ಕೋರ್ಟಿಗೆ ಅಂತ ಹೇಳಿದ್ದೀನಿ. ಅಸಿಸ್ಟ್ ಮಾಡೋದ್ ಬಿಟ್ಟು ಅವ್ರು ಹಿ ಟ್ರೈಡ್ ಟು ಡಿಫೆಂಡ್ ದಿ ಅಕ್ಯೂಸ್ಡ್. ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ? ಕನ್ಸೀಲ್ಡ್ ಅಂತ ಹೇಳಿ ಯಾಕೆ ಹೇಳಿದ್ದೀನಿ? ಕನ್ಸೀಲಿಂಗ್ ಅಂತ ಹೇಳಿದ್ದೀನಿ. ದಟ್ಸ್ ವಾಟ್. ನನಗೇನ್ ನೋಡ್ರಿ, ಐ ಆಲ್ಸೋ ಪ್ರಾಕ್ಟೀಸ್. ನಾನು ಏನ್ ಮೇಲಿಂದ ಹಂಗೆ ಓದ್ರು ಬಂದಿಲ್ಲ. ಐ ನೋ, ಬಟ್ ಹಿ ಶುಡ್ ಹ್ಯಾವ್ ಅಸಿಸ್ಟೆಡ್ ದಿ ಕೋರ್ಟ್. ಆಮೇಲೆ ನೋಡಿ ಅವರೇ ಬಂದ್ರು, ಇಲ್ಲ ನನ್ನ ಕಡೆ ತಪ್ಪಾಗಿದೆ, ನಾನು ಮೇಡ್ ಮೈ ಮೈಂಡ್ ಟು ನಾಟ್ ಟು ಕಂಟಿನ್ಯೂ ACB ಅಂತ ಅವ್ರು ಹೇಳಿದ್ರು. ಐ ಡೋಂಟ್ ನೋ ಹೂ ಹ್ಯಾವ್ ಫೋರ್ಸ್ಡ್ ಹಿಮ್ ಟು ನೌ ಕಂಟಿನ್ಯೂ ಹಿಮ್. ಇಲ್ಲ ಅವರು ರೀಸನ್ಸ್ ಹೇಳಿ, ಸಾರಿ ಕೇಳಿದ್ರು, ಕೇಳಿ ಇಲ್ವಾ ಅಂತ. ನಾವು ಇವಾರ್ ಇದ್ ಮಾಡ್ತಾ ಇದೀರ ಅವ್ರಿಗೆ ಹೇಳಿ. ಹಿ ಮೇಡ್ ಸಬ್ಮಿಷನ್ ಬಿಫೋರ್ ದಿ ಕೋರ್ಟ್ ಇನ್ ಆಲ್ ಪ್ರೆಸೆನ್ಸ್. ಐ ಆಮ್ ಸಾರಿ ಇನ್ನೂ ಹೊರಡು ಹೇಳಿದ್ರು ಅವರು. ಏನ್ ಹೇಳಿರಿ? ಹೇಳಿಬಿಡ್ರಿ, ನೀವೇ ಹೇಳ್ಬಿಡ್ರಿ, ನಾನು ಹೇಳಕ್ಕೋಲ್ಲ. ಮತ್ತೆ I don't know. He said even he made up his mind not to continue in the ACB. That's what he said. I don't know what force made him to continue. I don't know. But that's what I said also. He is also having bright future. He is also a future of this institution. That's what I said to him also. ಯಾರಿ ಮಾರ್ ಅವ್ರು ಕನ್ಸಿಲ್ ಒಂದಲ್ಲ, ನಾನು ಹೇಳ್ತೀನಿ ನೋಡಿ. ಅಷ್ಟೇ ಅಲ್ಲ, ಇನ್ನೊಂದು ಕೇಳಿದೆ. ಈ ನೋಡಿ ಹೇಗ್ ಮಾಡ್ತಾ ಇದಾರೆ ಅಂದ್ರೆ, ಫಸ್ಟ್ ಆಫ್ ಆಲ್ ಅವನು ಅರೆಸ್ಟ್ ಆದ್ನಲ್ಲ, ಅವನು ಅಕ್ಯೂಸ್ ನಂಬರ್ 2, he is working in the very same department. A1 DC ಸ್ಟೇಟ್ಮೆಂಟ್ ಮಾಡಿದ್ದಾರೆ, ರೆಕಾರ್ಡ್ ಮಾಡಿದ್ದಾರೆ. He denies that he is not working in our department or DC office ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ. Accused number 1, he is also working as personal assistant of the deputy commissioner. He says the person who has received an amount of rupees 5 lakhs, he is working in the appeal section ಅಂತ ಹೇಳ್ತಾರೆ. ಆಮೇಲೆ accused number 2 ಏನ್ ಹೇಳ್ತಾರೆ, ನಾನು ಕೂಡ ವರ್ಕ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ. A1 ನನಗೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಕೊಟ್ರು ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೊಳಕ್ಕೆ, ನಾನು ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೊಂಡೆ 5 ಲಕ್ಷ ಅಂತ ಹೇಳ್ತಾರೆ. ಆಮೇಲೆ ಇವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ, ಇಲ್ಲ ಅವ್ನು ವರ್ಕೇ ಮಾಡ್ತಿಲ್ಲ ನಮ್ಮಲ್ಲಿ ಅಂತ ಅಂತಾರೆ. ಹೌ ಕ್ಯಾನ್ ಇಟ್ ಬಿ ಪಾಸಿಬಲ್? State government also says like that. I summoned the deputy commissioner to place the records for appointing him as a temporary basis or contract basis. DC deny ಮಾಡ್ತಾರೆ. DC personal assistant says he is working in our department in appeal section ಅಂತ ಹೇಳ್ತಾರೆ. Is it not suppressing the truth by the ACB as well as the state? ನೀವು ಹೇಳ್ತೀರಾ ನೀವು ಇಲ್ಲ ಅಂತ? ಮತ್ತೆ ನಾನು ಲಾಯರ್ ಬಗ್ಗೆ ಹೇಳಿಲ್ಲ. ನಾನು ಲಾಯರ್ ಬಗ್ಗೆ ಏನ್ ಹೇಳಿದೆ? You are here to protect what I said. You are here to protect the institution, not to protect the accused persons ಅಂತ ಹೇಳಿದೆ. ನಾನು ಪಾಯಿಂಟ್ ಔಟ್ ಮಾಡಿದೆ. ಅವರ SP ಕೇಳಿ ನೋಡಿ, ಅವರೇ ತೋರಿಸಿದ್ರು ರೆಕಾರ್ಡ್ಸ್. ಈ ತರ ಸ್ಟೇಟ್ಮೆಂಟ್ ಮಾಡಿದಾನೆ ಏಟು ಅಂತ ಮಾಡಿ ತೋರಿಸ್ತಿಲ್ಲೇನ್ರಿ ಅವ್ರು ನಿಮ್ಗೆ? 4-0. Those are the statements by SP. ಹೌದು ಮಾಡ್ಲಿಲ್ಲ, ಕೇಳಿ ಅವ್ರನ್ನ ಕೇಳಿ ಮಾಡಿದ್ರ ಇಲ್ಲ ಅಂತ. ನನ್ನ ಹತ್ರ ಹೇಳ್ಬಿಟ್ಟು ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿ ಅವರು he did not come forward to produce the documents. ಅದ್ ಒಂದು. ಆಮೇಲೆ ಬಂದು ಅಡ್ವೊಕೇಟ್ ಜನರಲ್ undertook to produce the same before the court. That is the reason only ನಾನು ಮೆನ್ಷನ್ ಮಾಡಿದ್ದೀನಿ. ಅದಕ್ಕೆ ಹೇಳಿದ್ದು. He being he being an advocate for an institution, he should not dance to the tunes of the parties. We are here to dispense the justice. That is his duty. His duty is also to assist the court for dispensation of justice. ನಾ ಬುದ್ಧಿವಾದ ಅವತ್ತೇ ಅವ್ರಿಗೆ ಹೇಳಿದ್ದೀನಿ, ಅದೇ ಅವತ್ತೇ ಹೇಳಿದ್ದೀನಿ, you people are the futures of this institution, you should take care of this institution ಅಂತ ಹೇಳಿದ್ದೀನಿ. I am also concerned with the institution. ನನಗೇನ್ ನೋಡ್ರಿ, ನನಗೆ ಯಾವ ಪರ್ಸನಲ್ ಏನಿಲ್ಲ, ನನಗೆ ಯಾವ ಪರ್ಸನಲ್ ಇಲ್ಲ. ಅವರೇ ACB ಬೇಡ ಅಂತ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾರ. ಎಲ್ಲಿ ಡಿವಿಷನ್ ಬೆಂಚ್ ಅಲ್ಲಿ ಅಲ್ಲಿ ACB ಬೇಡ, ಇಲ್ಲಿ ADCP ಬೇಕು ಅಲ್ಲ, ಅಲ್ಲಿ ACB ಬೇಡ, ಇಲ್ಲಿ ADCP ಬೇಕು. There cannot be a double yardstick, Ashok ಅವರೇ. There must be one yardstick. There must be one yardstick. You cannot blow on hot and cold. Going division bench says no, Lokayukta is necessary, not ACB. Arguing their division bench, saying that. But here you are arguing on behalf of the. ನೋಡ್ರಿ, ನಾನು ಏನ್ ಮಾಡಿದೀನಿ, ನಾನು ಒಂದು ಇನ್ ದ ಇಂಟ್ರೆಸ್ಟ್ ಆಫ್ ಪಬ್ಲಿಕ್ ಅಷ್ಟೇನೆ, ಬೇರೆ ನನ್ಗೇನು ಇಲ್ಲ ಇದ್ರಲ್ಲಿ. ನನಗೇನು ಯಾರ ಮೇಲೂ ಗ್ರಡ್ಜ್ ಇಲ್ಲ, ನನಗೇನು ಯಾವ ಇದು ಇಲ್ಲ. ಜನರಿಗೆ ಒಳಿತಾ ಆದ್ರೆ that itself is enough. That's why I said like that. But also ಅದ್ರ ಜೊತೆಗೆ ಏನಾಯ್ತು, ಬೆಂಕಿ ಹಚ್ಚಿದ್ರು, ಥ್ರೆಟ್ ಮಾಡಿ. ಹೌದಲ್ಲ, ಥ್ರೆಟ್ ಮಾಡಿದಾಗ ನೀವೇ ಜಡ್ಜ್ ಆಗಿರಿ. ಫಾರ್ ಎಕ್ಸಾಂಪಲ್ ಅದೇ ಹೇಳಿದ್ದು, ನಿಮ್ಗೆ ಥ್ರೆಟ್ ಮಾಡಿದ್ರೆ ನೀವು ಏನ್ ಮಾಡ್ತಿದ್ರಿ ಹೇಳಿ, ನನ್ಗೆ ಅಷ್ಟೇ ಬೇಕಷ್ಟೇ ಅಲ್ವಾ? ಅಲ್ವಾ ಅಲ್ವಾ ನಮ್ಗೆ ಯಾವಾಗ್ಲೂ ಬ್ಯಾಕ್ ಡೋರ್ ಕೆಲಸ ಮಾಡಿ ಅಭ್ಯಾಸ ಇಲ್ಲ. ನಮ್ದೇನಿದ್ರು ಸ್ಟ್ರೈಟ್ ಫಾರ್ವರ್ಡ್ ಅಷ್ಟೇ. ಇದ್ರೆ ಎದುರುಗಡೆ ಹೇಳ್ತೀವಿ, ಇದ್ದವ್ರು ಇಲ್ಲ. ನೋ ಬ್ಯಾಕ್ ಸ್ಟಾಬಿಂಗ್. ನಾನು ಕೋರ್ಟಲ್ಲಿ ಏನ್ ನಡೆಯುತ್ತೋ ಅವತ್ತಿಗೆ ಅದು ಮುಗ್ದೋಯ್ತು. ನಾನು ವೈಯಕ್ತಿಕವಾಗಿ ಐ ನೆವರ್ ಟೇಕ್, ಇವನ್ ಮನಮೋಹನ್ ಅಂತಲ್ಲ, ಯಾರಾದ್ರೂ ಅಷ್ಟೇ. I only said you all people are the futures of this institution. That's what I said. Take decision and assist the court in dispensation of justice. Attack made on the judge. One is independence of judiciary. Another is interfering with dispensation of justice. ಈಗ ನಾನು ಹೋಗಿ ಬೇರೆ ಜಡ್ಜ್ಗೆ ಏನಾದ್ರು ಹೋಗಿ ಹೇಳಕ್ಕಾಗುತ್ತೆ, ಯಾವ್ದಾದ್ರು ಮ್ಯಾಟರ್ ಇದ್ದಾಗ ಹೇಳ್ಬಾರ್ದಲ್ಲ. That's what I understood. I cannot say. Now I will make it on record also. What are the words are used by a judge? Toli madam. When I to placed on record, ಆಯ್ತಲ್ಲ ಮೆಮೊ ಡೈರೆಕ್ಟೆಡ್ ಟು ಕಾಪಿ ಕೊಡ್ರಿ, ಅವ್ರಿಗೆ ಒಂದು ಕಾಪಿ ಕೊಡ್ರಿ. ಮನ್ಮೋಹನ್ ಕಾಪಿ ಕೊಡಿ. The registrar judicial is directed to get the details of the report. And ಏನಾರು ಕೊಟ್ಟಿದಾರ ಮೇಡಮ್? ಅವ್ರೇನ 4 ಗಂಟೆ ಹೊತ್ತಿಗೆ ಕೊಡ್ತೀನಿ ಅಂದ್ರು. ಅವ್ರೇನ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಬೇಕಂತ.
First question that is related also exactly what you asked. Why is the person who is supposed to be the author of the law? Where is he? Why is he not here? Our question. Our mother. Then of course the logic knows how this matter and all there around to get over. Then we are from then on, because of what a constitution is, what are the arbitrary investigations? I understand. I And you see, my role, I have nothing to do with this. The person who has to write this order is a deputy commissioner. He is not an accused. The person who has taken the money.
ಅದ್ ನಾವ್ ಹೇಳಿದ್ದೆ ತಪ್ಪಾಯ್ತು ಅಂತ ಅವ್ರ ಪ್ರಕಾರ ಅದ್ ಹೇಳ್ಬಾರ್ದಿತ್ತು ಅಂತ.
ಈಗ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಟ್ರ್ಯಾಕ್ ಬಂದಿರೋದು
ಅಲ್ಲ ಈಗ ನಾನು ನಿಮ್ಗೊಂದು ಡೈರೆಕ್ಟ್ ಮಾಡಿದ್ದೆ till date the place the investigation material ಅಂತ ಎಲ್ಲಿದೆ ರೀ? Learned Counsel for ACB is directed to place the investigation material collected till date in respect of the crime by the next date of hearing because you have conducted the ಮನೇನೋ ರೈಡ್ ಮಾಡಿದಿರಿ ಹೌದಲ್ಲ? ಏನೋ ಸಿಗ್ಲಿಲ್ಲ ಅಂದ್ರಿ ಬಟ್ ಏನೋ ರೆಕಾರ್ಡ್ ಸಿಕ್ತು ಅಂತಲೇನ ಅಂದ್ರಿ, ನನಗ್ ಗೊತ್ತಿಲ್ಲ. ಹೌದಾ? ರೆಕಾರ್ಡ್ ಸಿಕ್ಕಿದೀಯಾ? ಏನ್ ರೆಕಾರ್ಡ್ ಸಿಕ್ಕಿದೆ ರೀ? ಪ್ರಾಪರ್ಟಿ ಟ್ಯಾಕ್ಸ್ ಪೇಡ್ ರಿಸೀಟ್ಸ್. ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅಂಡ್ property documents. But who discloses all this to the paper? 30 acre land in and around between the Bangalore ಅಂತ ನೀವ್ ಯಾಕೆ ACB ಕಂಡಕ್ಟ್ ಮಾಡಿದಾಗ ಎಲ್ಲ ಪೇಪರಿಗೆ ಕೊಟ್ಬಿಡ್ತೀರಿ? ಲೈವ್ ಟೆಲಿಕಾಸ್ಟ್ ಆಗ್ತದೆ ಹೆಂಗೆ? ನೀವು ಅದನ್ನ ಸೀಕ್ರೆಸಿ ಕಾಪಾಡ್ಬೇಕಲ್ವಾ? ನೀವು ಯಾವ್ದೇ ರೈಡ್ ಆಗ್ಲಿ ಅನ್ನ ವೆರಿ ನೆಕ್ಸ್ಟ್ ಡೇ ನೀವು ಟೆಲಿಕಾಸ್ಟ್ ಮಾಡ್ತಿರಲ್ಲ ಹೆಂಗೆ? ಈಗ ನಾವು it has appeared in the paper that the DC has acquired the properties in around Bangalore 30 acres of land ಅಂತ. How they got all this information? ಮತ್ತೆ ಹೆಂಗ್ ಬಂತದು? ಇನ್ ಅಂಡ್ ಅರೌಂಡ್ ಏನೋ ಆಗ್ಲಿ ಏನು ರೈಡ್ ಮಾಡಿ ಮನೆ ಒಳಗೆ ನುಗ್ಗಿರೋದೆಲ್ಲ ಆಗ್ಲೇ ಟಿವಿ ಟೆಲಿಕಾಸ್ಟ್ ಆಗ್ತಾ ಇರ್ತದೆಲ್ಲ. Is it not your duty to maintain the secrecy or investigation? ಅದುವೇ actually even other side ಗೂ ಕೊಡೋಂಗಿಲ್ಲ in between court and the ACB. This is between the court and the ACB till completion of the investigation. Court and the ACB. But everything goes on viral in everything. But 30 ಎಕರೆ ಸಿಕ್ತು ಅಂತ ಹೆಂಗ್ರಿ? ಮತ್ತೆ ಯಾರು ರಿವೀಲ್ ಮಾಡಿರೋದ್ನ? If this court has not taken this monitoring, you would not have been arraigned as an accused. ಅಲ್ವಾ? ಆಮೇಲೆ ನೋಡಿ ಈಗ ನೀವೇನೇ ಮಾಡಿದ್ರಿ, ಅರೆಸ್ಟ್ ಮಾಡಿದ್ರಿ, ಈಗ ಮತ್ತೆ ರೈಡು ಕೂಡ ಕಂಡಕ್ಟ್ ಮಾಡ್ತೀರಿ ನೀವು. ಫಸ್ಟ್ ಆಫ್ ಆಲ್ ನಿಮಗೆ ಅಕ್ಯೂಸ್ ಮಾಡಕ್ಕೇನೆ ನೀವು ಯು ಆರ್ ನಾಟ್ that is what this court has said, inaction on the part of the ADGP. You have not arraigned him as an accused, and immediately when he has been arraigned as an accused and other acts are done, and then subsequently he was arrested, and after arresting on the very next day you conduct the raid on the house of the accused. ಹೌದಲ್ಲ? ನಿಮ್ ಪ್ರಕಾರ ಅಕ್ಯೂಸ್ ಮಾಡಕ್ಕೇನೆ ಏನು ಮೆಟೀರಿಯಲ್ ಇಲ್ದ ಮೇಲೆ how you conducted raid on the house of the deputy commissioner? That's why I said it is an inaction and lack of enthusiasm on the part of the officer who is having helm of affairs. Very purpose for which the institution is established is not taken care of by a person who is in helm of affairs. That's why I observed that, or otherwise I would not have observed. And now your action only clearly shows that subsequently after this court having found the material, you arraigned him as an accused and apprehended him and also conducted the raid on the house of the deputy commissioner. You would have done this. You would have done this before this court pursuing the matter. Having perused the material only, this court observed that inaction on the part of the ADGP. He is in helm of affairs. All other subordinates will hear his words if he gives any directions, but that has not been done. ಏನಾಯ್ತು ಮೇಡಮ್? ಏನು ಕೊಟ್ಟಿದ್ದೀರಾ? ಕೊಡ್ತಾ ಇದ್ದೀರಾ? sealed, huh? So, Registrar Judicial submits that received the details of the report from 18 districts and remaining districts yet to receive. The same is placed on record. Placed on record. Told early. The council appearing for the ACB also placed the investigation material collected till date as directed by this court and in sealed cover. And the same is also placed on record. Placed on record. The council appearing for the petitioner opposes any adjournment sought by the ACB council on the guise of matter has been moved before the apex court against the order dated 7/7/22 and matter is also listed before the apex court tomorrow. And when the matter is listed tomorrow, it is appropriate to grant 2 days time and list this matter in keeping the contention of the petitioner counsel that the personal liberty of a person who is in custody is also involved. And hence, list this matter on 13th. ಇನ್ನೊಂದು ಮ್ಯಾಟರ್ ಆಗಿದೆ ಮೇಡಮ್ PS ಇದು 14th 13th of July 13th of July 13th of July. This court would like to make it clear now, since the council Mr. Ashok Harnalli appears and submits that SLP is filed before the apex court. And he also says that there cannot be any attack on the judiciary. While dispensing the justice, it amounts to independence of judiciary. When this matter was heard on 29/6/2022, and this court found inaction on the part of the ACB in arraigning the real accused, made an observation with regard to the inaction on the part of the ACB in bringing the real culprit. And matter was adjourned to 4/7/22. In the meanwhile, on account of superannuation, a dinner was arranged by this court to give bid farewell to Honorable Chief Justice on 1/7/2022. The sitting judge who came and sat by the side of me and started with the word, he had received a call from Delhi, but not within bracket, not disclose the name, and says the person who called from Delhi inquired about me, and immediately I replied, I am not affiliated to any political party. The judge did not stop the same there itself. And said that ADGP is from North India and he is powerful. Good stuff. He also gave an instance of transfer of ಕೊಡಿ ಮೇಡಮ್ ಅಲ್ಲಿ ಫೈಲ್ ಇದೆ. ವೇರ್ ಇನ್ ದಿಸ್ ಕೋಡ್ ಫೌಂಡ್ ಅದಲ್ಲ ಎರಡು ಫೈಲ್ ತಪ್ಪೋದಿದೆ ನೋಡಿ. ಸರ್ವಿಸ್ ರೆಕಾರ್ಡ್ಸ್ ಇದೆ ನೋಡಿ. And on perusal of service records, for the period of assessment 2009-10, the reviewing authority a remarks was made. The officer has to pay adequate attention to police image while performing his duties or supervising duties of subordinate officers, public ranks. It is further observed in column number 9 that lesser strengths or loose supervision, comma, soft going on subordinates, comma, inability to say no. For the year 2008.9, 1/4/2008 to 31/3/2009, the officer is hard working. ಏನ್ ಹೇಳಿ? ಆಯ್ತು, ನಾವೇನಾದ್ರು ನಮ್ದೇನ್ ನೋಡೋದು ನಾ ಬರ್ದ್ಬಿಡ್ತೀನಿ, ನೀವು ಅಲ್ಲಿ ಏನಾದ್ರು ಮಾಡ್ಕೊಳ್ಳಿ, ನಂದೇನಿಲ್ಲ. ನೋಡಿ ಏನಾಯ್ತು ಹೇಳಿ? His ability to take tough stand, I will make it on record. Stand shall improve. The director, the deputy director, apart from that, deputy director of PPIR submits the records regarding a raid was conducted. A CBI raid was conducted in respect of the residence of ADGP, and also report submitted and requested the state government to inquire into the matter. And now the report is also placed on record by the CBI. When all these materials are found, and also the reports which have been submitted by ACB, and only in respect of 5 matters, even the details and the other 99 B reports are dumped to the court without any details of offences, crime, and hence this court summoned the documents from the details from the respective courts. And having taken note of all this with regard to the threat to the court as well as the way in which the officer who is in helm of affairs assisting the court found that the same is not in the interest of public as observed in the judgment of the apex court. In the order referred dated 7/7/22 that public interest is the sole consideration and the constitutional court monitors an investigation only when circumstances compelled to do so. Such as enthusiasm by the investigating officer or the agency within bracket to pressures in conducting a proper investigation, or a lack of enthusiasm by the concerned government in assisting the investigating authority to arrive at the truth, or a lack of interest by the investigating authority or the concerned government to take the investigation to its logical conclusion for whatever reason, or in extreme cases, to hinder the investigation. The same is found in investigating the matter and assisting the court by the ACB. And hence, the said circumstances posed to all the details, including service records as well as the B reports which have been submitted before the trial courts. That too, only public interest, which is the sole consideration, and constitutional court monitors an investigation only when circumstances compelled it to do so. The same is placed on record with regard to the threat to the court is concerned, and also the subsequent development in the case. List this matter on day after tomorrow. 2 days, wait any of well, why this is only if it is order is set aside, how it will bears on the considering of the bail petition, even assuming that order is set aside, how it will come in bear with the petition. Contentions you can opposing. Sorry, madam. Having discussed above, taking note of the material before the court, the very object in monitoring the investigation and considering the material, it is appropriate to direct the government, appropriate the chief secretary and DPIR while posting the officers, that to a institution which is established for prevention of corruption, to take note of the public interest and should not be posted any tainted officers to the helm of affairs of the institution which is established, prevent the corruption. And hence I pass the following order. Note. I am not sending out helta illa. I am not passing any such an order. No, council. And yes, I am having found the material before the court. I am making such direction. You can implement, whether they can implement it or not. That is left to in the interest of the general public only. I am giving such direction. Sorry, madam. Please, Ashok Karnataka, you are not on record. You are not on record. You are not on record. The memo which I find I have taken on record. Sorry. The chief secretary is directed to consider the person, the chief secretary is directed to, before posting an officer for the office which is established prevention of corruption, the officer must be having credibility and also to take the helm of the affairs of the institution to the great height, and the same has to be considered. One, the director, the secretary to the deputy DPR also bring it to the notice of chief secretary while posting an officer to the helm of affairs of prevention of corruption, that is ACB, to furnish all details regarding the service records as well as the integrity of the officer. And other day made a mention before the court by the deputy secretary to the DPR that due to the pressure, the same can't be done. And unless and pressure, state should not yield to such pressure. The interest of the public. In the interest of the public. Third one. The posting should not be any of the considerations, whether it is external influence or internal influence, the same cannot be a criteria while posting the officers to the institution. The officers who has to be posted to the prevention of corruption, to prevent the corruption of corruption, and his family members or any other persons should not facing any investigation by either by the ACB or Lokayukta. And are otherwise the family members or relatives who are facing the investigation by ACB or Lokayukta, there is the taking of advantage of the same. The registry is directed to communicate this order to the Chief Secretary as well as Secretary to the DPR. So, 2 days wait. The further investigation proceedings, investigation materials furnished to court. The registrar judicial is directed to keep the same in safe custody. This matter for hearing the bail application on 13th July 2022. At 2:30. ಯಾವ್ದ್ರಲ್ಲಿ ರಿಜಿಸ್ಟರ್ ಅದ್ ಮಾತ್ರ ಇನ್ಯಾವ್ದು ಕೊಟ್ಟಿದ್ದಾರೆ ಸೇಫ್ ಕಸ್ಟಡಿ ಇನ್ಯಾವ್ದು ಕೊಟ್ಟಿಲ್ಲ
This report, Lord, may I make one submission?
ಅದೊಂದೇ ಇಟ್ಸಿ ಸಾಕು.
Lord, may I make one submission? Lord, in the CBI report,
ರೆಕಾರ್ಡ್
copy of CD ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೀನಿ because that maybe may not
CD ಕೊಟ್ಟಿದೆ.
CD ಎಲ್ಲ first to explain how things happen.
ನಾನು ಪಿಟಿಷನ್ ಡಿಸ್ಪೋಸ್ ಮಾಡಿದ ಕೊಟ್ಬಿಡ್ತೀನಿ. I will order to return the same.
Process the court, we have given everything.
ಆಯ್ತು, ಅದನ್ನ ನಾನು ನಿಮಗೆ ವಾಪಸ್ ಕೊಡ್ತೀನಿ ನಾಡಿದ್ದೆ. ಈಗ ಹೇಗಿರೋ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ತೀನಿ ಮ್ಯಾಟರ್ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ. I will give return the file also to you. ಏನು ಹೌದು, you only intervened. You only intervened and made submission. All only from your client instructions only. That's all. You only intervened and made submission. I noted the same. That's all. You while dictating the order, you intervened and undertaken to place the documents. That's what I mentioned in my order. That's all. Officer was present. You intervened and made submission to the court. That I have noted in my order. That's all. ಅಪ್ಲೋಡ್ ಮಾಡ್ತೀವಿ, ಕರೆಕ್ಷನ್ಸ್ ಆದ್ರೆ ಇವತ್ತು ಮಾಡ್ತೀವಿ. ನನಗೆ ಬೇರೆ ಮ್ಯಾಟರ್ಸ್ ಇದೆ, ಇದೆಲ್ಲ ಬೇಲ್ ಮ್ಯಾಟರ್ಸ್ ಇದೆ, ಅದು ಎಲ್ಲ ಪರ್ಸನಲ್ ಲಿಬರ್ಟಿ ಆಫ್ ಎ ಪರ್ಸನ್. ಆಯ್ತು, ತೊಗೊಳ್ಳಿ ರೆಗ್ಯುಲರ್ ಮ್ಯಾಟರ್ಸ್ ಯಾವ್ದು ತೊಗೊಳ್ಳಿ. ಹ್ಮ್ 46. Yes, counsel. ಆಯ್ತು ಅದೇನು ಅಪಾಲಜಿ ಅಂತ ಓನ್ಲಿ ಮೆರಿಟ್ಸ್ ಅಷ್ಟೇ. ಹೇಳಿ 403, 406, 419, 420, 465, 468 ಹೇಳಿ. ಅನೆಕ್ಷ Annexure C or E? B. Accused.
Number 1 and 2 had approached the jurisdiction. That is not district assistant has obtained anticipated annexion E base 34. Base 34. But this is the order to criminal list number 41 of 2020 of first race. And annexation number 38. This is 21st September. But 1 month 2020 after 1 year 8 months. 1 year 8 months after. That is on 38/2021.
30?
August 30. 9 months, 1 year 9 months after. ಈ ಮರು ಹೇಳಿಕೆ ಫಿರ್ಯಾದಿದಾರರ ಮರು ಹೇಳಿಕೆ ಅಂತ
ಮರು ಹೇಳಿಕೆ ಮೇಲೆ ಆನ್ಸರ್ ಡಿ.
ಫಿರ್ಯಾದಿದಾರ ಮರು ಹೇಳಿಕೆ ಪೇಜ್ ನಂಬರ್ 33 ಅಲ್ಲಿ ಲಾಸ್ಟ್
that is on 38/21.
38/2021. 1 year 9 months. ನನ್ನ ಮೇಲೆ ಅಪ್ಲಿಕೇಶನ್ ಏನಂದ್ರೆ ನಾನು ಇನ್ಚಾರ್ಜ್ ಆಗಿದ್ದೆ ಅಷ್ಟೇ.
ಅವಾಗ ಇನ್ಚಾರ್ಜ್ ಆಗಿದ್ರಿ.
CEO, not HR, CEO.
C1.
In fact, I was the one who has given complaint. ನಾನೇ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ.
ಯಾವಾಗ?
But this is
given complaint against whom? A1 and 2 ಮೇಲೆ.
The complaint is dated 1/1/2020. ನಾನು 10 ದಿನ ಮುಂಚೆ ನಾನು ಈ ಮೂಲಕ ಏನಾಗಿದೆ ಹೆಚ್ಚುವರಿ ಪ್ರಭಾವದಲ್ಲಿ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ನಂದಿ ದೇವಾಲಯ ಹಾಗೂ ತಿರುಮಲ ತಿರುಪತಿ ದೇವಸ್ಥಾನ ಹೆಚ್ಚಿನ ಪ್ರಮಾಣ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿದೆ. ಈ ಸಂಬಂಧದಲ್ಲಿ ನಾವು ಭಾರತೀಯ 2 ಬಾರಿ ಬರುತ್ತಿದ್ದು ಕೆಲಸ ಬಂದಿದ್ದರಿಂದ ಅವರು ಬಿರುದು ಕೊಟ್ಟಿದ್ದಾರೆ. After lapse of almost 12 years.
Hmm.
2020 FIR Act.
Hmm.
2022 What's action?
Hmm.
Therefore, I approach the
Hmm. Hmm.
that has been rejected.
Hmm.
Age about 59 years.
Hmm.
In the complaint itself, my lord, his name is revealed.
Hmm.
Page number 20.
Page number
20, my lord, complaint.
20.
Please, my lord.
Hmm.
Para 4. ಈಗಾಗಲೇ ಹಿಂದೆ ಕಾರ್ಯನಿರ್ವಹಿಸಿದ ಕಾರ್ಯನಿರ್ವಾಹಕ ಅಧಿಕಾರಿಗಳಾದ ಶ್ರೀ ವೆಂಕಟರಮಣ ಗುರುಪ್ರಸಾದ್ ರವರಿಗೆ
Hmm.
ಗುಜರಾತ್ ಇಲಾಖೆ ಆಯುಕ್ತ ಸದರಿ ನೌಕರಿಯನ್ನು ಅಮಾನತಿಟ್ಟು ಆದೇಶ ಹೊರಡಿಸಿದ್ದಾರೆ.
Hmm.
Initially, his name is revealed in the FIR.
Hmm. Hmm.
Allal.
Hmm.
It's a complaint itself.
Hmm.
His name revealed.
Hmm.
The initial stage, madam. Lord Mohammed is the CEO of the in charge. During the 2017 to 26/8/2019, he along with accused number 1 and 3, misappropriated the huge amount of rupees 90,84,698 rupees. 90,84,698 rupees, madam, of the temple property.
This petitioner.
Along with accused number 1 and 2.
Total overall.
Please, madam.
Hmm.
Custodial interest required, my lord, is some impression and
ಬೆದರಿಕೆ ಹಾಗೂ ತೊಂದರೆ ನೀಡುವ
he is the responsible person. He is the CEO.
ಬಟ್ ನಿಮ್ ಪ್ರೇಯರ್ ಅಲ್ಲಿ ಇರೋದು ಅಪ್ಲಿಕೇಶನ್ ಕೌಂಟ್ ಇದ್ರಲ್ಲಿ ನೋಡಿ ದುರುಪಯೋಗಗೊಳಿಸಿರುವಂತೆ ಸುರೇಶ್ ಮತ್ತು ಶ್ರೀಮತಿ ಶ್ರುತಿ ಅಂತ ಹೇಳಿ ಬರ್ದಿದ್ದೀರಿ. ನಿಮ್ ಪ್ರೇಯರ್ ಅಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಇರೋದು ಓನ್ಲಿ ಅಗೇನೆಸ್ಟ್ ಟು.
ಅಲ್ಲ ಅದೇ ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಕಾರ್ಯ ಆಕ್ಚುಲಿ ಇಲ್ಲಿ ಏನಾಗಿದೆ, ಇನ್ನೊಬ್ಬ ಅಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟರು ಕಾರ್ಯನಿರ್ವಹಣಾಧಿಕಾರಿ ಸೇಫ್ ಗಾರ್ಡ್ ಮಾಡಕ್ಕೆ ಎರಡೇ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿರೋದು ಅವನೇ ಸಿಇಒ, ಇನ್ನೊಬ್ಬ ಸಿಇಒ. ಇವನು ಸೇಫ್ ಗಾರ್ಡ್ ಮಾಡಕ್ಕೆ ಅವ್ರ ಇಬ್ಬರ ಹೆಸರು ಮಾತ್ರ ಹೇಳಿದಾನೆ. ಮೇಯರ್ ಓನ್ಲಿ ಹೆಸರು ಮಾತ್ರ ಹೇಳ್ತಾನೆ ಅಷ್ಟೇ ಅಲ್ಲಿ.
ಆಯ್ತು, ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗ್ಲಿ ಬಿಡಿ ನೋಡಿ ಮಾಡ್ಲಿ. ಲೆಟ್ ಹಿಮ್ ಕೋಪರೇಟ್. ನೋಡಿ at the petitioner counsel and also the counsel appearing to the state. The factual matters of the case of the prosecution based on the complaint of executive officer Sri Viduraswata Narayana Swami Temple. FIR is registered against accused number 1 and 2 that they have indulged in misappropriating the amount belongs to the temple. And based on the complaint, case has been registered. The counsel appearing for the petitioner would submit that this petitioner name has been arrayed up to 1.5 years, 1 year 9 months. Recording the further statement dated 30/8/21 of the complainant as per annexure B. And specific allegations made against only accused number 1 and 2 in the complaint dated 24/12/2019. And after that, this petitioner has been arraigned as an accused. And hence petitioner may be enlarged on bail. For counter, the counsel appearing for the state would submit that in the complaint itself mention the name of this petitioner, stating that the executive officer has been kept under suspension. And though specific action is sought against accused number 1 and 2, this petitioner along with other accused persons misappropriated the amount to the tune of 90,84,698. And hence, the very presence of the petitioner is required to be proper. Having heard the respective counsel and also on perusal of material available on record. No doubt complaint was given in the year 2019. And specific action is sought against accused number 1 and 2. Though it is mentioned that this petitioner was kept under suspension, no action was sought. And also this petitioner has been arraigned as an accused.
Accused number 1.
Big but charge sheet agilla. Arraigned as an accused based on the further statement of the complainant. That too after lapse of 1 year 8 months. When such being the material disclosures before the court, it is appropriate to enlarge the petitioner on bail with conditions to cooperate with IO for the investigation in the matter. 47 Samuel.
Cancellation of bail.
Cancellation of bail.
Serviagilla.
What happened? ಏನಾಯ್ತು ನೋಡಿ ಮೇಡಮ್, ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ಪಾರ್ಟ್ ಅವೈಟೆಡ್ ಅಂತ. ಹ್ಮ್ 30th ಬಂದಿಲ್ಲ. Order was passed and dispatched. We have paid on the next day only. We have issued the avoid service of notice of part 2. This matter on 20th. Another 10 days for a note. But why? 18th ಆಯ್ತು ಇನ್ನೊಂದು ವಾರ. 48 ಚಂದ್ರಯ್ಯ. ಹ್ಮ್ 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 ಪ್ರೈವೇಟ್ ಕಂಪ್ಲೇಂಟ್.
ಹೌದು, PCR ಮೇಲೆ ರೆಕಾರ್ಡ್ ಆಗಿದೆ.
ಏನ್ ಡಾಕ್ಯುಮೆಂಟ್ರಿ ಇದ್ದಿದ್ದಾರೆ ಅಂತ? ಒಂದು ಬಿಲ್ಡಿಂಗ್ ಅನ್ನು ಕಟ್ಟುತ್ತಿರುತ್ತಾರೆ, ನಂತರ ಫಿರ್ಯಾದಿದಾರಿ ಗಾರ್ಡನ್ ಲೇಔಟ್ ಮುನ್ನಕೊಳಗ
BWSSP ಎಂಪ್ಲಾಯಿ
ಬಿಲ್ಡಿಂಗ್ ಒಳ್ಳೆಯ ರೀತಿಯಲ್ಲಿ ನೀರಿನ ವ್ಯವಸ್ಥೆ ಮಾಡಿಕೊಡುವುದಾಗಿ ತಿಳಿಸಿ ಬಳಿ ಒಟ್ಟು 13 ಲಕ್ಷ ರೂಗಳನ್ನು ಚೀಟ ಚೆಕ್ ಮೂಲಕ ಫಿರ್ಯಾದಿದಾರರ ಪರಿಚಯದಾರ ಶ್ರೀಮತಿ ನಂದಿನಿ ಸೋಮಶೇಖರ ಬಾಲಕೃಷ್ಣರವರ ಬ್ಯಾಂಕ್ ಖಾತೆಗೆ ಹಾಕಿಕೊಂಡಿರುತ್ತಾರೆ. ನಂತರ ಫಿರ್ಯಾದಿದಾರಿಗೆ ಯಾವುದೇ ರೀತಿಯ ನೀರಿನ ಸೌಲಭ್ಯ ಕೊಡದೆ ಅದು ಫಿರ್ಯಾದಿದಾರಿಗೆ ಈಸ್ ವರ್ಕಿಂಗ್ ಇನ್ ದಿ BWSSP. How the amount can be transferred to the 3 persons? Check ತಗೊಂಡಿರೋದು. ರಿಟೈರ್ ಆಗ್ಲಿ, ಬಟ್ the amount was transferred in the name of ಶ್ರೀಮತಿ ನಂದಿನಿ ಸೋಮಶೇಖರ ಬಾಲಕೃಷ್ಣ. ದಿನಾಂಕ 21/4/2001 ರಾಜ್ಯ ಮಾನ್ಯ ನ್ಯಾಯಾಲಯದ ಸಿಬ್ಬಂದಿರವರಾದ ಹಾಜರುಪಡಿಸಿದ ಮೇರೆಗೆ ಪ್ರಕರಣವನ್ನು ದಾಖಲು ಮಾಡಿದ್ದು ಸದರಿ ಪ್ರಕರಣ ಸಾರ್ವಜನಿಕರ ಸೈಟ್ ನಂಬರ್ 2020 But any amounts are transferred in the name of Srimati Nandini Somshekara Balakrishna.
PCR my lord. He is the present petitioner is accused number 1. He working in BWSSP. He issues the complaint that he get the connection. My lord. My lord, in 14 para, page number 14 my lord.
14.
Para 5. The complaint further submit that accused number 1 demanded
13 lakhs.
Please, my lord, of the water and sewage and cash and so on so. My lord, in next page, my lord, para 8, my lord. The complaint submitted that with the uttered shock which are given to the accused number 1,
has been
complaint,
presented by various names.
please, my lord. The complaint given the check to the accused presented in the various name and collected the money. In spite of collected money, he did not do the work, my lord, or in para 10, my lord. The complaint further submit that for past 1 year, the complaint that is approaching the accused number 1 for refund of money for sum of 13 accounts or not taking call, my lord. This is the allegations. Yes, there is specific allegation against.
First check is in favor of only the 2,190. Another amount is 5 lakh in the name of Balakrishna. Another amount is 5 lakhs. 3 lakhs in the name of Somashekara.
Accused, arrived as accused.
At any of matter is referred under 156(3), let them investigate. Heard the petitioner counsel and also the counsel of the prospect. The factual matters of the case of the prosecution, based on the private complaint by complainant, matter was referred under section 156(3). With regard to the allegation that an amount of rupees 13 lakh was collected from accused number 1 in the name of accused number 2 to 4 and cheated the complainant. And checks were also encashed. And no work was undertaken and service was given. Based on the complaint, case has been registered. The counsel appearing to the petitioner would vehemently contend that a false allegation is made that no amount was paid in favor of this petitioner and amounts are also paid in favor of different persons, that is accused number 2 to 4. And the same is also encashed in favor of accused number 2 to 4. And matter is under investigation based on the private complaint, and IO yet to investigate the matter and collect the material. And when suspending the case in order to probe the matter, this court can direct the petitioner to cooperate with the IO for the further investigation in the matter. One of the discussions made up by pass the following order. Bail petition is allowed with conditions. Vijay Kumar Prakash. 306, 504, 506, 499, 500. 438. Sole accused. Wife of the first informant.
Since 1991. But in 2009, there's some difference between the first informant and the executive papers. There are bitter rivalry started. First informant got alleged that I had improved 14 buntas of land, all belonging to the government. What is the Vaishya Vyasa International? But in that connection, we gave a complaint to all the authorities, including the BBA Commissioner, BBNP Commissioner, also the HLTC for enforcement. But once he started with that, I started printing his wife for the court. He alleges that I also sent some good arguments to him and knocked on his gate. But all this happened in 2009, 2010. And he has given complaints to various authorities, alleging threats from me. But finally, in 2001, that is on 27th of July 2001, there was a TV program on TV9, a private channel, I participate. But in that TV program, I'm managed to have said that this first employment is a Honda and a Opel. And he has embezzled around 30 lakhs of my money. And he was associated in the trust. But this program was viewed by so many of his relatives and friends who spoke to his wife about the program and unable to take the insult. But 20 days later, on the 16th of August 2001, she commits suicide. And she attempts suicide, and the next day she dies. That is on 17th of August. The complaint is filed after 1.5 months, on 3rd of October 2012, and the commissioner of police. And finally it comes to the concerned police station. The crime is registered on the 15th of December 2012. The meantime, at the time of her death, UDR is registered. What should we kindly see? At the time of the UDR, the statement of the mother of the deceased. Internal page 37.
And the incident, it was telecasted in the TV on 27/7/12. But the she committed suicide on 16/8/22.
Not 22, but 12.
12.
20 days after. And in that.
12 later.
Yes.
The allegation is that
2012.
There was a 482 petition, stay was operating. On 19th of May, that was disposed of.
dismissed.
Against me, they said, no, not a case of project. But I had already put in the meantime the sessions court whereby the anticipation day was not considered. So, for the reason that the 482 stay was operating, I did not approve this. But now the charge sheet is already filed. And I was not even called for investigation.
Well, how it is approximated to the cause of death?
After the telecast from the TV9, my lord,
That
he
is-
used to call her.
We used to call her.
Please, my lord.
This petitioner.
After the telecast, not after the telecast.
That's
Somewhere it is said that after the telecast, I have called her.
Here is that allegation.
It is not to
My lord,
those
He used to call to whom?
the deceased.
Deceased.
Please, my lord.
Uh,
Their allegation is there. In the 482 is petition is observed as is there, my lord. Single jet, my lord. The 184, my lord.
Which in a TV channel which was published throughout the world, which was viewed so many people, and they are calling the wife of the complainant about damaging and defaming worldwide the petitioner, which might have enraged or abetted to commit suicide. Therefore, at this stage, comma without going for trial, this court cannot appreciate, also. Not saying it is not. This could the wife of the accused committed suicide was frequent phone call made by the accused to the wife of the complainant, and the same was intimated by her to the husband. Even the accused also made so many phone calls to the complainant. There was cold war between them, and finally the accused defamed her husband in the eye of TV9 channel.
These calls were made in 2009-2010. But the figure according to the prosecution, the final director of positive act what is required at 306 happened on 27th of July. Where the next I said I called this gentleman as the opening, and that has affected that. But your logic would kindly see our own mother's statement at internal page 37. Then I read that from 8 to 10 lines at internal page 37. Now charge sheet is 560.
Anyhow, no proximity to cause of death.
Not there.
Yes.
Then page 5 also.
Told madam. What the petitioner of counsel and also the counsel appearing for the state. The factual matters of the case of the prosecution is that deceased Esreno, this petitioner was the managing trustee of Navachetana Trust. And CW1 was the chief coordinator. and they are conducting the social services. And hence the CW1 came out with the affairs of the trust. And all works are stopped, social works are stopped. As a result, the and as a result, the same was indirectly the respect of this petitioner was lowered. The land which is bearing survey number 101/2, which was kept for social purpose, social activities purpose, which is belongs to the government, was acquired, encroached by this petitioner and put up Vyasa, building the Vyasa International School. And hence CW1 gave the complaint on 9/2/20 to Lokayukta. And the same was proved. And BMPF also filed the complaint, and charge sheet is filed against the accused. And hence he is having the grudge against the complainant and victim, and cause the life threat to the victim. And apart from that, in TV9 telecasted that the husband of the victim is not having good character, and he is a rowdy sheeter. You know, Pounda Pokri.
Unda Pokri. That's what he was.
Used the filthy language, and the same has been witnessed by the victim. Took the extreme step of committing the suicide, and hence invoked the offense punishable under section 306, 504, 506, 499, and 500 of IPC. The counsel appearing for the petitioner would submit that in order to invoke section 306 of IPC, there must be a proximity to cause of death, and according to the complainant, public informant himself, that it was telecasted on 27/7/2012, but the suicide was on 16/8/2012. And when considering the matter, ingredients of section 306 not attracts. The other offences 504, 506, 499, and 500 has to be proved with regard to the defamation is concerned. Hence, he may be enlarged on bail. The counsel also submitted that 482 petition was filed and there was a stay, and recently the court dismissed the petition, and hence approached the trial court as well as this court. And once the investigation has been completed, no need of custodial trial, and hence he may be enlarged on bail. For contrary, the counsel appearing to the state would submit that specific allegations are made that in TV9 about the husband, defamatory statement made by this petitioner was telecasted, and hence due to humiliation she took extreme step of committing suicide, and hence there is a prima facie case. Having heard the respective counsel and also on perusal of material available on record, and also the incident was taken place in 2012, and apart from that, the defamatory statement was telecasted in TV9 on 27/7/12, and committed suicide on 16/8/2012. Since the relatives were also talking about the said news, Hence he took extreme step, and having taken note of the setback into consideration, and there was no any immediate incident with regard to 16/8/22. When assessing the case, the court has to take note of the proximity to cause of death, and hence once the and also investigation has already been completed and charge sheet is also filed, and matter has to be probed during the course of trial, and hence it is a bit case to exercise the powers of 438 of CRPC with conditions. 50 Rajendra Reddy. Also,
439, 376 and 6 of Oxide.
Oxo ಇದೆಯಾ?
ಹೌದು ಬಾಕ್ಸ್ ನೋಟಿಫೈ ಮಾಡಿ ಮಾಡಿದೆ.
ಮಾಡಿದೀರಾ? HCGP submit that he has notified the complainant. ಹೇಳಿ grounds. Medical evidence ಏನಾದ್ರು ಇದೆಯಾ? DNA
ಮಗು ಆಗಿದೆ, DNA ಮ್ಯಾಚ್
ಆಗಿದೆ. ಹಾ.
My submission is Millard at the time, on the date of incident. He is also minor and juvenile.
Minor
And juvenile.
ಹಾ.
His date of birth Millard of 14.
ಫಸ್ಟ್ ಟೈಮ್ ಏನೋ ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಡ್ತೀನಿ ಅಂತ ಟೈಮ್ ತಗೊಂಡ್ ನೆನಪು. ಮೈನರ್ ಅಂತ ಹೇಳೋರು. ಫಸ್ಟ್ ಟೈಮ್ ಇದು. ಇನ್ನೊಂದು ಕೇಸ್ ಹಾಗಾದ್ರೆ ಬೇರೆ ಯಾವ್ದು?
Date of birth of the petition is Millard 7/1/2004.
ಇದೆಯಾ? ದಾಖಲೆ ಇದೆ ಅದಕ್ಕೆ?
ದಾಖಲೆ ಇದೆ. I produced
ಹಾಕಿದ್ದೀರಾ?
page 24.
24. ಹಾ. ಹಾ 24. ಜನನವಾದ ತಾರೀಕು 7/1/2004. ಹಾ.
He is also minor and comes under the Juvenile Justice Act. Section 12 of the Act, Millard, provisions for bail is entered for bail under Section 12.
ಏನ್ರಿ ಡಾಕ್ಯುಮೆಂಟ್ ಏನು ಡಿಸ್ಪ್ಯೂಟ್ ಇದೆಯಾ? ಏಜ್ ವೆರಿಫೈ ಮಾಡ್ತೀರಾ? HCGP seeks time to verify with regard to the genuinity of the document of date of birth, which shows date of birth of the petitioner as 7/1/2004, and hence this matter on 18th. Prakash MH A27A. 438.
Petitioner is the accused number 2.
A2.
Subsequent to registration of the crime called 36/22, there was a trap in respect of accused number 1 and 2.
1 and 2.
1 and 3. Sorry.
1 and 3.
PDO and staff attached to the panchayat. The present petitioner is secretary in the panchayat. Secretary. Allegation is that the de facto in a property standing in the name of the father of the de facto complainant, in respect of which there was a change of khata, and by the terms of the order of the executive officer, the panchayat was directed to restore the khata. The allegation made against the petitioner is that she has forcefully taken about 2,000, and subsequently what the complainant says that
ಗುಣಶೀಲರ್ ಅವರು ನನ್ನಿಂದ 2,000 ಲಂಚದ ಹಣವನ್ನು ಮುಂಗಡವಾಗಿ ಪಡೆದುಕೊಂಡಿದ್ದಾರೆ. 10,000 ಲಂಚದ ಹಣ ಕೊಡಬೇಕು ಒತ್ತಾಯಿಸುತ್ತಿರುವ ಹಾಗೂ ಖಾತೆ ಮಾಡಿಕೊಳ್ಳಲು ಹೆಚ್ಚುವರಿಯಾಗಿ 10,000 ಲಂಚದ ಹಣವನ್ನು ಕೊಡುವಂತೆ ಬೇಡಿಕೆ ಇಟ್ಟಿರುವ ಬೇಗೂರು ಗ್ರಾಮ ಪಂಚಾಯತಿ PDO ಶ್ರೀಮತಿ ಅಂತ.
subsequently what he alleges that the first accused has demanded 10,000 rupees, and in Kunigal, here executive officer's office, Lord, the trap was laid, and the accused number 1 and 3 who were present, and my lord may kindly turn to page 30.
Who is first accused?
First accused
is PDO.
PDO.
This is second.
Second is the petitioner is the second accused. So ಅಲ್ಲಿ
any conversation
record ಮಾಡ್ಕೊಂಡಿದೀವಿ ಅಂತ ಹೇಳ್ತಾರೆ.
ಹಾಕಿದಾರಾ?
Have the file with me.
ಇದೆಯಾ? ಏನದು?
Pass on minutes.
ಕೊಡಿ. Regarding demand by this petitioner ಏನಾದ್ರು ಇದೆಯಾ?
ನಾನು pencil ಅಲ್ಲಿ mark ಮಾಡಿದ್ದೀನಿ, and there is a blue color flag.
ಪೆನ್ಸಿಲ್ ಅಲ್ಲಿ ಮಾರ್ಕ್ ಮಾಡಿದ್ರಲ್ಲ ಅದ?
ಆರೋಪಿ 2 ಇವರು petitioner.
ಆರೋಪಿ 2. ಅದಕ್ಕೆ ಅಲ್ವಾ ಅವರು ಆಟ ಆಡಿಸ್ತಿರೋದು ಬುಕ್ಸ್ ಎತ್ಕೊಂಡು ಇಟ್ಕೊಂಡು ಬಿಟ್ಟಳು. ಅವತ್ ನನ್ನ ಹತ್ರ ಇತ್ತು, ನಾನ್ ಎತ್ಕೊಂಡು ಹೋಗ್ತಿದ್ದೆ ಮನೆಗೆ, ನನ್ ಕಡೆನೆ ಕೊಡಿ ಅಂತ. ಇವಾಗ ನನ್ನ ಎತ್ಕೊಂಡು ಹೋಗ್ತಿರೋದು ನೋಡಿ ಕೊಡಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಇಸ್ಕೊಂಡ್ಬಿಟ್ರು. ಎಂತಾರಿದು?
Previous one also, previous page also.
ಅದೇ ನಾನು ಹೇಳ್ತಾ ಇರೋದು, ಕೊಡಲೇಬೇಡಿ, ಆಗೋ ಟೈಮ್ಗೆ ಎಲ್ಲ ಆಗ್ತಾ ಇದೆ ಅಂತ ನೀವು ಅರ್ಜೆಂಟ್ ಮಾಡ್ತಿದ್ದೀರಲ್ಲ. ಹಾ, ಡಿಮ್ಯಾಂಡ್ ಎಲ್ಲಿದ್ದಾರೆ ಕೊಡಿ ಅಂತ ನೀನ್ ಕೊಡ್ಬೇಕು ಕೆಲಸ.
Previous page, not
ಪ್ರೀವಿಯಸ್ ಪೇಜ್.
ಹೌದು.
ಏನಂತ ಆರೋಪಿ 2? ಅಯ್ಯೋ ನೀವು ಕೊಡೋದು ಬೇಡ, ನಾವ್ ಸುಮ್ನೆ ಯಾಕೆ ಬೇಡ ಅಂತ ನಾನು ನಾನು ಜೆರಾಕ್ಸ್ ಹಾಕ್ಸಿ ಕೊಡೋದು ಹೇಳ್ಬಿಟ್ಟು ಎಷ್ಟೊತ್ತೀವಿ ನೀವು ಸೈಲೆಂಟ್ ಆಗಿ ಇರ್ತೀರಾ ಅಂತ ಮಾಡ್ಕೊಂಡು ಎಂಟ್ರಿ ಮಾಡಿಸ್ತೀನಿ. ದುಡ್ಡಿಗೋಸ್ಕರ ಸಾಯ್ತಲ್ಲ ಅಂತ ಕೊಡ್ತೀರಾ. ಕೊಡೋದೇ ಬೇಡ ಅಂತ ಹೇಳ್ತೀನಿ ಅಂತ. ಇಲ್ಲಾಂದ್ರೆ ನನ್ ಕಡೆ ಕೊಟ್ಬಿಡಿ, ಅವ್ರಿಗೆ ಹೇಳಿ ಮಾಡಿಸ್ತೀನಿ. ಅವರಿಗೆ ಹೇಳ್ಬಿಟ್ಟು ಕೊಟ್ಬಿಟ್ಟು, ಯಾಕೆ ಅಂದ್ರೆ ಈಗ ಎಮ್ಗೆ ಫೋನ್ ಮಾಡಿದ್ದೆ ನಾನು. ಏನ್ ಕ್ರಮ ತಗೊಂಡ್ರಿ ವಿನೋದ್ ಗೌಡ್ರದು? ನಾನ್ ಮಾಡ್ತೀನಿ ಮಾತಾಡಿ ಅವ್ರಂತ ಅದೇನಂತ. ಇಲ್ಲ ಅವರು ಹಂಗೆ ಹೇಳ್ತಿರೋದು, ಹತ್ಬೇಕು ಅಂತ ಹತ್ಕೊಡು ಅಂತಾರೆ ಅಂತ. ನಾನೇನ್ ಮಾತಾಡ್ಲಿಲ್ಲ, ಸುಮ್ನೆ ಅದೇ. ನಾನು ಹೇಳ್ತಾನಲ್ಲ ಇರೋದು, ಕೊಡ್ಲೇಬೇಡಿ, ಆಗೋ ಟೈಮ್ಗೆ ಎಲ್ಲ ಆಗ್ತದೆ ಅಂತ
ಅವ್ರು ಹೇಳ್ತಾರೆ. ಆಮೇಲೆ ಕಂಟಿನ್ಯೂ ಮಾಡ್ಬಿಟ್ಟು ಈ ಕಡೆ ಪೇಜ್ ಅಲ್ಲೂ ಇದೆ, ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲೂ ಮತ್ತೆ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತಾರೆ ಕಾನ್ವರ್ಸೇಷನ್.
ಅವ್ನ್ ಡಿಮ್ಯಾಂಡ್ ಎಲ್ಲಿದೆ ನಾನು ಕೇಳ್ತೀನಿ. ಫೈನಲ್ ಈಗ ನನಗೆ ನನ್ ಜೊತೆ ಅಷ್ಟು ಹೇಳ್ಬಿಟ್ಟು ಹೋಗಿ ಹೊರಟೋಗಿದ್ದು, ಈಗ ಅದೇನ್ ಇದ್ ಮಾಡ್ತಾರೋ ಕೇಳ್ಬಿಟ್ಟು ಇಸ್ಕೊಳ್ಳಿ ಅಂತ ಹೇಳ್ತು. ಈಗ ನಾನ್ ಹೇಳಿದ್ದು ನಿಮಗೆ ಆಯಮ್ಮ ಕೇಳ್ತಿದ್ದೀನಿ ಅಂತ 1000 ಹೊರಗಡೆ ಒಪ್ಪಿಲ್ಲ. ಆಯಮ್ಮ ನೀವು ಎಷ್ಟು ಕೊಡ್ತೀರೋ ಅಷ್ಟು ಇಸ್ಕೊಂಡ್ ಬೇಕಾರ್ ಕೊಡ್ತೀನಿ. ನಾನ್ ಕನ್ವಿನ್ಸ್ ಮಾಡಿ ಅದನ್ನ ಬಿಟ್ಟು ಇನ್ನೇನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ ನನ್ ಕೈಲಿ. ಏನ್ರಿ ಫೋನ್ ಕಾನ್ವರ್ಸೇಷನ್ ಇದೆಯಲ್ಲ, ಕಂಪ್ಲೇಂಟ್ ಅಂಡ್ ಅಕ್ಯೂಸ್ ನಂಬರ್ 2
and kindly turn to page 30.
30 ಯಾವ್ದ್ರಲ್ಲಿ? ಇದ್ರಲ್ಲೇ 30 ನಾ?
ಇಲ್ಲ ಇಲ್ಲ, ಅದು ನಾನು ನೋಡೇ ಇಲ್ಲ. ಅದು
ಯಾವ್ದು?
ಕಾನ್ವರ್ಸೇಷನ್
ಪೇಪರ್ ಬುಕ್ ಹೇಳಿ.
ಕಂಪ್ಲೇಂಟ್ the complainant itself says
ನನ್ ಕೈಲಿ ಕೊಟ್ಬಿಡಿ ಅಂತ ಹೇಳ್ತಾ ನೀವು.
ಇಲ್ಲ ಇದೆ ಡ್ರಾಫ್ಟ್ ನ್ಯೂಸ್
30
ಅಲ್ಲಿ ಸೆಕೆಂಡ್ ಪ್ಯಾರಾಗ್ರಾಫ್. So this is the wordings that the complainant has reproduced what has been allegedly stated by the accused number 1. ಬಿಡಿಒರವರಿಗೆ 10,000 ಖಾತೆ ಬದಲಾವಣೆ ಮಾಡಲು ಕೊಡಬೇಕಾಗುತ್ತದೆ ಎಂದು ಹೇಳಿ ಸೆಕ್ರೆಟರಿ ಮೇಡಮ್ ಅವರು ನೀವು ಎಷ್ಟು ಕೊಡುತ್ತೀರೋ ಕೊಡಿ, ಮೇಡಮ್ಗೆ ತಲುಪಿಸ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಎಂದು ಹೇಳಿದ್ದಕ್ಕೆ ಬೇಡ ಬೇಡ ಸುರೇಶ್ ಕೊಡಬೇಕು, ಅನಿತಾಗೂ ಇದು ಮಾಡಬೇಕು, ಅನಿತಾನ ಹತ್ರನೇ ಕೊಡಿ ಅಂತ. ಸಪೋಸ್ there is any proximity, then there is no problem for that the accused number 1 to mention the name of the petitioner as well. Lord, because of the trap, the investigation insofar as the alleged grafting of money of 10,000 which was allegedly handed over to taken by the accused number 1 and 3 is over. Lord, what the prosecution is saying, they claim that only on the basis of the recorded version, that too even as per the version of the complainant, that forcibly she has taken rupees 2,000. Lord has gone through even what I have heard. There is no such demand by the petition number 2. For the time being, my lord,
2,000 ಡಿಮ್ಯಾಂಡ್ ಮಾಡಿ ಕೇಳಿದ್ದಾರೆ ಈ ಕನ್ವರ್ಸೇಷನ್ ಅಲ್ಲಿ.
ಮುಂಚಿನ
ಕನ್ವರ್ಸೇಷನ್ ಅಲ್ಲಿ ಎಲ್ಲಿದೆ? ಏನು ಇಲ್ವಲ್ಲ.
ಅದಿಲ್ಲ ಅಂತ ಇವರೇ ಒಪ್ಪಿದ್ದಾರೆ.
ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ ಪೇಜ್ ನಂಬರ್ 9 ಅಲ್ಲಿ ಆಫ್ ದಿ ಪೇಪರ್ ಬುಕ್. ಹೌದು, 7/5/22 ನಮಗೆ ಗ್ರಾಮ ಪಂಚಾಯತ್ is a complaint I am reading, unnumbered paragraph. ನಾನು ದಿನಾಂಕ 7/5/22 ನಾನು ಗ್ರಾಮ ಪಂಚಾಯತ್ ಕಚೇರಿ ಖಾತೆ ಬಗ್ಗೆ ಕೇಳಲು ಹೋದಾಗ ಅಲ್ಲಿನ ಸೆಕ್ರೆಟರಿ ಸೋ ಅಂಡ್ ಸೋ ಎಂಬುವರು ಖಾತೆ ಮಾಡಲು ಹಾಗೂ ನಮ್ಮ ಖಾತೆ ವಿಚಾರದ ತೀರ್ಮಾನ ಬಗ್ಗೆ
ಒತ್ತಾಯವಾಗಿ
ಪಿಡಿಒ ಮೇಡಮ್ ರವರು 10,000 ದುಡ್ಡು ಕೇಳ್ತಿದ್ದಾರೆ, ಅವರಿಗೆ ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಖಾತೆ ಮಾಡೋದಿಲ್ಲ ಎಂದು ಹೇಳಿದ್ರು. ಆದ್ರೆ ಅಲ್ಲಿ ನಾವು ಸ್ವಲ್ಪ
ಮಾಡಿಕೊಂಡು ಸಾಧ್ಯವಾಗಿರಲಿಲ್ಲ.
ಇದು 7/5 May 7.
That is 7/5.
7/5.
So this is the only allegation against petitioner.
But this conversation is that
ಅದನ್ನ ಈ 10,000 ರೂಪಾಯಿದು ಟ್ರ್ಯಾಪ್ ಆಯ್ತಲ್ಲ, ಅಲ್ಲಿಗೆ ಅದನ್ನ ರಿಲೇಟ್ ಮಾಡ್ತಾರೆ. And since the complaint was registered, ಇಲ್ಲ
ಇವ್ರು ಇರ್ಲಿಲ್ಲ.
In fact, they have targeted against the first and the third accused.
Third accused Malots is SDA with whom the illegal gratification.
ಅವ್ರು ಹೇಳಿರೋ ಸ್ಟೇಟ್ಮೆಂಟ್ ಪ್ರಕಾರನೂ ಕೂಡ ಇಲ್ಲಿ at least ಇವ್ರ ಹೆಸರಾದ್ರೂ ಬಂದಿದೆ ಅಂತ.
ಈ ಕನ್ವರ್ಸೇಷನ್ ಯಾವತ್ತಿಂದಿದು?
7/5
ಇದಾ 7/5 ರೆಕಾರ್ಡ್ ಮಾಡಿಲ್ಲ. ಈಗ ನೀವು ಓದಿದ್ರಲ್ರಿ?
ಹೌದು, ಅದ್ರಲ್ಲಿ ಫಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲೇ ಇರುತ್ತೆ ಮೇಲ್ಗಡೆ.
1/6
ಇಲ್ಲ 19/5 ಅಂತ ಹೇಳ್ತಾರೆ.
19/5
ಅಂತ ಇಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ.
ಕನ್ವರ್ಸೇಷನ್ ಕೊಡ್ಬೇಡ, ಆಗೋ ಟೈಮ್ಗೆ ಆಗ್ತದೆ, ನೀವು ಅರ್ಜೆಂಟ್ ಮಾಡ್ತಿದ್ದೀರಲ್ಲ ಅಂತ ರಿಪ್ಲೈ ಮಾಡ್ತಾನೆ ಅವನು. ಕೇಳ್ಬಿಟ್ಟು ಇಸ್ಕೊಂಡ್ಬಿಟ್ಟು ಆಳ್ತಾರ, ಕೇಳ್ಬಿಟ್ಟು ಇಸ್ಕೊಳ್ಳಿ ಅಂತ ಹೇಳ್ತೀವಿ. ನಾನು ಏನ್ ಮುಸ್ಲಿಮ? ಅವ್ನ ಲ್ಯಾಂಗ್ವೇಜ್ ಎಲ್ಲ ನೋಡಿ ಹಂಗಿದೆ. ಇಮ್ರಾನ್, ಇನ್ನೊಬ್ಬ ನರಸಿಂಹಮೂರ್ತಿ. ಈಗ ಯಾರು ಪಿಟಿಷನರ್ ನಂಬರ್ ಯಾರು? ಪಿಟಿಷನರ್ ಗುಣಶೀಲನ?
ಸೆಕೆಂಡ್ ಅಕ್ಯೂಸ್. ಇಲ್ಲಿ ಪಿಡಿಒ ಸ್ಟೇಟ್ಮೆಂಟ್ ಪ್ರಕಾರನೂ ಕೂಡ ಈಕೆ ಹೆಸರಿಲ್ಲ. ಅನಿತಾ ಮತ್ತೆ ಜಗದೀಶ್ ಅಂತ ಇವ್ರ್ಯಾರು ದೇ ಆರ್ ನಾಟ್ ದಿ ಅಕ್ಯೂಸ್ಡ್.
ಮಾತಾಡಿ ಮೇಡಮ್ ಫೈನಲ್ ಆಗಿ ಏನಾದ್ರು ಒಂದು ಡಿಸಿಷನ್ ಗೆ ಬನ್ನಿ, ಕೊಡಿ ಅಂದ್ರೆ ಕೊಡಿ, ಪಟಾಪಟ್ ಸುಮ್ಮನೆ ಹೇಳ್ಕೊಂಡು ಹೋಗೋದು. ಫೈನಲ್ ಈಗ ಅಯ್ಯಮ್ಮ ನನ್ಗೆ ನನ್ ಜೊತೆ ಅಷ್ಟೇ ಹೇಳ್ಬಿಟ್ಟು ಹೊರಟೋಗಿದ್ದು, ಈಗ ಅದೇನು ಇದ್ ಮಾಡ್ತಾರೋ ಹೇಳ್ಬಿಟ್ಟು ಇಸ್ಕೊಳ್ಳಿ ಅಂತ ಹೇಳ್ತು. ಈಗ ನಾನು ಹೇಳಿದ್ದೆ ನಿಮ್ಗೆ, ಅಯ್ಯಮ್ಮ ಕೇಳಿದ್ದೀನಿ, 10,000 ಕೂಡ ಕೊಡ್ಲಿಲ್ಲ. ಅಯ್ಯಮ್ಮ ನೀವು ಎಷ್ಟು ಕೊಡ್ತೀರೋ ಅಷ್ಟು ಇಸ್ಕೊಂಡು ಬೇಕಾದ್ರೆ ಮಾಡ್ಕೊಡ್ತೀನಿ, ನಾನ್ ಕನ್ವಿನ್ಸ್ ಮಾಡಿ ಇನ್ನೇನ್ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ ತನ್ನ ಕೈಲಿ. ಅಷ್ಟೇನಾ?
They have to cooperate with the investigation. Second, insofar as accused number 2, the application is rejected and one petition is pending, 439, that is under 570.
438 was rejected.
ಹೌದು.
A2 was whether he was present at the time of trapping?
A2 was not. He was not.
He was not there. This petitioner was also not there.
A2 is a petitioner here.
Right,
Number
A2.
2 is
Petitioner is A2. A1 and A3.
A1 and A3. A1 is
Petition filed under section 439 ಯಾರ್ದ್ರಿ? One he was also not present at the time of trap.
She was there. She was present at the time. We have arrested.
But how 438 was filed? 439 is pending. 439 is pending. A1 while accepting the amount, the A1 was apprehended.
Yes.
ಹೌದಾ?
A1 and A3.
A1 and A3. A3 was also present at that time. This petitioner was not present at the time of the trap. So, not the petitioner counsel and also the counsel appearing for the state. ಎಷ್ಟು ಅಮೌಂಟ್? 10,000. 10,000.
ಅವರಿಬ್ಬರಿಗೆ 10,000.
ಅಲ್ಲ, ಅವ್ರು 10,000 ಇದ್ದಾಗ
10,000 ರೂಪಾಯಿ.
The factual matters of the case of the prosecution is that in order to correct the khata entered in Baigur Grama Panchayati, ಅಕ್ರಮ ಖಾತೆ ಮಾಡಿ ವಜಾಗೊಳಿಸಿ ಮೂಲ ಖಾತೆ ಮತ್ತು ಖಾತೆಯನ್ನು ಮಾಡಿ.
A resolution was passed by the panchayat to restore the khata into the name of the father of the complainant. So for restoration, the demand was placed.
The factual matters of the case of the prosecution is that in order to restore the khata, demanded an amount of rupees 2,000 as advance and an amount of rupees 10,000 payable to PDO, and also demanded an amount of rupees 10,000 And the same is against the accused number 1, PDO. In the complaint, an allegation is made that this petitioner had collected an amount of rupees 2,000 forcibly in order to write the same in a resolution book. But there is no any conversation between the complainant and this petitioner. And that on 19/5/2022, this petitioner expressed that already spoken to the PDO, and PDO did not agree for receiving a less than amount of rupees 10,000. And also he demanded whatever the amount he gives, he will give the same to her. And the same is recorded in the mobile. That on 25/5/22, he went and met the PDO. And demanded whatever the amount he gives, the same will be given to the madam. And also he expressed that amount also to be paid to the Suresh. And hence told that to give the amount with Anita. And PDO also told that the same was told in the 2 days back itself. And PDO also agreed for an amount of rupees 10,000. And the same is also recorded in the mobile. And hence, we note the and later trap was committed, the trap was held, and accused number 1 and 3 were arrested. And this petitioner is seeking an anticipatory bail. The counsel appearing to the petitioner would submit that no material against this petitioner, and this petitioner has not demanded any money. And also the complainant says that with regard to the 7/5/22 conversation, no material. And subsequently on 19/5/22, regarding payment is concerned, bargained with the complainant. And when this petitioner was not present at the time of conducting the trap, and only based on the conversation found in the phone, and the same is also not clear, and hence the petitioner is entitled for anticipatory bail. For counter, the counsel appearing for the statement submits that there is a conversation between. Special counsel submits that there is a conversation between the complainant and also this petitioner regarding payment of money, and he also claims that to hand over the money to her, and she would repay the amount to the PDO. And also he says that the PDO told her to collect the amount, and hence he demanded money, and replied that he would convince the madam. And he can convince only, except that he can't do anything. And hence there is a clear demand to pay the money. Having heard the respective counsel and also on perusal of material, A1 and A3 were trapped while accepting the bribe amount. And this petitioner was not present at the time of the trap. And the prosecution mainly relying upon the conversation between the complainant and this petitioner. And also on perusal of the conversation, this petitioner also mentioned that not to pay any amount, but you are making urgency. And the same would be done as usual. And we said conversation is also found in the said conversation between the complainant and also the accused. And also on perusal of the conversation between accused number 1 and 2, there is no any material with regard to the he demanded and accepted an amount of rupees 2,000 earlier. But the discussion is with regard to payment of amount in favor of the PDO. And when such being the case, it is appropriate to enlarge the petitioner with conditions to cooperate with the IO for the investigation in the matter.
Take back the investigation papers. May I take back the investigation?
You can take that. Take that. Whatever. M. Shivaprakash. 354A, 506, 504.
Public time.
Okay.
Enter charge sheet.
Huh?
Enter charge sheet.
Petitioner counsel 6. Time to place the entire charge sheet materials. And then this matter on 18th. Raju CN. A2, A3. 399, 402. Any criminal antecedents idea? Admel one matra. Here dilwa. Thought. Henry. Heard the petitioner counsel and also the counsel appearing for the state. The factual matters of the case of the prosecution that this petitioner. Here or idara? Openena. And accused number 2 and 3. These 2 petitioners along with accused number 1 ಮೂರೇ ಜನವಾ or making or making preparation to commit the dakaiti. And other 3 persons were also there and they were having the long and knife. And hence case has been registered and matter is under investigation. The counsel appearing to the petitioner would submit that no any criminal antecedents against the petitioner and also an allegation is that they were making preparation to commit the dakaiti. And subsequently after registration of this case, one more case is registered against this petitioner and the same is also a false implication. And hence he may be enlarged on bail. For counter, the counsel appearing to the state would submit that on this petitioner along with other accused persons making preparation to commit dakaiti along with deadly weapons. And also one more case has been registered. Having heard the respective counsel and also on perusal of material, allegation is that they are making preparation to commit the dakaiti. And also not disputed, one more case has been registered and the said crime is number 187 back. But is that ಇನ್ನೂರ ಒಂದಿದೆ ಇದು 201 ಇದೆ ಅಂದೆ.
ಆದ್ಮೇಲೆ ಮುಂಚೆ ಮಾಡಿದ್ರು ಅಂತ ಹೇಳಿ
ಇದಾದ್ಮೇಲೆ
ಅರೆಸ್ಟ್ ಮಾಡಿದ್ಮೇಲೆ ದೇವರ್ ಇನ್ವಾಲ್ವ್ಡ್ ಇನ್ ಅದರ್ ಅಫೆನ್ಸ್ ಅಲ್ಲಿ ಇವರೇ ಮಾಡಿದ್ದಾರೆ.
ಬಟ್ ಆ ಕ್ರೈಮ್ ಆಲ್ರೆಡಿ ರಿಜಿಸ್ಟರ್ ಆಗಿತ್ತು.
ಅದಾಗಿರೋ ಸ್ವಾಮಿ 7/6/22.
ಅದೇನದು ಮತ್ತೆ ನೀವ್ ಹೇಳಿ ಸಬ್ಮಿಷನ್ ಕರೆಕ್ಟ್ ಅಲ್ವಾ? ಈ ಕೇಸ್ ಆದ್ಮೇಲೆ ಇನ್ನೊಂದು ಕೇಸ್ ಆಗಿದೆ ಅಂತ ನೀವ್ ಹೇಳಿ. ಏನಾಯ್ತು ಮೇಡಮ್? 187 of 2022 and present case is 201 of 22. And counsel submits that after registration of this case in the old case, this petitioner has been implicated. And having taken note of the setback and apart from that, an attempt is made to commit the dakaiti and hence it is a fit case to enlarge him on bail with a condition not to indulge in similar offences in future. We have the discussions made up by pass along order allowed with conditions or on condition cancellation for bail in case of any similar offences committed in future. 54 Renspree Pritesh Pisoja 307 or 328. Poisoning, forcible administering.
Father administered poison to son.
Father. Oh, ಏನಾಯ್ತು ಆಮೇಲೆ?
ಏನಾಗಿಲ್ಲ ಬದುಕಿದೆ. He himself consumed the poison and also administered the poison to the son.
He also. Father also consumed and for son also he
administered.
Why? What is the reason?
Dispute between husband and wife, my lord. Charge sheet has been filed, my lord. Now, age number 32, charge, my lord.
Because of dispute between husband and wife, he also made an attempt to commit suicide as well as he administered poison to the son also. Page number
32 ಅಲ್ಲಿ charge sheet.
ಎಷ್ಟು ದಿವಸದಿಂದ ಇದನ್ನ ಒಳಗಡೆ
Lord, arrested on my lord 14/10/2021.
ಮಗು ಬದುಕೊಂಡ ಮಗ
ಎಲ್ಲ ಬದುಕಿದೆ.
ಎಷ್ಟು ದಿವಸ ಇದ್ದ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ?
2 ದಿನ ಮಗು, 2 ದಿನ ಇವನು 1 ದಿನ.
Not the petitioner counsel and also the counsel appearing for the state. The case of the prosecution is that this petitioner married 11 years ago and in the said wedlock, and he developed and he is having the habit of consuming ಏನ್ರಿ ಇದು ಡ್ರಗ್
ಅಮಲು ಪದಾರ್ಥ.
ಅಮಲು ಅಂದ್ರೆ ಡ್ರಗ್
ಡ್ರಗ್ ಅಲ್ಲ, ಹಳ್ಳಿ ಔಷಧ. ಶರಾಬ್ ಇರ್ಬೋದು.
ಅಮಲು ಅಂದ್ರೆ
ಅಮಲು ಪದಾರ್ಥ.
ಏನದು? habit of consuming the intoxicated substance, and the same was increased from last 2 to 3 years, and he quarreled with his wife, that is CW1, and that on 5/10/21 with the influence of the intoxication he came to house and he also consumed the poisonous juice, and in order to commit the murder of his son, ಯಾರು ಇಬ್ರುನಾ?
ಇಬ್ರಲ್ಲಿ ಒಬ್ಬ ಕುಡಿಲಿಲ್ಲ.
ಚಾಸ ಇದು ಮತ್ತು 600
ಒಬ್ಬ ಕುಡಿಯೋದಿಲ್ಲ ಅಂತ ಹೇಳಿದ. ಸಣ್ಣ ಮಗುವಿಗೆ
murder of 2 children, he gave the said poisonous juice, and one and CW5 was accused to consume the same, but CW6 was forcibly administered to CW6 forcibly administered and made an attempt to take away the life of his son. ಅವನು ಸನ್ನೇನಾ? ಅವನು ಸನ್ನೇನಾ ಅಂದೆ.
ಹೌದು, ಇಬ್ರು ಮಕ್ಕಳು. ದೊಡ್ಡವನು ಕುಡಿಯೋದಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾನೆ, ಸಣ್ಣವನಿಗೆ ಕುಡಿಸಿ ನಂತರ ಇವನು ಕುಡಿತಾನೆ.
This petitioner also made an attempt to consume, also commit suicide, and also under the allegation is that under the influence of intoxicated substance he made an attempt, and he took treatment for 2 days, and the son also took treatment for 1 day, and both of them are out of danger, and the allegation is also that he quarreled with his wife, then took the extreme step. Hence he may be unlocked and bail. Per contra, the counsel appearing to the state to submit that not only he consumed the poisonous juice, but he also made an attempt to administer the same to his sons, and out of that one son consumed the same, and though he was out of danger, but an attempt was made to take away the life. Then there is a prima facie case. Having heard the respective counsel and also on perusal of material, an allegation is that this petitioner not only consumed the poison and made an attempt to take away the life of a son also, and both of them are out of danger, and this petition is filed on 439 of CRPC, and this petitioner is in custody from the date of arrest. 14/10/21 and taking into note of investigation already been completed and charge sheet is also filed, and both of them are out of danger. It is a case to exercise the powers of 439 of CRPC with condition. Prasad, yes. 406 420. ಯಾರು ಶಿವಪ್ರಸಾದ್ ಬರ್ತಾನೆ ಇಲ್ಲ ಅಪೇರ್ ಆದ್ರ? ಹೌದಾ? ತಗೊಳ್ಳಿ. Petitioner counsel is absent, list this matter, and one more opportunity is given, list this matter on 18th. 56 Jagdish Baliga.
406 420 and 21 of Birth Act. 10 FIR has been registered on the similar offences. 10 ಹೌದು. 4ರಲ್ಲಿ ಬೇಲ್ ಆಗಿದೆ, 1ರಲ್ಲಿ ರಿಜೆಕ್ಟ್ ಆಗಿದೆ. ಮನೆ ಬಾಡಿಗೆಗೆ ತಗೊಂಡು ಬೇರೆಯವರಿಗೆ ಮನೆ ಬಾಡಿಗೆ ಕೊಡ್ತಾ ಇದ್ರು. Unfortunately, he could not get vacated or repaid the advance amount. Then one after another, the complaints came to be filed. Since 8 months, he is inside. In this particular case, he is inside from 6/6/2022. ಇದು ಒಂದನ್ನ
10 ಕೇಸಲ್ಲಿ 5ನೇ ಕೇಸಲ್ಲಿ ಬೇಲ್ ಆಗಿಲ್ಲ,
ಇನ್ನು 5
ಕೇಸಲ್ಲಿ ಆಗಿದೆ. ರಿಮೈನಿಂಗ್ ಏನ್ 5 ಕೇಸಲ್ಲಿ
ರಿಮೈನಿಂಗ್ ಅಲ್ಲಿ ಆಗಿಲ್ಲ. ಅದೀಗ ಬರ್ತಾ ಇದೆ, ಇನ್ನು ಅರೆಸ್ಟ್ ಆಗಿಲ್ಲ.
ಅಂದ್ರೆ ಇವನ್ habitual ರೀ.
ಅಲ್ಲ habitual ಅಲ್ಲ, ಈ ಕಂಪನಿ ಅವರು ಏನ್ ಮಾಡ್ತಾರೆ ಅಂದ್ರೆ ಬೇರೆಯವ್ರ ಹತ್ರ ಬಾಡಿಗೆ ಔಟ್ ಸ್ಟೇಷನ್ ನಲ್ಲಿ ಇರೋರ ಹತ್ರ ಬಾಡಿಗೆ ತಗೊಂಡು ಬೇರೆಯವರಿಗೆ
ಈವ್ನಿಂಗ್ ಮಾಡಕ್ ಸಬ್ಲೆಟ್
ಬಾಡಿಗೆ
ಸಬ್ಲೆಕ್ಟ್ ಮಾಡೋದು ಬೇರೆಯವ್ರಿಗೆ
ಕೊಡೋದು. ಅಲ್ಲ 40,000 ಕೊಟ್ಟಿದ್ದಾರೆ. ಇದು ಇದರಲ್ಲಿ 40,000 3-4 ತಿಂಗಳು ಆ ಟರ್ಮ್ ಲೀಸ್ ಟರ್ಮ್ ವರೆಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ.
438
39
ಒಳಗಡೆ
6 ಇಂದ ಈ ಕೇಸಲ್ಲಿ 6 ಇಂದ
ಬಿಟ್ರೆ ಮತ್ತೆ ಅದೇ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತಾರೆ.
ಇಲ್ಲ ಕಂಟಿನ್ಯೂ ಮಾಡೋದು. ಈಸ್ ಅನ್ ಎಂಪ್ಲಾಯ್ ಆಫ್ ಇನ್ಫೋಸಿಸ್.
ಮತ್ತೆ ಆ ಕೆಲಸ ಬಿಟ್ಟಿದ್ದ
ಏನೋ ಗ್ರಾಚಾರ ಮಾಡಿದ್ರು, ಗ್ರಾಚಾರಕ್ಕೆ ಮಾಡಿದ್ರು, ಏನೋ ಬೇರೆ ಸ್ಕೀಮ್ ಅಲ್ಟಿಮೇಟ್ಲಿ ಇಟ್ ಫೇಲ್ಡ್. ಅದಕ್ಕೆ 21 ಆಫ್ ಬರ್ಡ್ಸ್ ಆಕ್ಟ್ ಹಾಕಿದ್ದಾರೆ.
ಏನಾಗಿ ಕೆಲಸ ಮಾಡ್ತೀನಿ ಇನ್ಫೋಸಿಸ್? What is his designation in Infosys?
ಇನ್ಫೋಸಿಸ್ ಅಲ್ಲಿ ಆಫೀಸರ್ ಆಗಿದ್ದಾರೆ.
10 ಕೇಸ್ ಆಗಿ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ಮೇಲೆ ಅವ್ನು ಕೆಲಸದಿಂದ ತೆಗ್ದಿಲ್ವಾ ಇನ್ಫೋಸಿಸ್?
ಇನ್ನೂ ತೆಗ್ದಿಲ್ಲ. ಇವಾಗ ಯಾಕಂದ್ರೆ ನೋಟಿಸ್ ಸರ್ವ್ ಆಗಿರಲ್ಲ.
It may result also.
ಅಲ್ಟಿಮೇಟ್ಲಿ ವಿಲ್ ಅದಕ್ಕೆ
39 crore
39 crore ಅಲ್ಲ
ಹೊರಗಡೆ.
ಇಲ್ಲ 39 crore ಇಲ್ಲ, 2 crores ಅಂತ ಹೇಳ್ತಾರೆ.
2 crores are ಕಡಿಮೆ
ಅಲ್ಲ ಕಡಿಮೆ ಅಲ್ಲ. ಅದಕ್ಕೆ ಆ ರೀಸನ್ಗೆ ಈ ಲರ್ನರ್ ಸೆಷನ್ ಜಡ್ಜ್ ರಿಜೆಕ್ಟೆಡ್ ದಿ ಬೇಲ್ ಅಪ್ಲಿಕೇಶನ್. ಲಾಸ್ಟ್ ಮೈ ಕೈಲಿ ಸಿ ಪೇಜ್ ನಂಬರ್ 33
ನಲ್ಲಿ ರೀಸನ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ರೀಸನ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. 13 ಜನರಿಗೆ
rupees 59 lakhs 59,000 on receiving monies. They have invested
2,59,000.
It also stated that the money to various other accounts, and there is evidence to show that number 1 Supreme Mora had transferred money to Santipe India Sales and Marketing.
ಇದ್ರಲ್ಲಿ ಆಗಿಲ್ಲ, ಬೇರೆ 2 ಕೇಸಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ. A2 ಮತ್ತು 3 ಜೊತೆ ಸೇರ್ಕೊಂಡು ಕಂಪನಿ ಮಾಡಿದ್ರು.
A2 3 ಜೊತೆ ಸೇರ್ಕೊಂಡು ಕಂಪನಿ ಬೇರೆ ಮಾಡೋಣ.
ಅಲ್ಲ ಕಂಪನಿ ಮಾಡಿದ್ರಿಂದ ಇಷ್ಟೆಲ್ಲ ಪ್ರಾಬ್ಲಮ್ ಆಗುತ್ತೆ.
359 people told what the petitioner counsel and also the counsel appearing to the state. The factual matters of the case of the prosecution is that this petitioner had indulged in cheating the general public, taking the premises for lease, taking the premises for rental purpose and leasing the same for and the said premises is leased for the prospective lessees, and in all he had indulged in cheating the general public more than crores of rupees. Also it is prosecution that there are 10 cases against this petitioner, and now he is in custody in this case of, if he is released he would then he cheated 359 persons and more than crores. Hence matters of investigation matters of investigation. Cases are registered. This case this case petition has been rejected. And he is an employee of Infosys. He is having permanent abode and he may be enlarged on bail. Enlarged on bail. For contra, the counsel appearing for the state to submit that he has cheated 13 people and have issued more than rupees 2 crores 59 lakh 59,000 and receiving monies. And they have invested somewhere else. And this petitioner is the main accused who, along with other two accused persons, indulge in such acts and hence is not entitled for bail. The council also would submit that totally 359 persons were cheated by this petitioner and hence if he enlarged on bail, there is a chances of committing similar offences. Having heard the respective counsel and also on perusal of material, particularly 10 cases are registered against this petitioner and the same is also not disputed by the petitioner. And counsel also would submit that in 4 cases he has been enlarged on bail, but in this case also the trial court has rejected bail petition and taking into note of the specific allegations against this petitioner that he had indulged in taking the premises for rental purpose and in turn the same is also leased for getting lakhs of rupees from the lessees. And matter is under investigation and when such being the specific allegation is made against this petitioner that he had indulged in committing fraud on the general public, it is not a fit case to exercise the powers at this juncture unless investigation has been completed. In the investigation ಆಗಿಲ್ಲಲ್ಲ
ಅಲ್ಲ ಇದರಲ್ಲಿ ಆಗಿಲ್ಲ ಬೇರೆದ್ರಲ್ಲಿ ಎರಡರಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ.
Our liberty is given to the petitioner to approach this court after filing of the charge sheet. 57 RB Deshpande. Connected ಅಲ್ಲಿ
1, 3, 5, 6 and 4 ಮೇಲೆ last I also produced that document.
ಆಗಿದೆಯಾ ಸೇಮ್ ಪೇಜ್ ಇದರಲ್ಲಿ ಇದೆಯಲ್ಲ 4668 of 2022 ಇದು ಎಷ್ಟನೇ ಅವನಿಗೆ ಅಕ್ಯೂಸ್ ನಂಬರ್
Number 8 madam. Number 8 madam.
ಇದು 8 4688 ಆಗಿರೋದು ಯಾರಿಗೆ 4668 of 22
4688 madam 1
ಕಾರ್ತಿಕ್ ಬನ ನರಸಿಂಹನ್ 135 and 6 ಓಕೆ ಮೇಡಮ್ ಅದು ಗೊತ್ತಲ್ಲ 135 6 ಅಂದ್ರೆ enlarged on bail in 5219 ಅಲ್ಲಿ
number 4 madam.
Number 4 and also similar allegation is made against this petitioner.
No recovery.
No recovery. Allowed with conditions. 60 Pradeep HS. ಇವ್ರ ಮೇಲೆ ಏನು ಅಲಿಗೇಷನ್ ಅವನಿಗೆ ಓನ್ಲಿ ಇನ್ಸ್ಟಿಗೇಷನ್ ಅಂತ A1 ಗೆ ಹೊಡೆದಿರೋದೇನ್ರಲ್ಲಿ ಇವರು ಪ್ರೀವಿಯಸ್ ಇಂಜುರಿ
27/5 ಗೆ ಡಿಸ್ಚಾರ್ಜ್ ಆಗಿದ್ದಾರೆ
27/5 ಗೆ ಆಗಿದ ಇನ್ಸಿಡೆಂಟ್ ಯಾವಾಗ 23/5 ಆಯ್ತು ಇಂಜುರೀಸ್ ಏನು ಎಲ್ಲರೂ ಇಷ್ಟು ಜನನು ಈಗ ಒಳಗಡೆ ಇದಾರ ಲ್ಯಾಸೋರೇಷನ್
No criminal accidents malady.
Metatarsus and the same is not on the vital part and custody ಇದಾರಲ್ರಿ ಅವರು ಎಷ್ಟು ದಿವಸದಿಂದ 27/5 27/5 ಇಂದ ಇದಾರೆ ನೋಡಿ heard the petitioner counsel and also the counsel appearing to the state. The factual matters of the case of the prosecution is that accused number 1 and complainant were friends about 2 years back. ಇದನ್ನ ಹಾಕೋಬಿಡಿ ಮೇಡಮ್ paragraph number 2, 3. Counsel appearing to the petitioner would submit that these petitioners are read as accused number 2 to 5. And allegation that they have assaulted with weapon entry with the chopper. And at the instance of accused number 1, these petitioners have subjected the injured persons to injured person to take away his life. Further, the council appearing to the state would submit that the wound certificate clearly discloses that injury number 2, 3, 6, and 7 are grievous in nature and other injuries are simple in nature, and also contend that these petitioners have inflicted the injury at the instance of accused number 1. The council appearing to the petition would submit that already accused number 1 enlarged on bail in 5480 of 2022. For reply to the argument, counsel submits that he was not at the scene of occurrence. Hence, this court granted bail. Having heard the respective counsel and also on perusal of material, the history also clearly discloses that assault by unknown persons, and only allegation against the petitioner is that, at the instance of this petitioner, the assailants came and assaulted the complainant. The injured is out of danger, and though some of the injuries are grievous in nature, certain factors were found in material, and the same is not on the vital part. And taking note of the same is not on the vital part, this court exercises the discretion. And here also the allegation against these petitioners that they inflicted injury. And also recovery was made. And apart from that, incident was taken place on 23.
In the previous day, the wife of the petitioner was left the house. They came to the house, my lord, for the death ceremony of the my lord, to attend the funeral of the my lord, the mother of the petitioner. A complete copy, my lord, in page number 10.
Pin 11, typed copy.
Typed copy in page number 12. ಹನ್ನೆರಡು ವರ್ಷ ಆಗಿದೆ ಮದುವೆಗೆ, ಮಕ್ಕಳಿಲ್ಲ.
Groaning. Any proximity to cause of death? Hospital ಅವತ್ತಿನ incident ಆ ತರದ್ದು ಏನು ಇದ್ದಾಗಿಲ್ಲ. And also all of them went to attend the ಯಾರದು she was missing. Not the petitioner of counsel and also the counsel appearing to the state. The factual matters of the case of the prosecution based on the complaint of the brother of the victim, Maudala?
Yes,
brother of the victim, stating that the victim marriage was solemnized with this petitioner 12 years ago. And even after the marriage, this petitioner subjecting her for both mental and physical harassment. That on 24/3/22, at around 7 a.m., father-in-law made the phone call and informed that Ratnamma is passed away. And his father was not keeping good health, and hence his uncle and relatives went to Marnanahalli village And in the meanwhile, the sister of the victim was also missing. And they revealed that they left the house quarreling with them. And thereafter, missing complaint was given, and on the next day, found the dead body. And hence case is registered against the petitioner. The counsel appearing to the petitioner would submit that there is no any proximity to cause of death. And hence offense under section 306 is not attractable, attracts. And also other allegation is subjected her for both mental and physical harassment, but marriage was solemnized 12 years ago. Children ilva? No issues. And the reason may be the reason for her death also because there was not having any issues. And the allegation has to be probed, and petitioner is ready to obey the conditions. For account of the counsel appearing to the state to submit that no any death note, but he left the house quarreling with the petitioner, and in the complaint the same is mentioned. And matter requires to be probed, and hence presence of the petitioner is required. Having heard the respective counsel and also the perusal of material, marriage was taken place 12 years ago, and also no issues for both the husband and wife. When suspending the material available on record and in order to know 306 of IPC, there must be a proximity to cause of death and taking extreme step of committing suicide. And when such being the material on record, it is which case to exercise the powers of 438 of CRPC with conditions. Remaining amount, remaining ಎಲ್ಲ next week ಅಥವಾ ಈ ವಾರದಲ್ಲೇ ಕೊಡೋಣ. 63 day after tomorrow. Tomorrow ಇಲ್ಲ ಲಿಸ್ಟ್ ಆಗ್ಬಿಟ್ಟಿರುತ್ತೆ. ಆಗಿದೆಯಾ ಆಗಿದೆಯಾ ಕೊಡಿ ಅದೇನು ಆರ್ಡರ್ ಶೀಟ್ ಇದೆಯಾ ಆರ್ಡರ್ ಇದೆಯಾ ಆರ್ಡರ್ ಕಾಪಿ ಇದೆಯಾ 5398 ಡೇಟ್ ಹೇಳಿ ಬರ್ಕೊಳ್ಳಿ ಮೇಡಮ್ 5398 ಡೇಟ್ ಆರ್ಡರ್ ಕಾಪಿ ಇಲ್ಲ ನಾವೇ ನೋಡೋಣ ಏನ್ರಿ ಕೊಟ್ಟಿದೀವಿ ನಾವು ಇವನ್ ಜೊತೆ ಇರ್ತಾನೆ ಅವನ ಜೊತೆ ಆಯ್ತು allowed with conditions. One is Syed Akbar Pasha. ಯಾವತ್ ಬೇಕ್ರಿ day after tomorrow or ಯಾವತ್ ಬೇಕು 14th. List this matter on 14th. H.V. Manjunath ನಿಮ್ದು ಯಾವತ್ ಬೇಕು ಆಯ್ತು ನಾಡಿದ್ದು ನೋಡೋಣ 303 ಇದೆ 13th ಆಗ್ಬೋದಾ 13th 66 ಭೋಜರಾಜ ಯಾವತ್ ಬೇಕು ನಾಡಿದ್ದು 13th 67 ದಯಾಮಣಿ 13th ಮೇಡಮ್ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಇವತ್ತು ಆಗ್ಲೋಡಿ ಲಿಸ್ಟ್ ಹಾಕೋಬಿಟ್ರತ್ ನಾಳೆ ನಮ್ದು 14th ಬೇಕಾ 14th ಫಸ್ಟ್ ಅವರ್ ಬೇರೆ ಇದೆಯಾ ಎಲ್ಲ ಡೇಟ್ ಫಸ್ಟ್ ಅವರ್ ಎಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಏನು ಹೇಳಿದ್ರಲ್ಲ ಇದ್ರಲ್ಲೇನು ಕಾಸ್ಟ್ ಕೊಟ್ರ ಬಂದ್ರ ಇಲ್ಲ ಇಲ್ಲ ವಿಶ್ವನಾಥ್ ಕೆ ನಾನ್ ಪೇಮೆಂಟ್ ಆಫ್ ಕಾಸ್ಟ್ ಆಫ್ rupees 500 ತಗೊಳ್ಳಿ ದಿಸ್ ಮ್ಯಾಟರ್ ಇಸ್ ಲಿಸ್ಟೆಡ್ 4th time and earlier occasion urgent on cost of rupees 500 and cost also not paid and also not complained hence and this matter is called twice even at 4:48 PM no representation and hence petition is dismissed for non prosecution. Next ಏನಾಯ್ತು ಮೇಡಮ್ ಏನಾಯ್ತು ನಿಮ್ದು 13 ಏನಾಯ್ತು ರಿಯಾಜ್ ಪಾಷಾ ಕಾಸ್ಟ್ ಕಟ್ಟಿದಿರ the council submit that he has paid the cost of rupees 2500 ಈಗ ಎಷ್ಟು ಕಟ್ಟಿದಿರ್ರಿ ನೀವು 500 ಫಸ್ಟ್ ರೆಡ್ಯೂಸ್ ಮಾಡಿಸ್ಕೋಬೇಕು ಹಂಗಾಗೋದಿಲ್ಲ 9ನೇ ಮ್ಯಾಟ್ರ್ ಬಂದಿರೋದು 9ನೇ ಸರಿ 9 ಸರಿ ಕೋರ್ಟ್ ಮುಂದೆ ಹೌದು ಮತ್ತೆ ನೋಡ್ಬೇಕಲ್ಲ 500 ಓನ್ಲಿ ಥರ್ಡ್ ಟೈಮ್ಗೆ ಇದು 9ನೇ ಸರಿ ಎಲ್ಲ ಒಂದೊಂದ್ ಸರಿ 500 ರೂಪಾಯಿ ಏರ್ತಾ ಹೋಗ್ತದೆ ನೀವು ಯಾವಾಗ ತಗೊಳ್ಳಿ council submit that by mistake he paid the cost of rupees 500 and ತಗೊಂಡಿರಿ and he would pay the amount within 3 days and also would okay comply ಬೇರೆ ಮಾಡ್ಬೇಕಲ್ಲ And 6, 1 week time to pay the balance cost and also to comply with the office objection, and hence list this matter on 18th. Next Monday, ಅಷ್ಟೊಳಗೆ ಕಟ್ಟಿ ಮಾಡ್ಕೋಬೇಕು. Right, 19th. The told petitioner counsel is absent and earlier occasion also absent. However, in the end of justice, one more opportunity given. This matter on 18th. If counsel doesn't appear, matter petition will be dismissed for non-prosecution. 28th. ಚಕ್ರವರ್ತಿ ಯಾವಾಗ ಬೇಕ್ರಿ? 2 days. ಲಿಸ್ಟ್ ಮಾಡಿ 13th. Due to paucity of matter was passed over at the first instance and in the evening not reached. And this matter on 13th. Apoda? 35. Agree, Shecha. Bardella. Petitioner counsel is absent. Last time in 30? 35, yeah. And earlier occasion also petitioner take time. And then urgent on cost of rupees 1,000. And if counsel doesn't appear in the next date of hearing and not paid the cost, petition will be dismissed for non-prosecution. Sana?